ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಆದ್ಮೇಲೆ ಹೋಗುತ್ತಾ, ಅದಕ್ಕೆ ಮುಂಚೆ ಹೋಗಲ್ವಲ್ಲ? ಡಿಸ್ಮಿಸಲ್ ಅಷ್ಟೇ. ಗುಲ್ಬರ್ಗ, ಧಾರವಾಡ ಒಂದೇ ಒಂದು. ಇದು ಧಾರವಾಡ ಒಂದೇ ಒಂದು. ಕಲಬುರ್ಗಿ ತುಂಬಾ ಡೀಟೇಲ್ ಆಗಿ ಕ್ಲಿಯರ್ ಆಗುತ್ತೆ ರೋಹನ್ ಸರ್ ಬಂದ್ರೆ. ಕಿರಣ್ ಅವ್ರು ಬಂದ್ರೆ ಅದು ಡೀಟೇಲ್ ಆಗಿ ಕ್ಲಿಯರ್ ಆಗುತ್ತೆ ಮಧ್ಯಾಹ್ನ ಅಷ್ಟೇ. ಅದು ಹಿಯರ್ ಆದ್ರೆ ಗೊತ್ತೆ. ಆಮೇಲೆ 4 ಪಟ್ಟು ಪ್ಯೂನ್ ಬಂದ್ರೆ ನೋಡ್ತಾರೆ ಅಂತ ಪ್ಯೂನ್ ಬಂದ್ರೆ ನೋಡ್ತಾರೆ ಅಂತ ಹೇಳಿ.
ಮೇಡಮ್, ಮಂಗಳೂರು ಹೋಗ್ತಿದ್ದೆ, ಬೀಚ್ ತುಂಬಾ ಚೆನ್ನಾಗಿತ್ತು. ಮಚ್ಚಲಿ ನಿಮ್ಮೀನಲ್ಲ, ಸಮುದ್ರದ ಮೀನಲ್ಲಿ ಮಚ್ಚಲಿನಲ್ಲಿ ಚೆನ್ನಾಗಿಲ್ಲ. ನಾನು ಹೋಗಿದ್ದೆ, ನಮ್ದಲ್ಲೇ ಇದೆ 6 ಕ್ರಾಸ್ ಇನ್ನ ಅದಕ್ಕಿಂತ 6 ಕ್ರಾಸ್ ಸಿಂಧಿನಲ್ಲಿ ಇನ್ಸಾಲ್ವೆನ್ಸಿನಲ್ಲಿ ಫಿಶ್ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಅವನೇ
ಅಲ್ಲ ತಗೊಳ್ಳಿ 230 ಇದ್ರೆ ಮಾತ್ರ ಸಬ್ಮಿಷನ್, ಇಲ್ಲಾಂದ್ರೆ ಎಲ್ಲ ತಗೊಳ್ಳಿ.
ಸಮರ್ಥ ನಾಯಕ ನೆಕ್ಸ್ಟ್ ಪೀಸ್ ಎಷ್ಟು ವರ್ಷದಿಂದ ಸಂಕಲೇಶ್ಪುರ ಮತ್ತೆ ಹಾಸನ ನೋಡಿದ್ರೆ
ಅದಕ್ಕೆ ಪೇಷನ್ಸ್ ಅಲ್ಲೇ ಗಾಡಿ ಓಡಿಸ್ತೀವಿ.
ಇಲ್ಲಿದೆ ಕಣಮ್ಮ, ಫೋಟೋ ಬೇಕಾದ್ರೆ ಎಷ್ಟೊಂದಿದೆ, 4-5 ಎಷ್ಟೊಂದು 2, 4, 6
3 ಗಂಟೆ ಹೊರಗಿದ್ದೀನಿ.
ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಸರ್. ಅದು
ಬರ್ಬೇಕಾದ್ರೆ 45 minutes 1 hour ಅಲ್ಲಿ
ಅಲ್ಲೂ ಕೊಟ್ಟಿಸಿದ್ದೆ, ಅವ್ರು ಎಲ್ಲಿ ಇಟ್ಕೊಂಡು ಹೋಗ್ತಿಲ್ಲ.
ಮರ ಹೋಗ್ಬೇಕಾದ್ರೆ 6 hours 5 ಮರ 6 hours.
ಇನ್ನೂ ಒಂದು ಸ್ವಲ್ಪ ಬೇಕಾಗಲ್ಲ.
ಒಂದೇ ಘಾಟಲ್ಲಿ 6 hours. 6 ಗಂಟೆಗೆಲ್ಲ ಬೆಂಗಳೂರು ರೀಚ್ ಆಗ್ಬೇಕು. ಇದು ಮಕ್ಕಳ ಪೇರೆಂಟ್ಸ್ ಮೀಟಿಂಗ್ ಎಲ್ಲ ಡ್ರಾಪ್ ಎಲ್ಲ ಟೈಮ್ ನೆನ್ಸ್ಕೊಂಡಂಗೆ ಹಾಗೆ ಇದೆ.
ಒಂದು ಪೇರೆಂಟ್ಸ್ ಟೀಚರ್ಸ್ ಮೀಟಿಂಗ್
ನಮ್ಮ ಸ್ಕೂಲ್ ಹೆಂಗಿದೆ ಅಲ್ವಾ? ಗೊತ್ತಲ್ಲ ನಮ್ಮ ಸ್ಕೂಲ್ ಹೆಂಗಿದೆ. ಪೇರೆಂಟ್ಸ್ ಹುಡುಕ್ತಾರೆ.
ಅವರೆಲ್ಲ ಅದು ಯಾರು ಹುಟ್ಟಿದ್ದ ಮಣ್ಣಾಗ ಅದೇ ಸ್ಕೂಲ್ಗೆ ಅಂತ ಇನ್ನ ಮೊನ್ನೆ ಹುಡ್ತಾ ಅಲ್ಲ ಸ್ಕೂಲ್
ಈಗ 15 ವರ್ಷ.
ಅದು ಯಾವ ಸೀರಿಯಲ್ ನಂಬರ್ ಅಲ್ಲಿ ಇದೆ ನೋಡ್ಬೇಕಂತ ನೋಡಿ. ಇವತ್ ಹಂಗೆಲ್ಲ ತಗೋಬೇಡಿ ನಾಗರಾಜ್. ಸೀರಿಯಲ್ ಅವ್ರು ಯಾರು ಕೊಡ್ತಾರೆ ಅವ್ರನ್ನೇ ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳು ಅಂತ ಅನ್ಬೇಕು. ಹಾಕಿ ಇವತ್ತೆಲ್ಲ ಇದೆಯಲ್ಲ ಅದೇ ಕೊಡ್ಲಿ ಅವರು. ನಾವು ಫೈಲ್ ಸಮೇತ ಕೊಟ್ಟಿರ್ತೀವಿ, ಫೈಲ್ ಸಮೇತ ಕೊಡ್ಬೇಕು. ಹಿಂಗ್ ಕೊಟ್ರೆ ನಾಳೆ ಇವತ್ತಿಗೂ ಇಲ್ಲ. ಇವತ್ತಿಲ್ವಲ್ಲ, ಇವತ್ತೊಂದಾದ್ರೆ ಇಟ್ಕೋತೀನಿ, ಹಳೆವೆಲ್ಲ ನಾನು ಯಾಕೆ ಇಟ್ಕೋತೀನಿ ಹೇಳಿ? ಇವತ್ತಿದ್ಯಾ ನೋಡಮ್ಮ, ಇವತ್ತಿದ್ರೆ ಯಾವ ಸೀರಿಯಲ್ ನಂಬರ್? ಹೋಗ್ಬಿಡ್ತಾರೆ, ನಮ್ಗೆ ಎಷ್ಟು ಕೆಲಸ ಆಗುತ್ತೆ ಅದು ಗೊತ್ತಾ? ಅಲ್ಲಿ ಡೇಟ್ ಇವತ್ತಿದ್ಯಾ? ಇಲ್ಲ, ಅದು ಇಲ್ಲ ಅಲ್ಲಿ. ಫೈಲು ನಮ್ಮ ಹತ್ರ ಇಲ್ಲ, ವಾಪಸ್ ಕೊಡ್ತೀವಿ ಅವ್ನ ನನ್ನ. ಹೇಳಿದ್ದೀನಿ, ಆಗ್ಲೇ ಹೇಳಿದ್ದೀನಿ, ಹೇಳದ್ನಲ್ಲ ಕಸ ಸರ್ ಇರ್ಲಿಲ್ಲ, ನಾನು ಹೇಳ್ತೀನಿ ಅಂತ ಹೇಳದ್ನು, ಹೇಳಿಲ್ವಾ? ಹೇಳ್ದೆ ಇಲ್ವಾ ನಾನು? ಹೇಳಿದೆ ತಾನೆ. ಹಾ,
For 230, my lord, the matter for 230, my lord. Urgency is, my lord, interim order has been vacated, my lord. Where, my lord, I paid 25% towards pre-deposit, my lord. The tribunal, my lord, has mentioned that as there is no case to the appellant, interim order is vacated. The interim order was subsisting for about 1 year.
1 year ಅಲ್ಲಿ ಬರೀ 25% ಕೊಟ್ಟಿದ್ದೀರಾ?
Initial 25% ಕೊಟ್ಟಿ
How much are you willing? How much are you willing to pay now?
My lord, within 2 months, I have undertaken.
How much are you willing to pay tomorrow?
Close the loan itself, my lord, within 2 months.
We have heard that in all matters. We are not concerned with closing the loan. ಇವಾಗ ಎಷ್ಟು ಕೊಡ್ತೀರಾ ಅಷ್ಟು ಹೇಳಿ. ಕೇಳ್ಕೊಂಡ್ಬಿಟ್ಟು ಆಮೇಲೆ ಮೂವ್ ಮಾಡಿ. ಅದುವರೆಗೂ ಮೂವ್ ಮಾಡಬೇಡಿ.
10% within, my lord.
230.
10% within 2 weeks.
Election matter.
ಏನಕ್ಕೆ ಎಲೆಕ್ಷನ್?
MPC's election matter. Election has been scheduled on 8/12/2024.
Election is scheduled on?
8/12/2024, my lord.
Very good. You came right on time. Sorry.
Being spoke.
Hmm.
In this matter, court has passed the 2 annexes. The order sheet, it was only the one annexure.
ಕೊಡಿ.
230. 230.
Yesterday's matter has not come up.
Fresh one.
Fresh one. You adjourned from yesterday to today. How did it not come?
Yesterday.
Hmm.
The other one has come.
Good. Have you served it on Sudev?
Yes.
230.
Make a mention at 2:30. The matter, when the matter comes, my lord, if I
ನಾಳೆ
take this
ಎಷ್ಟು ಕೊಡ್ತೀರಾ ಅಂತ ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ we'll have it on Monday again.
Please.
My lord, serial number
230. Wait, please.
Adjournments. List number 1, page number 13, serial number 50 and 51. Page number 14, serial number 52 to 57. Page number 15, serial number 58 and 59.
Yes.
List number 1, for dismissal, serial number 1, Devi Prasad Shetty.
Appearing for petitioners. Needful done, my lord.
Needful done. Counsel for the petitioner submit that process fee and copies have been furnished. Registry to verify if needful has been done, issue notice to respond number 4, returnable by January end.
One submission,
January,
one submission,
Interim order make it.
Interim order earlier granted is
Millard,
extended.
one submission, Millard.
Yes.
Kindly, respondent number 1 name may be, GB Sharad Gowda name may be deleted. Rajshekar K for R1.
Rajshekar K for R1 no na?
Please, Millard. Government for R2 and R3. Millard.
That counsel for Shri Rajshekar K. That counsel submit that he would be appearing for respond number 1,
Please.
and it is the government, it is government advocate who would be appearing for R2 and R3. Hence, registry is direct delete the name of Shri GB Sharad Gowda as that appearing for R1 and print the name of Shri Rajshekar K as that appearing for R1.
Please.
serial number 2, PL Sanjeev.
Needful has been done, my lord. Oversight, it was not paid. Today it has been paid.
R2 yaar,
R2 is that the petitioner, the respondent himself, my lord, that Purswamy, who has been filing applications after application, 160 applications. Yes.
that counsel for the petitioner submit that the process fee and copies have been furnished, registry to verify if needful has been done, issue notice to respond number 2, returnable by
30th January,
30th January.
serial number 3, Krishnamurthy D.
I'm open for the respond number 2.
R3 arrow,
R3 is petitioner in the connected.
Connected matter, is the petitioner, is the borrower.
Mr.
Wait
Ariga,
for 2 weeks time to produce.
just a moment. Mr. Ariga, you accept notice
Yes.
for R3? Shri K. Chandranath Ariga, who appears for respond number 3, who is the petitioner in WP number 9101 of 2017, accepts notice for respond number 3. And the question of making payment of any process fee in respect to respond number 3 would not arise. What is IA 1 of 17?
Before that.
Because entire amount has been paid by the petitioner.
Originals.
Original documents has to be least.
ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ.
ಇದೆಲ್ಲ
ಅದು
ಬೇಕಾಗಿಲ್ಲ.
DRT ಅಲ್ಲಿ we have applied for the DRT ಅಲ್ಲಿ apply ಮಾಡಿದ್ದಾರೆ bank.
New bank ಇದೆ?
Please.
You have produced it before the DRT.
It has been produced before the DRT. They are still they have to get the documents from the DRT.
When will
Pay
you
for
get it?
2 weeks time. It's a 2012 disposal case ಇದೆ sir.
Civil dispute pending in RSA.
That interstate dispute.
Who is to be handed over the documents they will deposit it in the RSA and whoever receives it. But first they have to receive it alone.
Yes.
We can dispose these two to the direction.
I paid the entire amount by lots.
We'll direct them to deposit it in the RSA. If you succeed, they'll have to pay.
Yes.
If you don't succeed, your money goes. That's what we told you.
Recovery petition against them. my lords. And meanwhile, my lords,
Hmm.
let them secure the documents, my lords. Otherwise,
Hmm.
bank is not party in the second appeal.
We are also part. The bank is also part.
Bank is a party.
Also part.
Petitioner is before the petitioners are before this court in the above matter seeking for the following reliefs. During the pendency of the above matter, the petitioner in WP 23210 of 2017 has paid the entire amounts due to the respondent bank.
In that regard, we have filed the memo.
And as on date, there is no amounts due to the respondent bank on account of the present loan account. It is submitted that the original documents, subject matter of the mortgage had been produced before the debt recovery tribunal, where application has been made for return of the original documents.
They are ascertaining whether it is, because there are 2 cases in civil court also there is one suit. Then that has come to.
Again, we'll keep it pending.
ಅದಕ್ಕೆ
ಆಮೇಲೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ.
ವೆರಿಫೈ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ಜಸ್ಟ್ ದೇ ಆರ್ ಸ್ಟಿಲ್ ಅಂಡರ್
ಹೊಡೆದಾಕಿ. Learned counsel for the bank confirming the receipt of the entire money on the loan account Seeks Point is granted 1 week's time finally to ascertain where the documents are.
2012 dispose ಆಗಿದೆ ಓಯ್ ಅದಕ್ಕೆ.
ಗೊತ್ತಿಲ್ಲ. ದುಡ್ಡು ತಗೊಳ್ಳೋವಾಗ ದುಡ್ಡು ವಾಪಸ್ ಕೊಡಿ. ಡಾಕ್ಯುಮೆಂಟ್ ಹೇಳಿದ್ಮೇಲೆ ಕೊಟ್ಮೇಲೆ ಕೊಡಿ. Why should they be deprived of the documents if the money is received by you?
1 week.
On that money, you will pay 24% interest to both of them. 12%, 12%.
Property has been auctioned and sold. Then they filed the writ petition and the possession was taken and it has been re-delivered to the
Well,
petitioner.
that is
on
over.
receipt
Now
of the
you have to
payment.
return the documents. You don't even know where the documents are. That is not good.
I have returned, already returned to the bank, to inform.
Finally, 1 week's time to
10 days time, maybe. 10 days.
10 days time to make a submission as to where the documents are and when the documents would be deposited in the pending regular second appeal in RSA number 387 of 2015, released on 13th December.
Much. 13th, personally, 18th.
Released on 18th December,
Much.
Serial number 4.
19th.
Respond number 3 in this case.
First, Alva.
Recall, copy not sold out.
Mr. Manjunath. Paso.
Serial number 5. Ajit Kalyan.
Petition.
R2, Mr. Achappa.
According to my lord, kindly grant 2 weeks of time, my lord, to file verifying affidavit.
This matter, if the allotments.
Mike Mail Ethford.
Well, it's in this matter, I would request for an interim order. If already the sites are not allotted to do any third parties, let him, until the disposal of the petition, my lords,
What is the matter?
my lords, in this petition, my lords, I have sought for consideration of my representation for fixing the prices in the old price as of 2013. And subsequently, my lords, I have sought for a certiorari for quashing of the endorsement issued that they can't be accepted with regard to this.
What is the measurement of the site?
My lords, it's 135 meters, 1,453 square feet.
Where do we get that?
My lords, it's annexure D, my lords, page number 15. All the sites are, 4 sites are same dimension.
4 sites.
Four.
How are you getting
4
4
petitioners?
4
different
petitioners, sir?
Yes.
They're not related to each other.
No, no, they are separate.
Page?
In page number 15, my lords, annexure D.
Pending the consideration of the above matter, the respondents are directed to, respondent number 2 is directed to, is reserved with 4 sites measuring 135 square meters each in Suryanagar Phase 2, Bangalore Urban, in order to protect the interest of the petitioner in the event of the petitioner succeeding in the matter. Released on January.
Lords, 135, my lords, it was 155, I heard. 135.
135.
22nd January.
That second matter, hardship permission, the second matter stay has to be extended.
Sale number 2, interim order extended.
Sorry, man.
Serial number 6. Fayaz sir.
In this case, my lord, I have filed IA-1 for 24 and IA-2 for 24, my lord, for impleading myself in the proceedings. For this reason, my lord, we had filed writ petition before this honorable court, my lord, for seeking direction for word in election to the
IA
Mask-
2 of 21 and IA 2 of 24. ಎರಡು
yes, my lord, I have filed this, my lord. In this case,
2
my
of
lord,
24 ನೀವು ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ?
ಹೌದು. ಅದ್ರಲ್ಲಿ ಏನಾಗಿತ್ತು ಅಂದ್ರೆ, we had filed writ petition seeking a direction of this honorable court for holding elections. Since the writ petition is pending, my lord, the board is not taking steps to hold election. My lord, worship may grant the prayers, my lord, sought by the petitioner and direct the board to hold elections, my lord. The prayer is for holding election only. Second prayer is for holding election.
What about the first prayer?
First prize, my lord, they are seeking to include some members. Let the fresh calendar events be, even they are seeking for fresh calendar events. Let fresh calendar events be, fresh enrollment members be done. The main pair is that, my lord. For preparing a fresh calendar of events and also hold fresh election.
You are appearing for whom, Mr. Sharif?
That is applicants, one of 24.
Who is the contesting respondent?
Contest in the work board,
Mr. Hanif,
my lord.
Mr. Nayaz Paso.
Yes.
Serial number 7. Sarvana, yes.
It's yesterday's matter. The lordships, my lords, asked me whether I have pleaded about the second list, my lords, anywhere.
Hmm.
So if I'm permitted, my lords, the copy of the earlier petitions, my lords, which
My
are
lord,
referred
a
to-
short passover, my lord. Senior engagement.
Let's see.
Yes, please.
Yes.
If lordships have, my lords, page number 10. Lords, that is WP 22487.
Hmm.
In that, if your lordships kindly come to para 7, my lords. At page number 13, my lords, in page 13. Starts, my lords, thereafter second respondent appointed, one Shri Muralidhar, Superintendent of the Office of the Assistant Registrar Cooperative Society, Second Shaka, Bangalore. As the election officer, the election officer so appointed published the calendar of events for the election on 3/7/3/17, and as per calendar of events, the elections were required to be held on 26/3/17. Para 8, it is published that in the meanwhile, the notification was published in Sanjayvani Kannada Daily, evening newspaper on 7/2/2017, stating that by order dated 3/2/17, the election officer is appointed the list of eligible members, voters, are as having been published in the notice board of the society. The notification called upon those persons whose names are left out or missing to approach the manager of the society on or before 18/2/17, along with the relevant documents. Also, the list of members were published by the administrator through the manager of the society. Copies of so and so. Then, my lords, however, though elections were required to be held on so and so, the same did not happen. It is submitted on 2/5/17. The petitioner is handed over a list of members of the society, whereby more than 800 names have been newly included as members of the society, and also fixing the election of the society on 14/5/17. After the same, the second respondent administrator addressed a letter to the manager and the general secretary of the first petitioner, calling on them to verify about the membership of 600 applicants who have responded in pursuance of the notification published in Sanjayvani Kannada Daily newspaper on 7/2/17. The second respondent called upon the concerned to produce the register, the bylaws of the society and the latest audited statement and the information as renewed with this department within 7 days. To the said notice, the petitioner replied on 23/17, stating that out of 95 members of the society and as 20 of them having passed away, about 75 members are living. It was also stated the receipts which are said to have been produced are as given as donation for renovation of the temple and not for securing membership. Also stated that the previous secretary so-and-so died in a road accident. No documents are handed over to the
What
present
happened to
committee.
this writ petition?
My lord, these petitions were allowed. If I have produced the order also, my lords. My lords, page number
Were
3. my lords.
challenged. Did you challenge the list?
No, it was not challenged.
My lord, I disputed the list. I said because of these inflations are happening, it is only at the instance of the administrator. My lords, I challenge the appointment of the administrator. Page number 3, my lords, is the order. The matter, my lord, the appointment was quashed. Matter was remitted back, my lords, for fresh consideration. However, my lords, a similar order was passed. Again, my lords, appointing the administrator, which was challenged.
We challenge that list, Mr. Srikanth.
My lords, I said, my lord, that list is, my lord, is not valid.
You can make various allegations, but without challenging it.
My lord, ultimately, my lord, I have said, my lord, this is the list which was prepared by us, submitted, and we accepted it. Even the administrator says the society did not authenticate it. If you lordships kindly see the document itself, at the end, my lord, the administrator makes a charade, saying that if your lordships are having, my lords, are having, my lord, the list of members. My lords, it is filed by, my lords, the state at page number 92, my lords, last paragraph. ಸಂಘದ ವ್ಯವಸ್ಥಾಪಕರು ಸದಸ್ಯರ ಪಟ್ಟಿಯನ್ನು ನಿರಾಕರಿಸಿದ್ದರಿಂದ ಕ್ರಮ ಸಂಖ್ಯೆ 1ರಿಂದ 85 ಈ ಮಾತರ ಪಟ್ಟಿಯನ್ನು ದೃಢೀಕರಿಸಲಾಗಿದೆ. Administrator himself notes authenticates it. When the manager says, I don't want to authenticate this. Lord, my lord, that's the way, my lord, it is said. My lord, ultimately, the division bench says, as on the date, what was available, that should be taken into consideration. What was provided to him is a list of 95 members, which was also published.
Kindly have a look at page 113, my lords. After the draft list was published, paper publication was taken out. Members came and they have shown the receipts because the case of the petitioner is that the page 113. ಮೇಲ್ಕಂಡ ಸಂಸ್ಥೆಗೆ ಚುನಾವಣಾಧಿಕಾರಿ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ 2017ರಂದು ನೇಮಕ ಮಾಡಿ ಆದೇಶಿಸಿದ್ದು ಸದರಿ ಚುನಾವಣೆಯಲ್ಲಿ ಮತದಾನ ಮಾಡಲು ಅರ್ಹರಿರುವ ಕರಡು ಪಟ್ಟಿ. ನಾವು ದಿಸ್ ಕರಡು ಪಟ್ಟಿಯನ್ನು ತಾರಿಸಿ ಸೂಚನಾ ಫಲಕದಲ್ಲಿ ಲಗತ್ತಿಸಿದೆ. ಸದರಿ ಪಟ್ಟಿಯಲ್ಲಿ ಸದಸ್ಯರ ಹೆಸರು ಬಿಟ್ಟು ಹೋಗಿದ್ದಲ್ಲಿ ಅಂತ ಅವರು ದಿನಾಂಕ 18/2/2017 ಹೋಗಿ ಸಂಘದ ಮ್ಯಾನೇಜರ್ ಅವರಿಗೆ ಸೂಕ್ತ ದಾಖಲಾತಿಗಳೊಂದಿಗೆ ಸಲ್ಲಿಸಬಹುದಾಗಿದೆ.
This was done. Is 1 or 2 we understand.
Lords, this is the reason.
95 to 855.
Lords,
This
this
is not understandable.
No, I just wanted to say this, my lords. This is the list of members which was there about 10 years back, 10-12 years back. This list, my lords, what has happened is that portion, my learned friend read it over to your lordships. All the documents which was in the custody of the secretary is
let
not
the-
raised.
Let the registrar do an.
Let an inquiry, my lords. I'm
Who
open
will
for it.
further
Let your lordships may
members?
fix a time within which let them hold the inquiry.
Inquiry as to
That will
if
come
it
in
is
part 2 of the.
donation or not donation,
Lords,
whatever it
No,
is, let him hold an.
Yes.
if I'm permitted, my lords. It's a
Even
settled,
if-
it's a settled, my lords. The administrative, my lords, cannot say as to who is a genuine member or otherwise.
We're not asking the
No,
administrator.
secondly, my
Sir.
lords, my lords, if they contend that they are the bona fide members, not for them, the forum is before the civil court.
Ah.
They should have, my learned friend is
Then
aware
we'll
of
do
it.
one thing, we'll
Please.
take note of your this one,
Please.
and we'll say instead of 6 months, until the suit is disposed. The
Administrative
will
No, the
continue.
difficulty is this.
You are
2000
continuing in the management. and you
No,
want
I
to
am
con-
not. That's the difficulty.
Who is in the
They
management?
are continuing, my
One
lords.
second. No.
Who is in the management? Mr.
2016 administrator is appointed. He is continuing till this day. Not the mandate of section 27 capital A is, it's only for maximum 4 years, nothing beyond that. No one can not extend the period beyond 4 years. That's the reason not we filed memo for disposal.
You don't have the documents.
Not I have.
You can't validate
I have
anything.
not, that is the contention I have taken. I produced
Give the
it.
documents.
I produced
You
it.
say
Lords.
so and so expired in accident, no documents were
No
handed
documents are
over.
available. That's
I
the
don't
pleading.
have anything.
Lords,
So
for
therefore, I
lords,
won't recognize
those who are passed away, lords, out of 95 lords I have.
We are not
But-
speaking of 95.
855, it is by them, my lords, it is
That is why the
introduced.
registrar will hold an inquiry.
Yes.
My lord,
See the documents and verify if it is so.
lord,
If you are going to say that it is donation, you place your records.
you will, may make this submission. This is, my lord, 6 months is too long a period. The lords, my lords, have it.
4 weeks, my lords. Let them,
4
let him
weeks.
conduct.
When was the
within 4
last
weeks.
election, Mr. Khan?
My lords, that's
2001.
the reason. No, this, my lords, the elections were held. That's the reason this petition was filed. An interim order was granted not to declare the results.
Lords, I'm sorry, I stand corrected. 96, 97 is the last time when the elections were
Not correct.
conducted.
Kindly see the interim prayer, my lords, in this petition and the interim order granted. I was
96.
asked not to declare, my lord, the results.
Lords, 96, 97. My
That's
lords,
the reason, my lord, it was filed.
my lords, 96, 97 is the last election conducted.
Interim prayer.
After that, my lords, the election,
Before this, when was the last election?
96, 97. After that, they are continuing in the management from 96,
No,
97
no,
till
sir,
date.
please.
That's true.
2017,
A
my
moment,
lords.
Mr. Vishnu.
Lordships.
We are asking him a question. When we ask you, you can answer.
Sorry, my lords.
My lords, 2017, my lords, it was supposed to be held.
We are asking you,
Please.
before this election, when was the last election?
96, 97.
Lord, 2017.
ನೀವು ಇಲ್ಲೇ ಹೇಳೋದ್ಬಿಟ್ಟು ಇವಾಗ ಅಲ್ಬೇಡ. ನೀವು ಸ್ವಲ್ಪ hold your horses. Let him answer.
My lord, 2017, my lord, it was supposed to be held.
Before that, where?
Before that, my lords, it was being held, my lords, we are not filing the returns. The official returns are 96, 97.
They have no answer for it.
Your lords may take, my lords, officially, what is accepted by the registrar is of 96, 97.
A memo dated 4/12/24 has been filed enclosing 2 lists of members. One list containing 95 members, which is not in dispute either by the petitioner or the respondents. The other list containing 855 names, which the petitioner claims to be a list of members who have been excluded from participating in the electoral process.
Lords, this 855 includes 95.
855 includes 95?
Yes.
Yes.
855 including 95. 855 minus 95 ಎಷ್ಟಪ್ಪ?
55 ಅಂದ್ರೆ 40, 760,
760.
760, 760.
The submission of the petitioner is that 760 of the second list have been excluded from the electoral process, even though they are members and they had submitted the details of their membership to the administrator on a public notification being issued. Learned Counsel for respond number 6 and 7 disputes the said membership on the ground that the payments which had been made by these 760 persons.
Some of them, not all of them.
ಮತ್ತೆ
Ah.
ಇದು ಇನ್ನ ಇದು
ಅಲ್ಲ ಹೌದು, ಅವ್ರು ಕೊಟ್ಟಿರೋದು ಸ್ವಲ್ಪ ಜನ ಅಪ್ಲಿಕೇಶನ್ ಕಾಪೀಸ್ ನನ್ನ ಹತ್ರ ಇದೆ.
ಇವಾಗ 760 ಅಲ್ಲಿ ಎಷ್ಟು ಜನ ಕೊಟ್ಟಿದ್ದಾರೆ, ಎಷ್ಟು ಜನ ಇಲ್ಲ? ವಾಟ್ ಇಸ್ ಯುವರ್ ಸ್ಟೇಟ್ಮೆಂಟ್?
My lords, that I was given the photocopies, my lords. Right now, I do not. Some of them have gone, some of them only submitted, my lords, the application. That we were provided with copies of the application.
That some of them have, that the payment made by some of these 760 members is not towards membership. And some of those 760 persons
No
who have
doubt.
submitted their application for membership have not made payments
Please.
of the due amounts. If that be so, the last elections, according to the counsel for the petitioner prior to 2017, have been held in the year 1996. And the consider opinion that there would be a requirement for preparing a proper electoral list. In that view of the matter, the joint registrar, assistant
District
registrar.
registrar, my lords. It will come to the district registrar.
District Societies.
Societies Registration Act. Equivalent rank, my lords, may be a DRCS.
Deputy Registrar of.
Deputy
Cooperative.
registrar.
Deputy registrar, societies.
No, District Registrar of Societies. Who is
District
also.
registrar of societies. Who is going to conduct it, Papa? ಅವ್ರಿಗೆಲ್ಲ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಇಲ್ಲ, District Registrar of Societies, your lordships can say.
He has to delegate it to somebody. He has so much.
He'll ask not some of, one inquiry officer, election officer to conduct.
The district registrar is directed to appoint a suitable person to conduct an inquiry as regards the genuineness of the membership. Each of the 760 persons are permitted to furnish all the documents that they rely upon to establish their membership. Similarly, counsel for respond number 6 and 7 are permitted to place on record any document to dispute the same. A report of the inquiry officer to be submitted within 4 weeks from the documents to be submitted by 7, but you are not representing all 760.
Lords, may I make this suggestion, my lords? Let the registrar take out a paper publication, my lords, within a period of 1 week. Then 2 weeks thereafterwards, at least 1 week thereafterwards, the time needs to be given for submitting the documents.
855.
Then thereafterwards, another 2 weeks requires to be, because if public notice is not given,
It will take a little longer.
therefore, my lords, I'm in your lords.
Inquiry The officer is directed to issue a public notification through a newspaper of adequate circulation, inviting persons who claim to be members of the respondent number 4.
Only among, my lords, only among these 850, my lords, they should not add, my lords.
We
some
don't
more
know who will
amongst-
come.
My lords, that would be, my lords,
But the
again,
716
it is
notice
opening
code.
Pandora's box, my lord. My lord,
Not out.
Then
that's
what
what,
you-
my lord, the other side wants.
You have
My lord,
collected money from how many people then?
My lords, I am not. That is what is happening, my lords. That
It is
is not.
shown in the accounts. Public notice inviting persons who claim to be members of the 4th respondent to submit all documents in support of their claim within 2 weeks after the publication. On receipt of the documents, the inquiry officer shall share the same with the respondent number 4 society.
What's respondent number 4 is the administrator himself, my
You-
lords. Who
you
is the
lord-
district registrar himself.
Your lordship, my lords, one submission. Your lordship may say that, my lords, my lords, according to us, this itself is, my lords, in an inflated list. Your lordship may consider my submission that, my lords, if, let them, lords, confine only to so and so members.
Confine.
And my lords, for the reason that, my lords, those who are not, my lords, let's assume that they were members, my lords, for the sake of, my lords, that if they were vigilant, my lord, they would have approached at that time. My lord, they cannot come at a later point of time and say that again they are members.
If there are members, they have
They
to
are
be
members.
protected. We can't make them into different
But
silos.
there are no
and say
members,
only
my
this
lords.
will- This is a fresh
Lords,
thing which is being
no,
done.
we understand, my lords, under what circumstances all those things came about. But I don't want to dig into the grave. No, my lords, that's the reason I said, no problem, my lords, let them hold, my lords, in a suitable inquiry. But let it be confined only to, my lords, 850, my lords.
Once the documents are received, the inquiry officer shall prepare a list and make available and furnish the same to the fourth respondent, who would make available the same for inspection to any former committee member and or any other member of the fourth respondent to submit their respective their objections, if any, to the said list and or any person in particular, which shall be done within 2 weeks on a date to be fixed by the inquiry officer. On receipt of the application, objections, and any other documents, the inquiry officer shall, within a period of 4 weeks thereafter, prepare and submit a report to this court. Relist on March end on date code,
26th March.
26th March.
Please, Millards. Interim order requires to be.
Interim order earlier granted is extended till next.
Like, not to
I get
declare,
that.
my lords. Now there is, my lord,
Then-
extended by another order, my lords.
That goes out anyway.
Not to declare results antittu, now there is another order.
Serial number 8.
My lord, in this case, appear for respondent, my lord. My lord, as per the interim order, my lord, the petitioner has not complied, my lord.
My lords, my submission is, there was payment made, my lords, petitioner number 1 is dead now. Only petition survives only with respect to petitioner number 2.
The
Petitioner number 1 has made payments, my lords. We are trying to get access to the bank statements. Kindly a week's time may be granted, my lords. Will file the statements, my lords.
my lord,
That counsel for the
the interim
respondent.
order ordered on the 2022, my lord. Till
That
today,
counsel
it's
for
not
the
paid.
respondent submits that the interim order dated 3/2/2022 directing the petitioner to make payment of sum of rupees 5,000 on or before the 5th of every calendar month has not been complied with.
Yes, my lord.
That counsel for the petitioner seeks for a week's time to place on record proof of compliance. Relist on
My lords,
13th
proof of
December.
compliance till the petitioner number 1 was alive. He has
After
paid.
that,
After that, petitioner number 2 has tried to make payment, my lords, through cash. They have refused. We'll place that also in form of
nobody
an
asked you
affidavit.
to pay by
My
cash.
lord,
Allah, we'll place it on,
Not paid, deposit that entire balance.
my lords, we'll place it on, in the form of an affidavit, my lords, that they have refused. And I'll seek instruction on balance payment also, my lords, a week's
Not
time.
instructions, deposit. Carry the money next time to be handed over.
Please, my lords.
If you do, if there's any balance and you don't hand it over, the interim order will go.
Please,
Tell your client that.
please.
Petition number 1 during his lifetime,
Has
if he has
made
paid,
payments, my
well
lord.
and good. After his lifetime, petition number 2 to pay.
My lords, that's
If
the
not paid-
daughter-in-law, my lords. There are other sons alive.
No,
Other
my lord, only son
children,
is, only
other
son, my
children
lord.
are alive, my lords, and the respondent number 2 is holding the
Do
property.
one thing, we'll direct the property to be handed over to respond number 2.
My lords, property is not in question. The only thing in question is, respondent number 2 was allowed to reside in that house. We don't have any
Then
objection.
why
to-
do you want to prosecute this matter if you know this one?
My lords, it's only on the quantum of amount, my lords, that this lady cannot pay, daughter-in-law cannot pay. That is the only issue.
Next time you pay, otherwise
Interim order may be extended.
interim order is extended till next date, subject to furnishing of documents to in compliance.
My lords,
That may be fixed,
office
my lord.
objections have been complied with, my lords.
Court fees. Copy ಬಂದಿದ್ಯಾ government? ಬಂದಿಲ್ವಾ? Not complied.
My lords, I have, I'll.
Where is
just,
typed copy of annexure D? ಕೊಟ್ಟಿದ್ದಾರಾ?
By virtue of a memo, it is filed on 3rd, my lords.
A memo dated 3/12/24 has been filed, enclosing typed copy of the relevant manuscript portion of Annexure D. Since office objection at CL number 3 stands complied with. Learned counsel for the petitioner undertakes to furnish copy of the petition along with annexures on the learned government advocate by end of day tomorrow. Register to verify if the court fee has been paid.
My lord,
Request on
date may be
13th.
fixed, my lord. Date may be
13th.
much over.
Serial number 9,
My lords, I'm
9B and connected by.
preparing for petitioner, my lords. Amendment has been carried out, my lords. I'm filing amended cost settlement.
File it in the registry.
Please.
Learned counsel for the petitioner submit that he has carried out the amendment and you will be filing the amended cost title in the registry today.
Please.
Registry that print the name of Sri Gururaj R as that appearing for respond number
4, my lord.
4 in both the matters. You filed your objections?
No, my lord.
You want to file?
No, my lord. We are not filing any objection, my lord.
You are ready for
We are-
argument?
We are not competing party, my lord. We are not.
They are already
No, we are not. Yeah, we are. We are a formal party. I'm a formal party.
Objection. A week's time.
You will file objection. And AGS seeks for and is granted 2 weeks time to file statement of objections. Objections, if any, by 7th January, relist on 2nd week of January.
Please.
16th January. Serial number 10,
I appear for the respondent bank, my lord.
Yes.
I filed an application for vacation of interim order also.
Getting interim order.
Vacating interim order.
Interim
There
order
seems
is
to be
also
some defect in the IA that is fine. The office has raised some objections.
11, 8, 9. Sorry.
10.
2, 2, 5, 5, 6. When was the interim order? Interim order as prayed for till next day.
Yes, my lord.
Please.
In this case, my lord,
Yes.
this is the matter now, 2022.
Hmm.
The only issue is that the petitioner is required to file objection statement within 30 days. And it shall, that is a mandatory provision under the Debt Recovery RDB Act, my lord. And they have not filed the objection statement. So that the tribunal has stated that they have not filed the objection statement. Against that, this writ petition is filed. Now, as per regulation, the RDB Act, regulation 20, my lord, if they are agreed with any of the orders passed by the debt tribunal,
To
then they
file
have to
within
go to,
30 days. When did they file, Mr.?
that I'll read, my lord. My objection statement, my lord, page number, para number 8,
Page?
para number 8, objection statement.
Statement of objection.
As per section 19(5), your lordship got objection statement, para number 8.
Objection statement of form 8.
Alla, para number 8,
Para 8.
para 8, my lord.
Yes.
As per section 19(5) of RDB Act, the written statement has to be filed within 30 days of the service of the summons. The petition was appeared before the tribunal on 15/9/2020 and paper book was served on 21/9/2020. The written statement and counterclaim document number so and so was filed on 12/8/21 by the petition number 1. Both the dates of filing the documents on 12/8/21 and written statement claimed to have been filed on 20/11/2020 are beyond the
Oh, they have filed it, Mr. Matarna.
statutory period of 20 days. Man.
They have filed it now.
ಅಲ್ಲ ಅದು ನಾನು
2 ವರ್ಷದಿಂದ ಇಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ.
ಅಲ್ಲ ಇದು ಏನಾಗಿದೆ ಅಂದ್ರೆ honorable Supreme Court says that more than 30 days time should not be permitted because these are all tactics adopted for getting the time, my lord, because 2 years over now that they have to pay about 7 crores and 2 years now because this is going on for 2 years. If they had approached that appellate tribunal mileage this matter, they would have paid about 50% amount. That is why they have not gone to the even the provision specifically says.
That is not the
One order,
situation.
my lord, the Supreme Court order.
Well, look, that is not the situation. my lord. I voluntarily appeared before the DRT, filed my written statement along with a counterclaim, paid a court fee of 1,05,000, which was voluntarily not on a date when it was notified for hearing. That was not observed by the presiding.
Did you
officer.
file it?
My lord, that order sheet I have misplaced somewhere.
Order sheet I have-
Tomorrow I will.
I have produced, my lord, order sheet also I
I've
produced.
gotten on here. order sheet.
ಇದರ ಜೊತೆ ಇದೆಯಲ್ಲ.
Hold on.
ಹ್ಮ್.
They have misplaced. My lord, they are voluntarily appeared, entire order sheet. Along with the court fee, my lord, of 1,05,000 towards the counterclaim. And are to adopt the.
Produce the order sheet, Mr.
Order sheet, my lord, that I'm not produced, but I'm having order sheet.
Adu ನನ್ನ ಹತ್ರ
Yeah, produce
misplaced it
ಮಾಡಿಲ್ಲ.
somewhere, my lord. I will
Having
get
my
the
lord.
entire order sheet where it shows, even tomorrow, very well.
If it is here, we'll look at it now, Mr.
Please, please. It's a handwritten one. The date was something beyond the time when I filed the written statement.
What do, so if you have paid the court fee,
Please, ma'am.
you must have obtained a DD or a,
Yes, yes, through Bharat Kosh, my lord.
so what is the date of the DD?
It's on the very same day, previous date.
Have you produced it?
No, that is what
Produced
they have
that. My lord,
directed, that
all those documents. we
tribunal has
misplaced.
directed them to produce that they have not produced. That is also mentioned in the subjection.
My due apologies, Lord, that file was misplaced, so I'm not able to. place
Your
it.
file is misplaced.
Please, that's the reason. Otherwise, I will definitely place.
ಕೇಳ್ಬೇಕು ಮತ್ತೆ ನೀವು.
ಆಯ್ತು.
File misplaced ಅಂದ್ರೆ ಅಲ್ಲ ಇಲ್ಲೋ ಗೊತ್ತಾಗಲ್ಲ.
9ನೇ ತಾರೀಕು ಕಟ್ಟಿದೆ 10ನೇ ತಾರೀಕು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ದು ಯಾವಾಗ ಅಂತ ಗೊತ್ತಿಲ್ಲ.
Demand draft has to be there, which will indicate the date.
Please.
If the demand draft for 1,05,000.
Not a DD, my lord.
That is for
Bharat Koshal ಕಟ್ಟಿದ್ದು.
My lord, that is for counterclaim. Now we are not talking, we are talking that.
Written statement and counterclaim.
And counterclaim is separate, written statement is separate. Counterclaim and all they can file any time.
ಇಲ್ಲ
But written statement only as per this, they have to file within 30 days.
We'll know the date on which it is filed by the demand draft date.
ಅದನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕು. Court has directed. to produce.
ಏನೋ file misplace ಆಗಿದೆ ಅಂತ. We'll have it next week.
ಆಯ್ತು.
Well, 8 roll 1 and 2 and 6 here.
No, when
Come
date-
together.
Date may be given.
The
my lord.
counsel for the petitioner submit that the written statement along with counterclaim,
Please.
along as also the court fee on
Table
the
on
counterclaim was filed much before the date indicated in the impugned order, namely 12/8/2021. His submission is that unfortunately, the earlier date has not been recorded in the in the order sheet. He seeks for and is granted a week's time to place on record any document to evidence this above
Very well.
submission.
I will.
Released on 12th December.
Yes,
Please.
If by then no document is produced, adverse inference would have to be drawn and the matter
I
proceeded.
will. I will.
Hearing on IA, serial number 11. Praveen Kumar Raikote.
What is the basis of review, Mr. High
My lord, the petitioner had challenged the notice issued by the district committee.
Hmm.
On the ground, my lord, that the district committee has no jurisdiction to take up suo moto the proceedings, my lord.
Yes.
And I have produced the judgment of this honorable court also, my lord, annexure B. Page 18, my lord, internal page 18.
This is by DCVC, alva?
Please. My submission was, though my lord notice was challenged, the notice was without jurisdiction. Because I had not made an application for issue of validity certificate before the DCVC.
Hmm.
Nor my employer had sent any application for verifying my caste. So suo moto, my lord, they
No
took up.
complaint received.
No complaint received. Suo moto, they took up and issued notice. I said they have no jurisdiction to issue suo moto notice.
Why would they suo moto take up?
They cannot, my lord.
Why would they take up? For Bere and Kalsalva?
That, my lord, is
Okay,
not
accept
forthcoming
notice.
from the.
And AGA accepts notice for respond number, AGL. Shri C. Jagdish is directed to accept notice for respond number 1 and 2. The submission of the counsel for the petitioner is the proceedings by the DCVC were taken up suo moto without there being any complaint. Shri C. Jagdish is directed to obtain instruction and place the same on record as to on what basis the show cause notice was issued to the petitioner. Released on 19th December.
Please.
Serial number 10, the interim order may kindly be extended.
10
My due
interim orders.
apologies. Please.
Serial number 12. CH Virupakshaya and connected matter.
Lord, in this case, my lord, as per the order dated 13/11/2024, my lord, reconciliation meeting was held.
Aita.
I thought. This is the report, my lord, I am filing. And also Wakala.
You are appearing for the liquidator.
For the depositories, your lordship. We are filing a memo on the minutes of the meeting. It so happened that nobody turned on that day. No meeting held. We waited for up to 4:35 in the second half of the afternoon. It was not successful. And there was a coercive measure taken by the bank. Forcibly, they wanted to get it signed. Sir, let me.
Just
Just
let him
wait,
submit.
Sir, let me,
Let him
sir.
submit.
Let me. It so happened, it's a, there are depositors who were there, senior citizen. We waited up to evening. The liquidator didn't sit at the chair. He came, he said, we are going to finish the lunch and come back. He didn't turn up. No. We were there up to 4:35. We have adduced the annexed a letter issued to a liquidator, CEO and the administrator of the bank, saying that meeting was not successful. We have sought for the audit report in order to ascertain what is the equity position before we.
Not your business. That is not your business. You are only to furnish the documents of your claim.
Yes, indeed.
Have you furnished it?
Yes, we have, sir. We have already given it to the records of the files.
Where are they?
Previously, we have filed it.
Mr. Counsel, you did not appear on the last day. You are appearing today and
My
you are
lord,
making some.
till the end of the meeting, my lord, I was
One
present.
nimsha, Mr. Kiran.
Since
You did not
2014.
appear on the last day.
Yes,
You are not before this court.
I was present.
my colleague was present.
So let her make the.
2014, we are in the record.
You are not here. Please take a back seat. Let her come. Yes, madam.
Because of
What
you
are the
only,
documents that
everything
you
is spelling,
submitted?
We were present at the,
Where are the documents that you submitted?
documents are submitted before this court.
We are not concerned with before this court. What did the documents that are submitted to the OL for the liquidator?
The liquidator was not present on the day.
What are the documents available?
My lord, your lordship has directed to
Just a
submit
moment.
for me on 21st itself.
Just a moment.
Not to the liquidator.
Nimuge, correct.
ಹೌದು ನನಗೆ ಹೇಳಿದ್ದೀರಾ.
What did you submit to?
Nobody was there. This gentleman was not there. Sir.
The council will not again tell you. You were not here before this court. You did not even have the courtesy to read the order.
Great.
And you are making submission in the air. Don't try to be a politician here to make the statements
No, your
because your clients are present. We'll take exception to it. Please.
Okay. Great.
You are directed to furnish all the documents to Mr.
ನನ್ನ ಕಡೆಯಿಂದ 24 members ಕೊಟ್ಟೆ ನಾನು ಇವ್ರಿಗೆ ಕೊಟ್ಟೆ.
Did you furnish it to him?
I filed it.
We had only two depositors who were, tried to
So did you
submit
furnish
fees.
it?
No.
No, we had the record in the
Did you
court. so
furnish it, madam?
Not on that day because the liquidator was not
You're
present
not
before the court.
Have you read the order? It was
Yes,
pronounced,
yes, Your
it was passed in your presence.
Yes, Your Lord.
What is the order?
By 21st, we had to furnish the,
Did you furnish?
no, because I could not meet.
Then don't make any
deposit.
submission. You are out. Yes, next.
Rest of the depositors, we are also representing.
Rest
They
we
were
will
also
consider.
present.
You are representing only two.
Please, Your Lord.
Yes,
I appeal to the RBI, my lord.
you have nothing. Who else is appearing?
Majority of him from.
24.
Yes, ma'am.
Appeal ಮಾಡಿದ್ದೀನಿ sir. APF for respondent number 52. Lords, I could not submit on 21st. However, lords, I have submitted to the bank.
Nobody asked you to deposit, submit it to the bank.
Lords,
Allah, even
I
otherwise
informed
are
also.
humanitarian ground, we have accepted, my lord.
They have accepted.
We have accepted. my
That
lord.
I agree.
Yes,
with.
You have submitted.
Yes.
Please.
At least.
Yes.
Submit. And we have
Inner-alia.
received an acknowledgement also.
Who else?
My lords, no, majority he represent, my lord. Euro bro.
He also-
24 members.
He also represents majority of the.
Totally
20
24.
deposits.
You are not submitted.
My lords,
If you are not submitted, we are not
no,
concerned about
my
it.
lords, it so happened. We came to know off late. We went there to ask what is the requirement along with the depositors. There was no representation from the bank. Whom should I deposit? They came, they didn't even had a courtesy to sit and ask what is going on.
Have you read the order that we have passed?
Yes, sir.
Do you have the courtesy to read the order?
Indeed.
Don't make these statements.
No. It is a fact.
Please.
With humble self. With a humble self,
You are doing a disservice to your clients.
no, your lordship, I represented
They
along with it.
agreed to receive it and you don't have the courtesy to give them the papers.
Yes. We
And
give-
you go and ask audit report.
No, it so happened, my lords. May I make a
Nothing
submission?
happens.
May I make a submission?
Nothing happens.
We have transmitted, we have corresponded the orders of this honorable court to work on that. They
What's
they
your name?
came-
What's your name?
My name is Nityanand Murthy, your lordship.
Mr. Murthy, you have to comply with the order. That is the
Indeed,
basic
Your-
requirement.
Indeed, indeed,
If you are not capable of complying, that
indeed.
means you don't have the documents.
No, we have it, your lordship. It so happened.
Why did you not
May I make a submission?
give it to him today?
Yes, a day.
Today,
because-
by end of the day, you give it to him.
Because
If you have it, give it to him.
My
My
lord,
lords,
from morning till
that
evening,
is-
my lord, my staffs were waiting, my,
no.
in the
That's-
corridor.
We
my
were
lord.
there.
No one turned up,
Sincerely-
my lord.
sincerely we
We
were
are
there.
very sincere to the,
Murthy,
to,
you are not complied with the order. Don't
Indeed.
say anything more.
he comes
no,
at
I
4:30
understand.
and shouts
Already
at
at the-
everybody.
Sir,
Yes,
please, sir.
yes,
With
that's what happened.
kind self to the court.
You are already at the receiving end.
Yes,
Don't
Your-
make it more.
No,
If
no.
this is the way that you are going to make your submission,
Yes.
your clients are going to suffer.
I understand, your lordship.
Because of them, we are giving them time,
Yes,
not because of you.
it's fine, my lordship.
And don't tell them to go and ask audit report and all those things.
See,
And
only
you
one,
Don't be there.
it was just briefed by my clients. That's why we asked them in a written, because they have signed it.
They were only asked to give the documents.
Fine.
And not to create any hangama there. And that's why we, asked them-
They did.
that is why we had asked them to give the papers.
Yes, ma'am.
ಇವ್ರು ಇರ್ಲಿಲ್ಲ.
ನೀವು ಬಂದಿರ್ 4:15. ಅವ್ರು ಕೇಳಿ ಅವ್ರನ್ನೆಲ್ಲ
ಅವ್ರು ಇರ್ಲಿಲ್ಲ, your lordship.
ಎಲ್ಲಾರನ್ನು ಕೇಳಿ
ಅವ್ರು ಇರ್ಲಿಲ್ಲ.
ಕೇಳಿ ಇವರು ಇದ್ರು.
ಅದಕ್ಕೆ ನಾವು ಸಿಒಗೆ ಅದನ್ನ ಸಬ್ಮಿಟ್ ಮಾಡ್ಬಿಟ್ಟು ಬಂದ್ವಿ ಲೆಟರ್.
Because of him, my
Sign
lord, everything
ತಗೊಂಡು-
is going.
No.
Yes,
sir.
my lord. He
This-
made all the persons
Sir,
to
this is
gather
the-
together
sir.
and he took the leadership
No,
and
no.
he held a meeting
2000
and written complaint against.
ಸರ್ ಇದ್ರಲ್ಲಿ
ನಮ್ಗೆ ಗೊತ್ತು,
ಕ್ಯಾರೆಕ್ಟರ್
I was
ಅಸಾಸಿನೇಷನ್
also
ಮಾಡ್ಬೇಡಿ
there.
ದಯವಿಟ್ಟು
I
ಸರ್.
was also there as
ಎಲ್ಲಿದ್ರಿ
government
sir?
advocate. I know.
ನೀವು ಮಾತಾಡಿಲ್ಲ
ಹಾ.
ನಮ್ ಜೊತೆ.
ಏನ್ ಮಾತಾಡಿದ್ದು?
ಒಬ್ರು ಬಂದು ಮಾತಾಡಿಲ್ಲ, your lordship. ಇಲ್ಲಿ ಡಿಪಾಸಿಟರ್ಸ್ ಇದಾರೆ ಕೇಳಿ.
Kindly ask everybody, my lord.
ಇಲ್ಲಿ
My lord,
depositors ಇದಾರೆ,
each
ಅವ್ರನ್ನೇ
person
ಕೇಳಿ.
was called and we
Professional
heard.
conduct is under question. The integrity is under
You
question.
were asked to give the papers, which you were
ಕೊಡ್ತೀವಿ,
not.
your lordship. Depositors ಕೇಳಿ, how unparliamentarily they are treating us.
Eh,
Since 2014 we are in the case, your lordship.
Don't try to become a leader here.
I am not becoming a
That's
leader,
what
your
we are
lordship.
getting the impression.
We have gone through a lot of tough time,
This you
mentally
are
also.
You are doing disservice to your clients now. I have told you thrice.
I understood, my lordship. But
Now,
on the receiving
since
end,
you are not submitted, we can reject all your claims.
I understand. It is at your disposal.
This
your
is
lordship.
because of your conduct,
I understand.
your
your lordship.
advice.
ಒಂದೇ ಒಂದು submission ಏನು ಅಂದ್ರೆ, if they are questioning the professional integrity of a person, whom should I come and talk to, your lordship? Since 2014, we are on the case.
If you are not complying with this order,
ಇವಾಗ
what action do
ಮಾಡ್ತೀನಿ.
we take against you?
ಇಲ್ಲ, ಇವಾಗ ಮಾಡ್ತೀವಿ ಬಿಕಾಸ್ ನನಗೆ ಆಫ್ ಲೈಟ್ ಅಲ್ಲಿ ಸರ್ಕ್ಯುಲೇಷನ್ ಬಂತು. ನಾನು 15 ಜನಕ್ಕೆ ಇದ್ದೀನಿ, ಅವರು ಬಂದಿದ್ರು, ಅವ್ರಿಗೆಲ್ಲರಿಗೂ ಕೊಟ್ಟಿದ್ದೆ ತಗೊಂಬನ್ನಿ ಅಂತ.
ಅದಕ್ಕೆ ನಿಮ್ಗೆ ಹೇಳಿದ್ದು
They
ನೀವು
wanted a clarification.
ಏನೇನೋ ಶುರು ಮಾಡಿದೆ ಅಲಿಗೇಷನ್.
ಅಲಿಗೇಷನ್ ಅಲ್ಲಿ
We are not
it
going
so
to
happened.
accept this kind of submissions. We are not going to accept.
ಈ ಕೇಸಲ್ಲಿ ತುಂಬಾ ಕಷ್ಟಪಟ್ಟಿದೀವಿ ಲಾಡ್ಜ್. ತುಂಬಾ ಅಂದ್ರೆ ಆ ಮಟ್ಟದ್ದು
ನೀವು ಕಷ್ಟ ಪಟ್ಟಿದಿರೋ, ಕಷ್ಟ ಕೊಡ್ತಾ ಇದೀರೋ ಇವಾಗ ಅರ್ಥ ಆಗ್ತಾ ಇಲ್ಲ ನಮ್ಗೆ.
ಇಲ್ಲ.
ಕಷ್ಟ ಕೊಡ್ತಾ ಇದ್ದೀರಾ ಅನ್ಸುತ್ತೆ.
ಕಂಡಕ್ಟ್ ಏನು ಪ್ರೊಫೆಷನಲ್ ಕಾಂಡಕ್ಟ್, ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್. ಇಲ್ಲೂ ಬಂದು ಅಸಾಸಿನೇಟ್ ಮಾಡ್ತಿದ್ದಾರೆ ಕಾಂಡಕ್ಟ್ ನ. ನಿಮ್ ಲಾಯರ್ ಸರಿ ಇಲ್ಲ ಅಂದ್ರೆ ನಾವ್ ಏನ್ ಮಾಡ್ಬೇಕು?
Mr.
ಅವ್ರ ಕ್ಲೈಂಟ್ಸ್
Murthy,
ಹತ್ರ ಹೋಗಿ ಮಾತಾಡಿದಾರೆ ಈಗ.
Mr. Murthy, we are refraining from saying anything more. Don't take it.
My lords,
Don't
you
take
should
it from
protect my, that is the only thing what I can plead before your kind self.
In fact, if we were to do, we would have said much more than what he's saying.
Please.
We would have said much more.
Pro bono ಮಾಡ್ತಿರೋದು your lordship.
We are refraining because your interest of your client will suffer because of that.
ಆ ತರ ನಾವು ನಡ್ಕೊಂಡಿಲ್ಲ.
ನಡ್ಕೊಂಡಿದ್ದೀರಾ, ಪೇಪರ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ ಇನ್ನ.
ನನಗೆ ಆಫ್ಲೈನ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಅವ್ರಿಗೆಲ್ಲ
ಕೊಡಕ್ಕಿಲ್ಲ,
ಸರ್ಕ್ಯುಲೇಷನ್.
ನೀವು ಏನು ಆಡಿಟ್ ರಿಪೋರ್ಟ್ ಅಂತೀರಾ? It's not your business to ask for audit report.
Fine, your lordship.
That is what we will be looking into last.
They wanted to ask, we have asked, briefing ಮಾಡಿದ್ದಾರೆ.
You are only to comply with the order.
Yes, my lordship.
That's all.
We shall. But only one thing, professional conduct should not be questioned. It's a pro bono case what we are fighting
If
since
you
last
keep
10 years.
repeating this, we will have to say,
Yes,
then
my
you will
lords.
not like it.
Yes, my lords.
You will not like it then.
I understand.
So please.
I understand.
So
when
journey
will-
was tough.
When will you give the papers now?
2 days time ಕೊಡಿ your lordship. Compile ಮಾಡ್ಕೊಡ್ತೀನಿ.
We have seen the papers. It is all because of, we'll refrain.
ಬಟ್ ಒಂದು ರಿಕ್ವೆಸ್ಟ್
2 days
ಅವ್ರಿಗೆ
time.
ಹೇಳ್ಬಿಡಿ ಇವ್ರು ಲಾರ್ಡ್ಶಿಪ್ ಕ್ಲೈಂಟ್ಸ್ ಹತ್ರ ಹೋಗಿ ಪ್ರೊಫೆಷನಲ್ ಕಾಂಡಕ್ಟ್ ನ ಅಸಾಸಿನೇಟ್ ಮಾಡ್ತಿದ್ದಾರೆ ಡೈರೆಕ್ಟ್ ಆಗಿ. ಅದು ದಟ್ ಶುಡ್ ನಾಟ್ ಬಿ
We were asked to give the papers to
ಕೊಡ್ತೀನಿ.
Mr. Sunil Kumar.
ಇದನ್ನ ಮಾತ್ರ ನಾನು ತಗೊಳಕ್ ಆಗ್ತಿಲ್ಲ, ಯಾಕೆಂದ್ರೆ ವಿ ಆರ್ ಡೂಯಿಂಗ್ ಇಟ್ ಫಾರ್ ಪ್ರೋ ಬೋನೋ ಸಿನ್ಸ್ ಲಾಸ್ಟ್ 10 years,
Very
ಸಿನ್ಸ್ ದ
good.
ಡೇ ಒನ್.
Please do it.
ಪ್ರೊಫೆಷನಲ್ ಕಾಂಡಕ್ಟ್ ನ ಯಾರ ಹತ್ರ ಅದು ಕ್ವಶನ್ ಮಾಡಿದ್ರೆ ಇಟ್ಸ್ ಹಿಟ್ಟಿಂಗ್ ಆನ್ ದ ಇಂಟಿಗ್ರಿಟಿ ಆಫ್ ಅ
We
ಪ್ರೊಫೆಷನಲ್.
are telling you again, we are refraining.
ಗ್ರೇಟ್ಫುಲ್ ಯುವರ್ ಆರ್ಟ್.
If you again make that statement, then you'll let go. We'll let go.
Grateful your lords. Grateful.
Then it'll become a bigger problem for you
I understand.
than what he is saying.
Understand.
Please don't do this.
Understand.
Don't
But
invite.
ಅದು ಒಂದು ವಾರ್ನಿಂಗ್ ಆದ್ರೂ ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ.
ಅವ್ರಿಗಲ್ಲ, ನಿಮಗ್ ಕೊಡ್ಬೇಕು.
ನಾನು ಅವ್ರ ಹತ್ರ ಯಾವತ್ತೂ ಮಾತಾಡಿಲ್ಲ ಅಲ್ಲ.
ನಿಮ್ಗೆ ಹೇಳ್ತಾ ಇದೀವಿ ಸುಮ್ನೆ ಇರ್ರಿ ಅಂತ ನೀವು ಕೇಳಲ್ಲ ಅಂದ್ರೆ we'll have to take.
Great your lords.
ಇವಾಗ ಎಷ್ಟು ಜನ ಕೊಟ್ಟಿದ್ದಾರೆ?
24 members.
ನಮ್ಮ ಕಡೆ 24 members.
ಟೋಟಲಿ ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ ಡೆಪಾಸಿಟರ್ಸ್?
Total 27.
27 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹೌದು.
ಟೋಟಲ್ ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
ಅಷ್ಟೇ ಜನ 27 ಅಷ್ಟೇ
ಕೊಟ್ಟಿರೋದು ಅಷ್ಟೇ.
ಕೊಟ್ಟಿರೋದು. ಮೈ ಲಾರ್ಡ್ ಎಲ್ಲಾರ್ಗೂ ಕೊಡ್ತೀವಿ, ಯಾರಿಗೂ ಏನ್ ಇಲ್ಲಿ ಮಾಡೋದು.
ಅದು ಕೊಡ್ಸ್ತೀವಿ. That don't worry. That we'll see.
2 days.
How many are there now? How many are you?
15, we represent around 15 deposits.
By day after tomorrow evening, you
shall
give all the papers to him, not to the bank.
Great. ಅಲ್ಲಿ ತಗೊಂಡು
Who else is there?
ಮತ್ತೆ ಆಮೇಲೆ ನನ್ನ ಮೇಲೆ ಸಿಕ್ಲಿಲ್ಲ ಅಂತ.
ನೀವ್ ಯಾವ ಕೊಡ್ತೀರಾ ಮಿಸ್ಟರ್ ವಸಂತ್? ಯಾಕೆ ಕೊಡ್ಲಿಲ್ಲ ನೀವು?
ಅದು ಏನಾಗಿದೆ, ವೆರಿಫಿಕೇಶನ್ ಹೋಯ್ತು. ಓಕೆ, also deposited the money. You could not give the details of the amount he has withdrawn. What is the amount?
ಇಲ್ಲ ನಾವೇ ಕೊಡ್ತೀವಿ.
ನಿಮ್ಮ ಹತ್ರ ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆಯೋ ಅವ್ರು ಕೊಡಿ. Because this ಹಿಂದೆ ಮುಂದೆ ಹೋಗ್ತಾ 10 ವರ್ಷದಿಂದ ಇದೇ ಆಗಿರೋದು.
ಇಲ್ಲ
Received the payment much earlier.
ಇಲ್ಲ ಎಲ್ಲ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಈಗ ಟೋಟಲ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇಂಟ್ರೆಸ್ಟ್ ಅಷ್ಟೇ. ಕೇಳಿ ಎಲ್ಲಾರನು ಕೇಳಿ. 292 crores ಡೆಪಾಸಿಟ್ ನ ಕೊಟ್ಟಿದ್ದೀವಿ ನಾವು.
There is enough and more money to pay everybody.
ಅಲ್ಲ
Why this litigation has gone for 11 years is only seen in the order sheet which we have seen.
Yes, sir.
It is not required.
Yes, my lord. But this case is entirely different. It is for rejection of license. ಅದರಲ್ಲಿ impleading application ಹಾಕೊಂಡು ಬಂದಿರೋದು. So ಅದರಲ್ಲಿ as per the court, IT court direction, my lord, we have paid 292 crores.
ಇವಾಗ when will you give it, Mr. Vasant?
Please, next week about 3-4 days.
3-4 days. ಇನ್ಯಾರಿದ್ದಾರೆ for the deposit?
Serial number 34, my lord. I will furnish in the week, my lord. I will furnish.
34.
34, yes, my lord.
34 ಇದು connected.
ಅಲ್ಲ ನಂದು 34, party number 34 ಇದ್ರಲ್ಲಿ. Impleading application. Respondent 34, yes, my lord.
ಎಲ್ಲ ವೀಕ್ ಮಾಡಿದ್ರೆ ಇವ್ರನ್ನ ಹೆಂಗ್ ಹಿಡಿಯೋದು ಆಮೇಲೆ ಬಂದ್ಬಿಡತ್ತೆ.
ಅಲ್ಲ ತಮ್ಮ ಮುಂದೆನೆ ಇರ್ಲಿ. We'll comply this.
All the monies have to be paid.
Yes, ma'am. Only the question is, my lord, bank ನವ್ರದ್ದು ಇರೋದು ಏನಂದ್ರೆ ಡೆಪಾಸಿಟ್ ಮೆಚುರಿಟಿ ಅಮೌಂಟ್ ಆದ್ಮೇಲೆ ಏನಿದೆ SBI ಇಂಟ್ರೆಸ್ಟ್ ಅಷ್ಟು ಮಾತ್ರ ಕೊಡಕ್ಕಾಗುತ್ತೆ ಅಂತ. ಯಾಕೆಂದ್ರೆ ಇನ್ನ ತುಂಬಾ ಜನ ಇದ್ದಾರೆ, ಎಲ್ಲಾರ್ಗೂ ಕೊಡಕ್ ಹೋದ್ರೆ ದುಡ್ಡೇ ಸಾಕಾಗಲ್ಲ. ಸೊ ಏನು SBI ಅಂದ್ರೆ ಮೆಚುರಿಟಿ ಅಮೌಂಟ್ ವರ್ಗೂ ಏನೇನು ಇಂಟ್ರೆಸ್ಟ್ ಇದೆ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇನ್ನೇನ್ ಕೊಡ್ಬೇಕು ಅದನ್ನ ಕೊಡ್ತಾರೆ. ಮತ್ತೆ ಇನ್ನ ಮಿಕ್ಕಿದ್ದು
ನೀವು ಕ್ಲೇಮ್ಸ್ ಅಂಡ್ ನಿಮ್ಮ ದುಡ್ಡಿರೋದು 292 crores ಇದೆ.
ಅಲ್ಲ ಅದು ಕೊಟ್ಬಿಟ್ಟಿದೀವಿ.
ಕೊಟ್ಟಾಗಿದೆ. ಇವಾಗ ಎಷ್ಟಿದೆ ದುಡ್ಡು?
ಇನ್ನು 8 ಕೋಟಿ ಇದೆ ಅಷ್ಟೇ. ಅದರಲ್ಲಿ ಅಫಿಷಿಯಲ್ಸ್ ಇದೆ, ಬೇರೆ ಬೇರೆ ಎಲ್ಲ ಇದು ಇದೆ, ಅದನ್ನೆಲ್ಲ ಡೀಟೇಲ್ಸ್.
ಎಂಟೈರ್ ಲಿಸ್ಟ್ ಆಫ್ ಕ್ಲೇಮ್ಸ್ ನಮ್ಮ ಮುಂದೆ ಇಡಬೇಕು.
ರೈಟ್.
If that 8 crores is sufficient for everybody
we will
get the full amount.
ಅಲ್ಲ ಇವಾಗ ಆಸ್ ಪರ್ ಬ್ಯಾಂಕ್ ಇಂಟ್ರೆಸ್ಟ್ ಏನ್ ಸ್ಮಾಲ್ ಇಂಟ್ರೆಸ್ಟ್ ಇದೆ, SBI ಅಕೌಂಟ್ ಇಂಟ್ರೆಸ್ಟ್ ಅದು ಕೊಟ್ರೆ ಎಲ್ಲರಿಗೂ ಮುಗ್ದೋಗುತ್ತೆ.
Place it on record.
Please, we are
Everybody
ready to
should
pay.
get it. Everybody will get rateably.
Please, ma'am.
May I make a submission?
Yes.
There has been an order from this honorable court on 12/6/2015, Your Lordship. That all the
2015.
Yes, Your Lordship.
Yes.
That all the deposits have to be renewed at the prevailing rate of interest.
Madam, that was in 2015.
Yes, so all the deposits have been renewed at the prevailing rate of interest. ಇವತ್ತು ಅವ್ರು ಬಂದು ಹೇಳ್ತಾರೆ 2.9 interest ಕೊಡ್ತೀವಿ, total interest.
ದುಡ್ಡೇ ಇಲ್ಲ ಅಂದ್ರೆ ಇನ್ನೆಲ್ಲಿ ಕೊಡೋದು?
So
ಲಿಕ್ವಿಡೇಷನ್ ಅಲ್ಲಿ ಇದೆ.
ಅಲ್ಲಿ
ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ.
If
Meeting
that
like-
is the thing that you have,
ಹಾ,
we liquidate the bank, you stand in line.
ಅಷ್ಟೇ.
Those people who that you want this kind of a stand to be
My lord,
adopted.
majority are agreeing for this, my lord.
2.9
Majority,
is
my
not
lord.
even the SB rate of interest, your lordship.
Whoever
SB rate ಅದು
accepts it-
4% ಕೊಡ್ತಾ ಇದ್ದಾರೆ. ಎಷ್ಟು ವರ್ಷದಿಂದ ಕಾಯ್ತಿದ್ದಾರೆ.
ಅಲ್ಲ ಇವ್ರು ಬೇಕಾದ್ರೆ ಫೈಟ್ ಮಾಡ್ಲಿ ಸ್ವಾಮಿ, ಯಾರ್ಯಾರು ಬೇಕು ಅಂತ ಅವ್ರೆಲ್ಲ ತಗೊಂಡ್ಬಿಡ್ಲಿ ಅಷ್ಟೇ.
ನೀವು ಕೊಡೋದ್ ಬೇಡ ಅಂದ್ರೆ
ಹಾ.
ಕೊಡಬೇಡಿ. ನಿಮ್ಗೋಸ್ಕರ ಇದು ನಿಲ್ಲಲ್ಲ. This will go through whoever has to, all of them, many
They
of
are
them,
all ready, my lord.
many of them have expired. The
Yes.
legal heirs are here before.
Yes, my lord.
I
that
had
is-
made the submission on the last.
And if
meeting.
you are doing it
15
pro bono, then we don't know.
Sincerely, we are doing it pro bono, your lordship, because everybody is a senior
We don't know
citizen.
what you are doing.
ಅಲ್ಲ ಅವರು 2.9 ಗೆ ಅವ್ರುನು ಪಾಪ ಕಷ್ಟ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. That's why we are representing them, your lordship.
Did
2.9
you
ಅಂದ್ರೆ-
advise them that if it goes in for liquidation, they will not even get 1 penny? That is when. For another 10, 15 years. Did you advise them properly?
ಅವರೇ ಹೇಳಿದ್ದು 2.9 ಅಂದ್ರೆ
ಅವ್ರು
ನಮ್ಗೆ
ಹೇಳ್ತಾರೆ,
ಇಂಟ್ರೆಸ್ಟ್ ಬರಲ್ಲ
ನೀವು
ಅಂತ.
ಲಾಯರ್ ಅಂತ ಅವ್ರು ನಿಮ್ಮ ಹತ್ರ ಬರ್ತಾರೆ.
That would not even meet
For you
the-
to advise.
ಎಷ್ಟೊಂದ್ ಜನ medical expenses ಇದೆಲ್ಲ priorities ಇದೆ, your
For you to advise, they come to you. If you don't give the proper advice, this is what happens. They'd have got this money 10 years ago.
ನಿಮ್ ಕ್ಲೈಂಟ್ ಎಲ್ಲ ಒಪ್ಪಿದ್ದಾರೆ.
10 years ago payment ಬಂದೇ ಇಲ್ಲ,
ಬಂದೇ
your
ಇಲ್ಲ,
lordship.
your lord.
It has been paid only
It's
last
been
2 years.
the
ago.
counsel of this honorable court, we have reached this level. Mr. Justice Abdul Nazir sir ಅವ್ರು ಕರೆದು ಹೇಳಿ
Yes, when will you give the papers?
2-3 days.
ಬೇಡ ಬಿಡಿ.
2 days time.
3 days.
Learned counsel for the for the liquidator. Submit that he has received documents of 27 depositors.
Please. And their statement is also recorded, my lord.
And they have been, those documents have been reconciled and a statement has been prepared. He submit that insofar as other impleading applicants and other persons who claim to be depositors, no documents have been furnished. In that view of the matter, in the interest of justice, 1 more week's time is granted to enable the depositor to furnish all the relevant documents that they claim on, that they base their claim on, to the learned counsel for the liquidator, which shall be so furnished by end of day 11th December. It is made clear that if documents are not furnished by that date, there would be no requirement for the liquidator to consider any such documents furnished thereafter.
Please.
The Shri Murthy learned counsel for some of the depositors submit that when they called upon the office of the bank, they requested for audit reports, etc.,
On the
which were
briefing
not,
of the clients.
which were not furnished. It is made clear that the that the meeting which is to be convened is only for the purpose of reconciliation on the basis of the documents submitted by the depositors with the records of the bank relating to that depositor. And there would be no scope for any of the depositors to seek for any documents from the bank or the liquidator. Those would be matters which would be required to be decided by this court and not in the meeting for reconciliation.
Calculation at annexure 7 is furnished,
lords.
my lord. ಏನೇನ್ ಕೊಡ್ಬೇಕು, ಏನೇನ್ ಇದ್ ಮಾಡ್ಬೇಕು ಅಂತ.
With respect,
To
my lord.
consolidate ಮಾಡ್ಕೊಡಿ.
Please.
With respect, my lords, with respect. May I make a submission? In that representation what they have given, that's been given by the depositors. ಅದ್ರಲ್ಲಿ ಏನ್ ಕೇಳಿದ್ದಾರೆ, ತಮಗ್ ಕೊಡ್ಲಿ ಅಂತ ಕೇಳಿದ್ದಾರೆ, ನನಗ್ ಕೊಡ್ಲಿ ಅಂತ ನಾವು ಕೇಳಿಲ್ಲ.
Now, we know what to get and what we'll have to do.
ಅದಷ್ಟೇ ನಾನು ಮಾಡಿದ್ದು.
Without giving them, don't.
ಸರ್ ಅಲ್ಲಿ ಇರ್ಲಿಲ್ಲ ಸರ್,
Mr.
ಸತ್ಯ
Murthy.
ಹೇಳ್ತಾ ಇದೀನಿ, ಇದು ಸತ್ಯ ಹೇಳ್ತಾ ಇದೀನಿ, ಅವ್ರು ಇರ್ಲಿಲ್ಲ ಅವತ್ತು.
ನಿಮ್ಗೆ
You want to talk to them?
ನಿಮ್ಗೆ ಇನ್ನ ಬುದ್ಧಿ ಬರಲ್ಲ ಅಂದ್ರೆ ನಾವೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. 5 ಸತಿ ಹೇಳಿದ್ವಿ,
ಅರ್ಥ ಆಗಿದೆ.
ಸುಮ್ನೆ ಇರ್ರಿ ಅಂತ.
ತುಂಬಾ ಬೇಜಾರಾಗ್ತಿರೋ ವಿಚಾರ ಅಂದ್ರೆ ನೋವಾಗಿ ಮಾತಾಡ್ಬಾರ್ದು ಅವ್ರು.
ನಿಮ್ಗಿಂತ
they
ಜಾಸ್ತಿ
conduct.
ನಮಗ್ ಬೇಜಾರಾಗ್ತಾ ಇದೆ, ಪಾಪ ಇವ್ರಿಗೆ ದುಡ್ಡು ಹೋಗಿಲ್ಲ ಅಂತ.
ಕೇಳಿ ಅವ್ರನ್ನ,
And-
ಡಿಪಾಸಿಟರ್ಸ್ ಹೇಗೆ
And
ಟ್ರೀಟ್
because of
ಮಾಡ್ತಾರೆ.
your way of doing it, they'll be blaming the court.
We have
That
given
there's a delay.
blood and sweat, my lords, blood and sweat
The
for this.
delay is not in the court, delay is because of wrong advice.
My lords, maybe recorded in that way.
List
ನಮ್ಗೆ
on-
ಯಾಕೆಂದ್ರೆ ಪ್ರೊಫೆಷನಲ್ ಕಾಂಡಕ್ಟ್ ಮೇಲೆ ಬಹಳ ಕ್ವಶನ್ ಆಗುತ್ತಿದೆ.
On 11th,
ನನಗೆ ಅದು
You
ತುಂಬಾ
want-
ನೋವಾಗಿದೆ your lord.
You want to say something?
Please, my lords.
If we
ತಗೊಂತೀನಿ.
say it,
ಇವತ್ತು ನಾನು I will
then
receive.
you will be in lot of difficulty. Please.
I will receive, my lords.
When will you have the meeting?
My lord, from sessions are going on but till 20th, my lord. Liquidator is deputed there, my lord. After 20th, any date. ಮಾಡ್ತೀವಿ.
Vacation ಬರುತ್ತೆ.
ಅಲ್ಲ ಅದ್ರಲ್ಲೇ ಮಾಡ್ತೀವಿ, ಹಂಗೆ ವೆಕೇಶನ್ ಅಲ್ಲೇ ಮಾಡ್ತೀವಿ. ನಮಗೂ ಟೈಮ್ ಬೇಕಲ್ಲ, ಅವ್ರು ಒಂದು ವಾರ ತಗೊಂಡು ಕೇಳಿದ್ದಾರೆ.
So meeting will be in January.
ಆಗ್ಬೋದು. ಅಲ್ಲ ಬೇಕಂದ್ರೆ ವೆಕೇಶನ್ ಅಲ್ಲಿ ಬರಂಗಿದ್ರೆ
ಯಾರು ಇರಲ್ಲ ಆಮೇಲೆ.
ನಾವು ಬರ್ತೀವಿ ಮನೆ.
ಆಮೇಲೆ ಯಾರು vacation.
ನಾವು ಬರ್ತೀವಿ.
ಆಯ್ತು, ಜನವರಿಯಲ್ಲಿ
They should not have suffered because
ಈ
of that.
ಕೇಸ್ ತಮ್ಮ ಹತ್ರನೇ ಇರ್ಲಿ ಸರ್, ಪಾರ್ಟರ್ಡ್ ಅಂತ
Parted ಅಂತ
ಪ್ಲೀಸ್.
ಹಾಗಾದ್ರೆ 2 weeks time
ಆಯ್ತು
to furnish all the
ಆಯ್ತು
documents.
ಸ್ವಾಮಿ, ಆಯ್ತು.
ನೀವು ಆಮೇಲೆ ವೆಕೇಶನ್ಗೆ ಹೋಗ್ತೀರಾ. 3 weeks time to furnish the document to the council for the liquidator, which shall be furnished on or before 8th January 2025.
ನನ್ಗೆ ಹೇಳೋ ಬದಲು ಐ ವಿಲ್ ಜಸ್ಟ್ ಆಸ್ಕ್ ಒನ್ ಆಫ್ ಮೈ ಬ್ಯಾಂಕ್ ಸ್ಟಾಫ್ ಟು ಬಿ ಪ್ರೆಸೆಂಟ್ ಹಿಯರ್ ಮೈ ಲಾಟ್ ಇನ್ ದಿ. ಅಲ್ಲ ನನ್ನ ಏನಾಗುತ್ತೆ, ನಾಳೆ ನನ್ನ ಮೇಲೆ ಹಿಂಗೆ ಅಲಿಗೇಷನ್ ಮಾಡ್ತಾರೆ, ಸಿಕ್ಲಿಲ್ಲ ಹುಡುಕೊಂಬಂದು ಅದು ಇದು.
ಸ್ವಾಮಿ ಯಾರಿಗಾರ ಒಂದು ಫೋನ್ ನಂಬರ್ ಕೊಟ್ಬಿಟ್ರೆ ಆಗ್ಬಿಡ್ತು ಸ್ವಾಮಿ. ಯಾವ್ದು ಫೋನ್ ನಂಬರ್ ಕೊಟ್ಬಿಟ್ರೆ ವಾಟ್ಸಪ್ ಕಳಿಸ್ತೀವಿ, ಕಡೆ ಫಿಸಿಕಲ್
ಅಲ್ಲ ಬ್ಯಾಂಕಲ್ಲೇ ಬೇಕಾದ್ರೆ ಬ್ಯಾಂಕಲ್ಲೇ ಕೊಡ್ಲಿ ಸ್ವಾಮಿ, ಏನ್ ಪ್ರಾಬ್ಲಮ್.
Liquidator was also present at 4:30. But he oftenly incame endorsement. I don't know that because it's not my business to give an endorsement that you are there. He was present here itself in the court.
ಬ್ಯಾಂಕ್ ನಲ್ಲಿ ಬೆಟರ್ ಮೇಲೆ ಕೊಡ್ಬೋದು. ಬ್ಯಾಂಕ್ ನಲ್ಲಿ ಇರ್ತಾರೆ ಸ್ಟಾಫ್, ಅಲ್ಲಿ ಕೊಡ್ಬೋದು. ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಕೊಡ್ಬೋದು.
By end of day,
ನಾವು ಒಂದು ರಿಜಿಸ್ಟರ್ ಮೇಂಟೈನ್ ಮಾಡಿದೀವಿ, ಸೈನ್ ಹಾಕ್ಸ್ಕೊಂಡಿದೀವಿ, ಅದೇ ತರ ಮೇಂಟೈನ್ ಮಾಡ್ತೀವಿ. ಅದನ್ನ ಬೇಕಾದ್ರೆ ಹೇಳ್ಬಿಡಿ ಸರ್, ಟು ಅಫಿಕ್ಸ್ ದರ್ ಸಿಗ್ನೇಚರ್.
I'll ಬಂದು ಬ್ಯಾಂಕ್ ತಗೊಂಡಿಲ್ಲ ಅಂತಾರೆ, ಅದೇ ಪ್ರಾಬ್ಲಮ್.
Bank will be directed to receive on behalf of the liquid OL balance.
Correct.
Yes, my
By
lord.
8 December, by end of day 8 December at the bank, 8th January at the bank. The bank shall maintain a register of all the receipts of the documents,
ಅದನ್ನ ಅನೆಕ್ಸ್ ಮಾಡಿದೀನಿ, ಸೈನ್ ಮಾಡಿರೋದೆಲ್ಲ.
of all the documents submitted, and issue a receipt for having received the documents.
ಪ್ಲೀಸ್.
The reconciliation meeting shall take place after examination of documents on 16th.
ಆಗ್ಬೋದು.
ಇಲ್ಲ Saturday ಮಾಡ್ಬೇಕಾ?
ಸ್ಯಾಟರ್ಡೆ ಮಾಡಿದ್ವಿ.
On 18th January,
ಮಚ್ ಒಬ್ಲೈಸ್
commencing from 10:30 AM.
ಪ್ಲೀಸ್.
The reconciled statement shall be placed before this court by ಎಷ್ಟು ದಿನ ಬೇಕಾಗತ್ತೆ?
ಅದಾದ್ಮೇಲೆ ಒಂದು 10 days ಅಲ್ಲಿ ಮಾಡಿ ಆಗ್ಬೋದು.
By 27th January,
27.
relist on 31st January at 2:30 PM
ಮಚ್ ಒಬ್ಲೈಸ್.
for further hearing.
Yes. My lord,
ಏನಮ್ಮ?
They have called for the meeting. We all went there. They have asked our details. How much is there and who are all the nominees and everything they told. But the interest point they did not.
ಅಲ್ಲ ಅದನ್ನ ಕೇಳಕ್ಕಲ್ಲ.
That is for us to determine.
That's what. they are
We
not
will
clear.
determine that. That is why we are telling you, you only have to give your documents. That's all. Don't ask them anything.
4784.
For the purpose, why we
So
have.
election.
come there? What is the
ಎಲೆಕ್ಷನ್
interest
ಅದು ಡಿಸ್ಮಿಸ್ ಮಾಡಿಸ್ತಾರೆ.
for us? Hard earned money.
That interest,
They
ಎಲೆಕ್ಷನ್
have
ಮಾಡಿ.
called.
madam, that interest we'll have to determine after taking into account the amounts available. See, how much ever amount is there, that will have to be distributed amongst everybody. We can't give more than what is there.
Yes, sir.
That is why we are feeling bad that this could have happened long ago.
Yes,
Correct,
sir.
madam.
You would have got the money long ago. This last 5 years of interest also you would have got the money and used the money
Yes, sir.
instead of fighting on small little things. So you give the documents to them. There is around 8 crores which is there now. That 8 crores will have to be distributed amongst all the depositors and some other monies. So first we'll look at the principal. Please.
Principal is
have-
paid, my lord. Entire principal.
Wherever the principal is paid, well and good.
Principal is paid.
If the principal is not paid, the first which will go out to people who have not received the principal, will get the principal.
Correct.
Then remaining amount, we'll look at what is the interest that can maximum be given.
That's right.
It may not be PLR, it may not be any this one. With the amount that is there, what is the maximum that can be given? Correct. That is why we want to finish it soon so that you get it early.
Yes, sir.
Otherwise, another 6 months, the interest will go up and money will be less. So you give them the documents.
ಅಲ್ಲ ಇವತ್ತೇ ರೆಡಿ ಅಂದ್ರೆ ಇವತ್ತೇ ಬೇಕಾದ್ರೆ ಚೆಕ್ ಕೊಟ್ಬಿಡ್ತೀವಿ.
This is.
ನೀವು ಚೆಕ್ ಕೊಡಕ್ಕಾಗಲ್ಲ until we pass an
ಅಲ್ಲ
order.
ಅದೇ
ಎಲ್ಲ ಮಾಡಬೇಡಿ.
ಆಯ್ತು ಸಾರಿ.
Yes.
My lord, writ petition 47845 of 2018. This pertain to election, my lord. That becomes infractious because of the appointment of liquidator.
Mr. Atti?
Atti or is no more, my lord.
ಹೌದು. ಯಾರು ಬಿ ವಿಶ್ವನಾಥ್ ಕರೆಕ್ಟ್.
ಅದು ಎಲೆಕ್ಷನ್ ಕಂಡಕ್ಟ್ ಮಾಡಿ ಅಂತ ಹಾಕೊಂಡಿದ್ದಾರೆ.
4784.
Similar case, my lord, it was dismissed, my lord.
ಎಲೆಕ್ಷನ್ ಅಂತ ಇನ್ಯಾವ್ದು ಎಲೆಕ್ಷನ್ ಯಾವ್ದಿಲ್ಲ.
ಅಷ್ಟೇ ಸ್ವಾಮಿ. ಇನ್ನ ಎರಡಿತ್ತು ಅದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಅದು ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
47845.
ಹೌದು.
Petitioner is before this court
My name may be shown, my lord.
seeking for the following reliefs. A liquidator having been appointed to the respondent number 4 society, the question of holding elections would not arise. Hence, the petition stands dismissed.
Please, my name may be shown.
Hmm?
Bank can ನನ್ನ ಹೆಸರು ಕೊಡಿ. My name may be shown, my lord.
ಯಾವ್ದ್ರಲ್ಲಿ?
Bank.
ಫೈಲ್ ಮಾಡಿಲ್ವಾ ವಕಾಲತ್ತು?
ಇಲ್ಲ ಸರ್.
Bank is respond number?
4. I'm sorry, my lord. 4.
Registry is directed to print the name of the counsel appearing for the liquidator in respect to the bank, as that appearing for respond number 5. Delete the name of Sri Keshav Reddy. Yes.
Much obliged.
Please furnish all the documents, don't make allegations.
No.
Not going to get into any allegations. Next.
Lots.
Next.
Serial number 13.
Recall it.
Millets.
ಏನ್
Millets.
recalling?
ದಯವಿಟ್ಟು ಒಂದು ರಿಕ್ವೆಸ್ಟ್. Ask the bank to not to go to the depositors and spread wrong messages. ದಯವಿಟ್ಟು ಇದಾಗಿರೋದನ್ನ ನಾನು ನಿಮ್ಮ ಮುಂದೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. We have a good standing in the bar.
ಪಾಪ ಅವ್ರಿಗೂ ಸಂಬಳ ಇಲ್ದಲೆ ಒದ್ದಾಡ್ತಾ ಇದ್ರು. ಅವ್ರು
ಕೇಳಿ ಡಿಪಾಸಿಟರ್ಸ್ ಬೆಳಿಗ್ಗೆ ಬಂದು ಹೇಳಿದ್ದಾರೆ ನಿಮ್ ಲಾಯರ್ ಸರಿ ಇಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಅವ್ರೇನ್ ಸಿಟಿಂಗ್ ಬ್ಯಾಂಕ್ ಎಂಪ್ಲಾಯ್ ಥ್ರೆಟನ್ ಮಾಡ್ತಾ ಇದಾರೆ. ಅವತ್ತು ತಾವು ಅಲ್ಲಿ ಯಾರಾದ್ರೂ ಇದ್ದಿದ್ರೆ ಗೊತ್ತಾಗಿರೋದು. ನಾನು ಹೀರೋಗಿರಿ ಮಾಡಿಲ್ಲ ಇವಲ್ಲ. ಐ ಡೋಂಟ್ ವಾಂಟ್ ದಟ್. ಬೆಟರ್
First deposit the.
ನಾನು ಮಾಡ್ತೀನಿ, ಬಟ್ ಅವ್ರಿಗೆ ಒಂದು ವಾರ್ನಿಂಗ್ ಬೈ ಆರ್ಡರ್ ಕೊಡ್ಬೇಕು. ಬಿಕಾಸ್ ದೇ ಕ್ಯಾನ್ ನಾಟ್ ಅಸಾಸಿನೇಟ್ ದ ಕಾಂಡಕ್ಟ್, professional conduct and image
If
of
they are doing that, let them not do it. But you comply with the order.
I shall do it because I cannot stand that.
Yes.
Great.
Thank you. 13.
Serial number 13. I appear for the respondent bank, your lordship. I received the copy of the IA yesterday night by WhatsApp. May I request your lordships to kindly grant me 4 weeks' time? I'll get instructions. My lord, this pertains to sale of gold or pledged gold ornaments during 2019. The petition was disposed of during 2022. Now they have made certain allegations that even after the sale, their bank has held one more sale. Thank you. I've received the copy.
Okay, yes. This
I have
is
to get instructions, my lord. This is a serious allegation.
the allegation.
I've received the copy.
Their submission is that because this was disposed of as infructuous.
Yes.
It could not have been because you held a auction subsequently.
Yes, that's what they claim.
Serious allegation.
Yes, your lordship.
humble submissions, my lord. My lord, in the application, my lord, I produced one notification, my lord. On 29/3/2019, they told that it's conducted.
Let us get their reply. If you are right, then we'll take action against that manager who has made that submission.
Please.
If you are wrong, then
Please, my lord.
let it come on record.
Please.
Learned counsel for response seeks for and is granted a week's time.
For 4 weeks, your lordship.
4 weeks.
This of 2019, the manager would have changed. These small rural branches are manned by one officer, my lords. If he has to go through the records, he has to, I mean,
3 weeks time to file a statement of
Much.
objection. Objections, if any, to be filed on or before 9th January, relist on 16th January.
much.
14, Pawan Chandra Shetty.
Clear.
Petitioner, my lord.
So Jagdish,
I am appear for the respondent, my lord. My sir was met with an accident, my lord.
huh?
My sir was met with an accident, my lord. Knee injury ಆಗಿದೆ ಬೆಡ್ ರೆಸ್ಟ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ ಸ್ವಾಮಿ.
ಇನ್ನ ರಿಕವರಿ ಆಗಿಲ್ವಾ? ಮೈನರ್ ಆಕ್ಸಿಡೆಂಟ್ ಅಂದ್ರೆ?
ಅದು knee ಸ್ವಲ್ಪ ಇಂಜುರಿ ಆಗಿದೆ ಸ್ವಾಮಿ, ಅದು ನಡೆಯಕ್ಕಾಗಲ್ಲ ಸ್ವಾಮಿ, ಬೆಡ್ ರೆಸ್ಟ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ.
He had an accident.
Next week also.
It is submitted that the counsel for respond number 1, 2, 3 and 5 has suffered from an accident. Released on 9th January.
15, Prasad B.
Much obliged, my lord.
As to this matter, last citation on 15/11/2024, Honorable Court directed for a scientific investigation of the building.
Age of the building.
I inquired all those things and I have written a letter to the PWD also. PWD has stated that such kind of labs or something is not available in Shumaga. So on 28th of this month, I have intimated the sub-register to get back the file of the connection what they have obtained in 2008. It's 10 kilowatts for power.
ಎಷ್ಟು ದಿನ ಸ್ಫೂರ್ತಿ ಇದು?
May I make only one submission, ma'am?
Building was there, everything is
May I
there.
make only one submission?
Let them itself produce the current bill, my lord. They would be having that.
ಅವ್ರು ಇಲ್ಲ ಅಂತ ಬಿಲ್ಡಿಂಗ್ ಇಲ್ಲ, ನಾವು ಕರೆಂಟ್ ಬಿಲ್ ಎಲ್ಲಿ ಅಂತಾರ ಅವ್ರು.
May I make only one submission, my lord?
ನೀವ್ ಹೇಳ್ತಾರೆ ಬಿಲ್ಡಿಂಗ್ ಇದೆ ಅಂತ.
May I make only one submission? I have to save my property, my lord. That's the reason, my lord. I have obtained a loan. That is the reason attachment is there. That's why, my lord, minimum the penalty may be imposed, my lord. I will ready to deposit, my lord, because or otherwise I will lose the entire property. Because
Why will you lose the entire property?
because they will attach the property and they will take away that property. If I sell this property, I will get more money.
You're not able to clear the loan.
Yes,
Loan
my lord.
ತಗೊಂಡಿದ್ದೀರಾ?
Yes, my lord. Is a
You're
private
not
loan
able
is
to-
also there. And that's why, my lord, I have to, since from 2011, it's
So
a dispute
what is
between.
your submission now? You want to?
Because I am, it's a 4 lakh, they impose a penalty, sorry, actual due, they are saying. And they impose a penalty 5 times. That penalty may be
So 4 lakhs you are ready to pay?
4 lakhs, I'm ready to pay, my lord. Because I have to come out, my lord, or otherwise I will not sell the property.
There won't be any purpose left. Aman.
Already deposit 2 lakh and out at the time of filing appeal. Remaining 2 lakhs, my lord, I will ready to deposit.
What provision is this penalty?
It's a section 25, my lord. 28,
Stamp Act. Alla?
Stamp Act.
$20?
28.
2/8.
Yes, my lord.
2/8 penalty ಎಲ್ಲಿದೆ?
Penalty is considered, my lord, 61. Rules 61. Sorry, sir. party. ಇಲ್ಲ ಇಲ್ಲ.
Extend to 5 times the amount of the deficiency. Up to. ಇದು maximum ಮಾಡಿದ್ದಾರೆ.
Building was constructed, power was.
Because may make submission, my lord. It's a dispute between my uncle and the proper. After that, my lord, he filed a complaint before.
ಎಷ್ಟು penalty ಕೊಡ್ತೀರಾ?
Because he do, is a,
One time ಆದ್ರೂ ಕೊಡ್ಲೇಬೇಕಲ್ಲ.
because of this,
Maybe 3 times.
if I kindly see, my lord, kindly see valuation itself, my lord, I will say that valuation itself is, kindly see, after remand, they are saying that, my lord, very same order parts, they are not at all visited the part.
That if one merits you want to argue, then
No,
we'll have to do
that's,
that.
that's why, my lord, because I am losing.
ಅದಕ್ಕೆ if you have to do it, then we can't pass an order on merits. We'll have to say this and reduce the penalty.
Penalty
If
and.
we have to
and
reduce the
also
penalty,
give-
we can't make it 0.
Yes, my lord.
So
That's
at least
why I.
ಮಾಡಬೇಕು ಅಂತ ಅವರು 3 times ಅಂತ ಇದ್ದಾರೆ. At least once if you agree, we'll pass that order.
Sir,
So that you can save the
the
property.
interest is also there, my lord, 12% interest is there, that's why.
ಅದು ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. That we can't do
Sir,
anything.
on
because
the
the-
principal amount, not on the penalty.
Penalty. Penalty will, if you reduce it to one time, that will automatically reduce.
Yes, my lord, but interest part is concerned, my lord, only on the penalty amount, not on the, sorry, due amount. Interest is concerned, my lord, only on the part of the due amount, not on the penalty. If it is a penalty is concerned, my lord, it's a.
ತಗೊಳ್ಳಿ.
3 times the interest.
3 times. Petitioner is before this court seeking for the following reliefs. The petitioners claim to have purchased a site from one Abid Rahman, son of Abdul Rahman, and Srimati Shamshia Taz, wife of Abid Rahman, bearing Kata number 128 and municipal Kata number 128 and municipal old Kata number 814:132:128 and running municipal Kata number 814 so and so, measuring about 10,802.50 square feet and a registered sale deed dated
23/3/2011.
3/3/2011, which was registered as document number 10387 of 2010-11. Proceedings were initiated against the petitioner for contravention of section 28 of the Karnataka Stamp Act 1957 on the ground that the petitioner had not disclosed the correct information in as much as the sale deed is purported to have been executed as regards a vacant site, where in fact there was a construction which had been put up thereon. And it is in that background that after providing an opportunity of hearing to the petitioner, the second respondent, third respondent, while is order dated 22/12/2015, directed the petitioner to make payment of the stamp duty on the value of the construction and the property, which is valued at rupees 82,38,000, and directed the petitioner to make payment of sum of rupees 4,24,185 as differential stamp duty and rupees 62,380 as differential registration fee, and has also imposed penalty of 5 times the said differential amount along with interest at the rate of 12% from the date of registration on the differential stamp amount, differential registration fee, as also on the penalty. It is challenging the same, the petitioner is before this court. Now, counsel for the petitioner submit that there was in fact no construction which had been put up on the said property. What the petitioner purchased is only a vacant site. There being a dispute between the petitioner and one of his uncles, a false complaint had been lodged against the petitioner, which resulted in the aforesaid proceedings being taken up in the year 2015. The sale deed having been executed in the year 2011. In the meanwhile, the petitioner had put up the construction. The submission of Shri B.S. Prasad and counsel for the petitioner is that without ascertaining the date and time of construction, the respondent authorities cannot contend that the construction had been put up even prior to the sale deed having been executed, and call upon the petitioner to make payment of the differential stamp duty and registration fee, let alone imposing of penalty thereon. The respondents were called upon to make the submission as to on what basis it has been contended that a construction had already been put up. The submission of learned AGA in that regard is that there being a electricity connection which had been taken, which had been availed in the year 2008 for 10 kilowatt, same would indicate that there was in fact a construction put up, completed and in occupation.
Construction license was obtained in 6/7.
The construction license having been obtained in the year 0607 by the earlier vendor of the petitioner. Heard so and so peruse papers. Though this court had called upon the respondent state to ascertain if there was any scientific methodology of ascertaining the age of the building, the learned AGA submits that the PWD department does not have any such scientific equipment to measure the age of building. That being so, this court would have to look at the documents which are now available on record. The plan sanction having been granted in the year 2006-07, the building license having been issued in the year 2006-07, electricity connection for 10 kilowatts having been obtained in the year 2008. The petitioner having purchased the property in the year 2011, the description of the property was indicated to be a vacant site in the registered sale deed. The fact that electricity connection for 10 kilowatt as a permanent connection has been obtained and not as a temporary connection would indicate that there is a building which had already been constructed and a permanent connection was serviced to the said house. If not, it would have been a temporary connection of much lesser kilowattage would have been obtained by the vendor of the petitioner. The photographs which have been produced also indicate that the building is quite old. However, the said photographs cannot be relied by me at this stage to determine the age of the building. The plan sanction and the servicing of the electricity connection would be sufficient at this stage to hold that the building had in fact been completed and the electricity connection commissioned in the year 2008 itself. That being the case, the claim of the petitioner that there was no construction which had been put up and therefore the same was not required to be mentioned in the sale deed, and consequently there is no violation of section 28 of the Karnataka Stamp Act 1957 cannot be countenanced in law of facts. Hence, no grounds having been made out, the petition would be liable to be dismissed. However, taking into consideration that the maximum penalty has been imposed in terms of section 61, and they consider opinion that the construction being that of an house, and in terms of submission made by the learned counsel for the petitioner, they said house has also been mortgaged and has now been brought to sale, now is proposed to be brought for sale by the bank. And they consider opinion that the penalty can be reduced, taking into consideration the peculiar circumstances with a human element. In that view of the matter, the penalty imposed is reduced to one time the stamp duty, the differential stamp duty, which is, and registration fee, which is required to be paid. The interest cannot be levied on the penalty.
ಇಲ್ಲ ಇಂಟ್ರೆಸ್ಟ್ ಅದಕ್ಕೆ ಇದಕ್ಕಿಲ್ಲ ಪ್ರಿನ್ಸಿಪಾಲಿಗೂ ಇಲ್ಲ. ಇಫ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಡೆಪಾಸಿಟೆಡ್ ದೆನ್ ಇಂಟ್ರೆಸ್ಟ್ ವಿಲ್ ಬಿ ಇಂಪೋಸ್ ಅಂತ. ಸಾರಿ ಬಟ್ ಅದರಲ್ಲಿ ಏನಂತ
ನೀವು
ಹೇಳಿದ್ರೆ
ಡೆಪಾಸಿಟ್ ಮಾಡಿಲ್ವಲ್ಲಪ್ಪ?
ಅಲ್ಲಲ್ಲ ಸೀಸ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್, ದಟ್ಸ್ ದಿ ಎಂಟೈರ್ ಮ್ಯಾಟರ್ ಸೀಸ್ ಬಿಫೋರ್ ದಿ
Don't take that advantage.
ಇಫ್
Interest cannot be levied on the penalty and can be only levied on the differential stamp duty and registration fee. And as such, the petitioner would be liable to make payment of the differential stamp duty, differential registration fee, differential stamp duty of rupees.
is already deposited 50% of amount is already deposited at the time of filing appeal.
On the differential stamp duty, the Madak Munche, the petitioner has deposited 50% of the differential stamp duty and registration fee. Stamp duty and registration fee na?
Registration fee, sorry, registration.
Stamp duty
4,24,000 ಅಲ್ಲಿ.
4,24,000, Prasad.
Yes, my lord, so 2 lakhs not that we deposited at the time of filing appeal before the commissioner.
Registration fee 62,000, so total 484 ಬರುತ್ತೆ.
Yes, my lord.
Yes, deposit ಮಾಡಿದ್ದೀರಾ?
2 lakhs 12,000.
The petitioner has deposited a sum of rupees
12,000.
ಯಾವತ್ತು?
So at the time of filing appeal, my lord, I don't have a receipt. I don't have a receipt, my lord.
Before the second respondent.
Before the second respondent commissioner, at the time of first filing the first appeal in the year 2000.
ಎಷ್ಟು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದೀರಪ್ಪ? ಅಮೌಂಟ್ ಎಲ್ಲಾದ್ರೂ ಇದೆಯಾ?
ಇದೆ 50% of the amount.
ಯಾವ್ದು?
It's a statute says that, my lord, it's at the time of filing appeal, we have to deposit 50% of the amount.
50% of what? Stamp duty and registration fee, or both you are deposited?
No, my lord, only a registration fee, 2 lakh and
Has deposited certain amounts before the second respondent at the time of filing of the appeal. If that be so, due credit to said deposit amount would have to be provided to the petitioner. Hence, the petitioner would be liable to make payment of the differential stamp duty after taking into account differential stamp duty and differential registration fee after taking into account. ಏನಮ್ಮ? ಏನಾಯ್ತು ಶ್ರೀನಿವಾಸ್? ಯಾರು? ಡಾಕ್ಟರ್ ಫೋನ್ ಮಾಡಿ ಮಾಡಿದ್ದಾರೆ. Get us something to eat from the canteen or something. You may not have eaten. In month.
Sorry, my lord, 2,12,095 rupees deposited.
Stamp duty of 4,24,185 and differential stamp registration fee of rupees 62,380. After taking into account the deposited amount of rupees 2,12,095, the interest at the rate of 12% being payable on the said differential amount after taking into consideration the deposit.
Instead of one, for 2 times, maybe. It will not carry interest also.
ಪಾಪ ದುಡ್ಡಿಲ್ಲ ಇವಾಗ. ನೀವು
30 days time.
ಮಾಡ್ತಾ ಇಲ್ಲ.
ಬೇರೆಯವ್ರು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿರೋದ್ರಿಂದ ಇವ್ರಿಗೆ ಚೆನ್ನಾಗಿ.
30 days time may be granted, my lord. Depositing the amount, 30 days time may be granted.
Petitioner is granted 30 days time to make payment of the aforesaid amounts.
Please.
16. Sadhya, you Prabhu.
My lord, in this case, my lord, the client is going to close the loan by today itself, it seems, my lord.
Mr. Muthana,
No, my lord, this.
ಅಲ್ಲ ಇವತ್ತೇ ಕಟ್ತಾರಂತೆ.
ಇಲ್ಲ, ಇಲ್ಲ, ಇವತ್ತು-
ಮಂಡೆಗೆ ಹಾಕೊಳ್ಳಿ ಸುಮ್ನೆ.
My lord, this is all, no, my lord, because
No, if you. Loan close ಇವತ್ತು.
yesterday 6 o'clock they sent the mail. Then I said, no, I cannot bill you because I'll wait till 10:30. So that you may pay in the night RTGS and all. 10:30 they sent the mail that they, very sorry to inform you that they have not paid even a single pi. And even that, my lord, that interim order has all not been completed with. That is why your lordship has dismissed it. And again, our petitioners
No,
council came and
What I'm
requested
asking for is only
entire
Monday,
amount
my
has to
lord.
be paid.
Monday,
Lord.
Monday ಒಳಗಡೆ ಇವತ್ತು ಕಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಮಂಡೇ ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಡ್ಲಿ.
counsel
dismiss
for the
ಮಾಡಿದ್ರೆ.
petitioner submit that the entire loan amount will be cleared by end of day 9th December. Released on 10th December at
As per
2:30
my
PM.
instruction.
ಗೊತ್ತಿಲ್ಲ ನಿಮ್ಮ
ಅಲ್ಲ
instruction
ಅಲ್ಲ ಅದನ್ನ ಬರ್ದು ಬಿಡಿ.
ನೀವು ಅಷ್ಟು ಜೋರಾಗಿ ಹೇಳ್ತಾ ಇದ್ದೀರಾ.
ಅಲ್ಲ ನಮ್ಮನ್ ಕಳಿಸ್ಬಿಟ್ಟ ಬಾರ್ ಕೌನ್ಸಿಲ್.
ಪಾಪ ಅವ್ರು ಇಲ್ಲ ಅಂತ ಇದ್ದಾರೆ.
ಇಲ್ಲ ನೋಡಿ,
as per the
Instructions submit that.
Please.
17. Sharath Gowda.
In this matter, my lords, first, my lords, I have to say that there is a bona fide mistake. The court had directed to deposit a DD 5 lakhs, sum of rupees 5 lakhs, my lords. ಅದು 5 lakhs DD ಅವತ್ತಿಗೆ ತಗೊಂಡಿದ್ದಾರೆ, ಬಟ್ ನಮ್ಮ ಆಫೀಸ್ ನಲ್ಲಿ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ, my lords.
24/11/2022, the order was posted, order was passed.
ಹೌದು.
And in fact, from then, my lords, the EMI would itself run up to 7 lakhs. From then,
DD
the monthly EMI would itself run to 7.
ನಮ್ಮ ಆಫೀಸ್ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ, ಅಲ್ಲಿ ಆಫೀಸ್ ಅಲ್ಲೇ ಉಳ್ಕೊಂಡ್ಬಿಟ್ಟು.
In fact, I moved IA, served a copy on him way back in
DD ಅಂದ್ರೆ ಸ್ವಲ್ಪ ಇರತ್ತೆ.
July ಅಲ್ಲಿ ಕೊಟ್ಟಿದೀವಿ ನಾವು ಅವ್ರಿಗೆ. We have served a copy for IA for vacating. At least then you could have informed us.
ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ. ಕೊಲಿಗ್ ಒಬ್ರು
I had to run pillar to post to get this matter listed, my lords. Had to run
Pillar to post to get it listed. ನಮ್ಮುಂದೆ. What is this?
Yesterday we made submission. The file ಸಿಕ್ಕಿರ್ಲಿಲ್ಲ ಅಂತ. Yesterday we made submission, my lords, it came before.
First I will deposit, my lords, on merits. I have a
But
case.
I have serious objections. Additional condition of another 5 lakhs may be imposed.
What is the due as on today?
The due is more than
24,20,000 was the due, my lords, but your lordship will.
On 24/11/22.
Yes, my lords.
What is the amount today?
lords, as on 34, somewhere 34 to 35 lakhs, my lords, as on today, approximately.
Lords, one submission, my lords. This petitioner along with her husband availed the loan of rupees 42 lakhs. They were paying regular EMIs, my lords, 24 lakhs. The husband of the petitioner died. They were the joint account holders. They had availed loan jointly, my lords. At the time of availing the loan, my lords, the first respondent, that is the bank, insisted upon taking a life insurance policy, my lords, so that to secure the loan amount. That policy was taken, my lords. My lords, that second respondent is the insurance company. Master policy holder is the bank itself. They know everything. Now, my lords, they have declined to honor the insurance amount to secure the loan on the count that this husband of the petitioner was suffering from physical deformity. Lords, admittedly, he was a polio patient. Bank was aware. They filled the form. It is a regular format. Now they deny the claim to honor the insurance amount on the count that the petitioner had not disclosed his previous medical history. Your lordship will kindly take the insurance policy, my lords. At annexure D.
You dishonored insurance, you declined the.
Yes, I am for the respondent number 1. I am a home finance company. Respondent number 2 is ICICI Life Insurance Company.
Respondent number 2, yarappa.
Respondent number 2,
Who appears for respondent number?
some other advocate. I don't know.
Who appears?
All these arguments were addressed in the initial day of admission of this matter, my lords. In spite of that, interim order was imposed.
That's a different, that will not take
Respondent
away my.
Siddhappa.
I am for the respondent number 1, my lords.
Or respondent
Revant
one.
Siddhappa for R2.
Revant Siddhappa.
That's what happens, my lords.
And
Nowadays,
the-
it has become a ailing person. Loan is claimed. This is a, within a span of 4 months, he will die after taking the loan. In fact, it is admitted he was ailing.
Bank ಅವರು ಎಲ್ಲ ಫಾರ್ಮ್
The claim was repudiated by the respondent number 2.
Annexure
You
D.
should file a consumer case against them, my lord.
Name of the master.
You are representing the insurance company?
No, I am not representing him.
Then why are you submitting? Why are you submitting?
I am sorry.
It's for the insurance company to make that submission. So insurance in Togondo, when was the policy obtained?
Policy at the time of availing the loan itself.
When? Date and?
Date. 31/7/2021.
And when did he die?
He died, my lords, on 3/11/2021. Natural.
31/7.
2021 is the law, on date on which insurance policy was issued.
31/7/2021 is the loan
Yes, on the same date policy. was issued.
policy. He died on
3/11/2021, November.
in 4 months.
And master policy holder is the bank.
What was his age?
His age, my lords, was around 40 years, my lords. A death certificate. And he was having a private, he was a private license holder to do small contracts, my lords. He was the earning person. Now she is the widow who is the before my lords.
Where is your form? Form idea?
Annexure D is the insurance policy.
Where is the form for submission? Have they produced it? Insurance policy ತಗೊಂಡಾಗ form fill ಮಾಡ್ಬೇಕಲ್ಲ?
That
Have you submitted it?
Let's kindly, only one indulgence. 29/7/21, gift deed was given to them for the wife. Gift deed was registered by the deceased in favor of his wife on 29/7/2020. Just 4 days back, five days back before the
availing loan.
availing the loan.
ಏನ್ ತೊಂದ್ರೆ?
I'll not.
ಅಲ್ಲ ಎಲ್ಲ ಪಾಲಿಸಿನೂ ಇವ್ರ ಹತ್ರ annexure
I'm concerned with the, whether there is any suppression made in the policy. If there is
That's
no
a-
suppression,
that-
then
that
if
letter
that
is-
had been cleared, then there would have been no amount due.
That letter is there with, in the annexure, annexed by them itself.
Lokesh, when any loan is taken, as a security, apart from everything that you take,
Yes.
you also nowadays start taking insurance policy
Yes, that is a RBI guideline.
with the insurable interest
ಹೌದು.
of the bank.
ಅವ್ರು ಕೊಟ್ಟರೆ ನಮ್ಗೆ ಅಭ್ಯಂತರ ತಗೊಂತೀವಿ.
ನೀವು
ಫೋರ್ಸ್
ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಇನ್ಶೂರಬಲ್ ಇಂಟ್ರೆಸ್ಟ್ ಅಂತ ಹೇಳಿ ತಗೊಳ್ಳೋವಾಗ ಇನ್ಶೂರೆನ್ಸ್ ಪಾಲಿಸಿ, you know what is applicable and what is not applicable.
Correct.
It is not an insurance policy that they are availed of their own,
Yes.
on their own interest, voluntarily, in their own, for any particular this one. Idralli ee policy alli, you will be the nominee,
You is
you will be the
master policy holder.
The master policy holder, because in case
Annexure
of
D
any
it
death,
says.
that is up to the insurance company which they have repudicated, my lords. They already, as per the letter
Annexure
given by
D.
insurance company.
Master policy holder is Indian Shelter, page 62, my lords. Indian Shelter Finance Corporation is the master policy holder.
That's-
He knows my status.
No.
They fill and send it. No.
I not
Out
feel,
of-
my lords, that's absolutely wrong. Basically, well, I understand your lordship's concern. Basically, what happens, my lordship, some NBFCs have their own insurance companies. Some NBFCs have their own insurance companies. They ಅವ್ರಿಗೆ suggest ಮಾಡ್ತಾರೆ. ನಾವು ಆ ಥರ ಇಲ್ಲ. In fact, he himself has produced one, that policy, that where we have also given them an option, you can opt elsewhere. Third party ಹತ್ರ ನೀವು ತಗೊಬೋದು ಅಂತ ನಾವು ಹೇಳಿದ್ವಿ.
you give option, all those things are fine. If they had gone for that option, then no problem. Then
This
you
case,
can blame them.
in this case, they have gone for that option, my lords. They are taken from elsewhere, not from me. From another third party vendor, which is ICICI. That kindly come to page para 5 of the petition, my lords.
We'll call for all the records, don't worry.
Obliged.
We'll get those records.
Let them comply the condition. Caste kadta lord. That's
5 ಲಕ್ಷ ಕಟ್ತೀವಿ within.
ಅದು ಹೇಳ್ತೀವಿ.
That's, I'm only concerned about the money.
ಅಷ್ಟೇ.
And in
You
fact,
can only be concerned about the money. What else can you be concerned about? You are the bank. ಇವಾಗ ಈ 5 lakhs ಆಮೇಲೆ ಇನ್ನೆಷ್ಟು ಕೊಡ್ತೀರಾ?
My lords, another 3 lakhs, my lord. She is a widow, no source, my lord.
ಇನ್ನೊಂದು 5 lakhs ಮಾಡಿ. 10 lakhs they'll have it. By when will you deposit that?
My lords,
let him directly deposit. Let him withdraw this DD, my lords. Let him directly deposit.
this 5 lakhs, my lords, will be deposited within Tuesday only, my lords. Another 5 lakhs, my lords, your lordship may kindly grant another 3 weeks time.
ಯಾವ ಬ್ಯಾಂಕ್ ಮೇಲೆ ಇರೋದು ಇದು DD?
ಇದು ಇಂಡಿಯನ್ ಶೆಲ್ಟರ್ಸ್
IDBI bank.
ನನ್ನ DD ನ.
ಆಮೇಲೆ NBFC.
ಇವಾಗ ಅಲ್ಲಿ ಹೋದ್ರೆ ಹೈ ವ್ಯಾಲ್ಯೂ we won't give it ಅಂತಾರೆ. ಇವ್ರ ಹತ್ರ ಒಂದು ಇದು ತಗೊಳ್ಬೇಕು.
ಇಲ್ಲ ನಾವು
There is no objection. ಮೊನ್ನೆ ICICI had come before us. 50 lakhs DD 2010. In 2018, they refused to give it because they have pay is no objection ಬೇಕಂತ.
They should surrender that. Let them surrender
ಅಲ್ಲ
it.
ಇದು ಸರೆಂಡರ್ ಮಾಡಿ ಹೊಸ DD ತರ್ತೀನಿ.
Don't say by Tuesday, it may not happen by Tuesday. If we record it, ಆಮೇಲೆ ಮತ್ತೆ violation ಅಂತ ಬರ್ತದೆ.
Next Friday.
Learned counsel for the petitioner submit that though a demand draft for a sum of rupees 5 lakh had been obtained by the petitioner in November, ಯಾವಾಗ ಅದು?
16/12/2022.
On 16/12/2022, in order to comply with the orders passed, an interim order dated 24/11/2022, the same could not be deposited in time. He submits that due to inadvertence, the same was not deposited.
Actually, ನಮ್ಮ ಆಫೀಸ್
The order was there for to deposit with me, my lord. This is for registrar of.
ಬರೆಯಕ್ಕಾಗಲ್ವೇ?
This
ನಾನು
is for
ಬೇರೆ
registrar.
ಹೇಳಬೇಕು.
Lordship may kindly note the fact that this is for registrar of High Court of. The order was to deposit it to me, not for the registrar of High Court. The DD is in favor of the registrar High Court. Basically, my lords, this court in registration, the money is to be paid to me directly. That's what the orders are meant.
Deposit ಅಂತಿದೆ ಅಷ್ಟೇ.
Basically, ಎಲ್ಲ ಬ್ಯಾಂಕಿಗೆ ಕಟ್ತಾರೆ ಸ್ವಾಮಿ. ಎಲ್ಲ ಬ್ಯಾಂಕಿಗೆ
ಅಂತಿಲ್ಲ. That's why we'll change.
We'll deposit in court, my lords, because we are disputing our
earlier-
liability. Because we are disputing our liability, my lords, on the ground
Don't
that-
do this, the interest will continue there.
Let them deposit it to me.
ಈಗ ಅದಕ್ಕೆ ಈ 5
ಇಲ್ಲಿ you'll get 6%. ಅಲ್ಲಿ they'll be charging you 19%.
my lords, your lordship may only make it clear subject to
Subject to the outcome of the
that
petition.
will not take away my right that insurance policy should have.
That we'll see. Learned counsel for the petition submit that you surrender the said demand draft, obtain a fresh demand draft and make payment to the bank.
To the respondent
Given-
number 1.
Respond number 1 bank
I mean,
in a week's time.
I mean NBFC. Bank ಅಂತ
Respond number 1 within a week's time. His further submission is that a further amount of rupees 5 lakhs would be paid within
1 month, 1 month, my lords.
30 days from now. In that view of the matter, the interim order dated 24/11/2022 is extended till next date of hearing. None appears for the respond number 2 today. Respond number 2 is directed to place on record the entire file pertaining to the insurance policy of the husband of the petitioner by next date of hearing. Relist on 21 month, relist on 17th January.
Needless to say that this interim order is subject to payment of this, whatever your lordship.
Needless to say that if the above amounts are not paid by the petitioner, the interim order will stand automatically vacated. The payment of the above amount is without prejudice, is subject to the result of the above writ petition.
Published.
Without prejudice ಅಂತ ಹೇಳಿದ್ರೆ ನಾನು ಆಮೇಲೆ
Without prejudice and subject to result of the above petition.
Published.
can it be further hearing ಅಂತ ಇಟ್ಕೊಂಡ್ರೆ my lords, part
For further hearing of the case.
grateful, my lords.
Further hearing.
Serial number 18, Prasanna.
Lords, for the petitioners, my lords, I pray short accommodation for 2 days, my lords. Kindly have it on Monday. There is an adverse order passed in one of the civil suits initiated by respondent number 4.
The State Commissioner
I will place it on record. my lords.
was challenged before this court, my
Learned
lordship.
counsel for the petitioner seeks and is granted a week's time to make his submission relist on 13th December.
10th or 11th, my lord, too late.
11, 12, 13, 3 ದಿನದಲ್ಲಿ ಯಾವ್ದಾರು
12, my lord.
12th.
11th. I mean, my father's surgery, my lords. 12th is,
13th.
You want, what date do you want?
11th is fine,
11.
much obliged.
19th, P. Sheshagiri Rao.
What's the petitioner before this court not says essentially seeking, not says right of compensation
Yes.
in view of the lands which have been taken away by the authorities. Not the fact and issue not is covered by two trial court judgments, not by holding that the plaintiff is entitled to compensation.
Yes.
If I could just take my lordships to the judgment and decree, my lordship, which is annexed at the statement of objections filed by my learned friend on 9/9/24, annexure R13,
Page
40 minutes.
40.
Yes,
Yes.
minutes at, it starts at 40, at 50 minutes again.
This is a suit filed by Mohammed Gauss.
Please.
Who is Mohammed Gauss? Is your husband and father?
My
Yes.
predecessor, my predecessor.
Yes.
My predecessor. Minutes, the decree is to this effect at 50. It is hereby declared that the plaintiff is entitled to receive compensation for an encroached area for the purpose of formation of public road illegally formed in survey number 41 of Maralur village, and for compensation of 2,900 square feet of community place situated within the prevailing market value of 40 into 150.
Filed a suit for declaration that you are entitled to compensation.
Please, because
Yes. Hmm.
thereafter, now, a writ has been filed, execution is pending, execution, we are not able to enforce it. The current writ, is filed on 2 counts. Since this was an act which took place prior to 2013 and compensation is still not awarded,
And you are objecting to the execution on the ground that the court did not have pecuniary jurisdiction.
There are facts which my friend has not placed before you, Lordship.
Yes, you can place it, please.
Even prior to this decree, there is one more decree in question. That is, at annexure G to the writ petition at running page 95. Here too, similar relief was sought. The mistake was, the schedule, the boundaries were not, the properties were, the extent was not indicated. I'm sorry, annexure G, is the first appeal, but the preceding original suit is at annexure F, running page 60. One minute. The question as to
Page?
it starts at 60. The issues in consideration in the comprehensive suit is found at 68. Here,
68.
68. The issues have been answered in the affirmative, and the operative portion, I'll just point out because the typing is not clear there. 84 minutes, the operative portion is there. So there 2 minutes, the area in dispute minutes at 69 was 40 into 400 square feet, para 14.
The individual at liberty to agitate before the proper forum for the compensation by paying the proper court fee and defend his direct determined quantum of compensation for the encroached area. What is this? What are this suit for?
suit was for declaration, not that I am entitled to receive compensation.
25 rupees court fee. You did not seek for recovery.
It was not quantification irrilla. Quantification irrilla.
What kind of a suit is that and what kind of relief are you asking?
That's kindly see, the suit was on this count. Sorry. Not the suit prayer, not.
What value is this decree for you? Plaintiff is at liberty to agitate before the proper forum for compensation by paying the proper court
Court
fee.
fee, and defendant is directed to determine the compensation for the encroached area. For the purpose of determination of compensation, I don't think there is any court fee payable or there is any as such section 9 jurisdiction CPC applies.
What if further plaintiff is at liberty to agitate before the proper forum andre ಏನು?
Court is it is
court ಅಲ್ಲಿ ಹೆಂಗ್ ಬರುತ್ತೆ?
because the factum that the area has been encroached now. All I am pointing out, the area has been encroached illegally. And I am entitled to compensation is one thing which has been settled in the previous proceedings. That is one suit in OS number 189 of 2002. And the consequent suit what my lordship saw here at 474 of 2005, that is found in the statement of objections, annexure Art 13 there. So the declaration notes that so the declaration notes that there has been an encroachment by the authorities for the purpose of formation of road, not putting up of these KPTCL lines, and for the purpose of taking over these plotting community places is now.
Where is the plan sanction?
The plan sanction is there, at annexure Art 12.
In fact, I have produced annexure R1, page 14 of the objection statement.
Art 12.
Here it is.
Okay. Where is this land?
It's come up subsequent to the same. It's come up subsequent to the same, which led to filing of the suit. The roads were a proposed road was there, which was not formed. Proposed road was there, which was not formed, my lords. And then, they also took over the lands, for the purposes of.
This is the plan sanction.
Yes, my
Where is the land? Subject land there in this plan.
It's the entire layout property.
This entire layout is encroached.
No, the roads have been encroached.
Where is this property?
I may place few facts, the background. That the 2 acre 32 guntas, in survey number 41/1 of Marlur village was owned by Mr. P. Mohammed Gauss.
Yes.
It was converted in 1992. He sought for approval of layout plan in 1993. The layout was approved and he has executed 2 relinquishment deeds for roads and civic amenity sites in the year 1994.
Roads and civic amenities.
Roads and civic amenities.
As part of the plan sanction.
Plan
process.
sanction. Then, in the year 1996, he instituted a suit in OS number 89 of 96, contending that the authorities have encroached upon the road areas which are shown in the layout plan. He sought for
By doing
injunction.
what? By forming a road on the road area.
According to him, the relinquished portion which is used for road is an encroachment, according to him. His contention was the road formed in a layout.
Your encroachment is is by forming a road on a road area.
On a road area. That is the contention.
Yes,
then
it is not so.
Incrementing
the area, what was shown there.
Then
roads have been formed.
That is why we were asking you,
Please,
this plan sanction.
Yes,
Where is this land that you claim to be encroached by them?
formed by us.
Other three events will clinch the issue.
Yes.
Let's see, 1996, he filed a suit. Then, on 17/2/1997, petitioner sought for modification of the layout plan, contending that
the residential yield is very less. Therefore, increase the residential yield for some more extent. The initial plan, for which the plan was sanctioned, it is residential and commercial yield was about 44%. Then after he filed an application seeking for modification of the layout plan to increase the residential and commercial yield. By that time, there was an order of injunction in the suit filed by him. We said, you first withdraw the suit, then we will consider for modification.
Increase 55-45 with
55-45
That is the maximum limit is 50, and it depends upon the designation of land users in the layout plan. Upon consideration of the application for modification, the modified layout plan was sanctioned. By increasing the percentage of residential yield from 43 to 48%. He accepted that plan and he withdrew the suit. He produced the copy of the order sheet saying that I have withdrawn the suit. Thereupon, he has executed the modified relinquishment deed because the original relinquishment deed will have to be modified because of the change in the residential yield. That was, it is all concluded in the year 1997. The plan was, modified layout plan was issued. In the year 2002, after 5 years of the modification of the layout plan, he files a suit before the trial court contending that the Urban Development Authority has encroached upon the area, land belongs to him for formation of road and buffer zone and civic community area. This was the claim sought to be made before the trial court. Unfortunately, the provisions of Karnataka Town and Country Planning Act and Karnataka Urban Development Authorities Act were not brought before the courts below.
Is there no bar for the court to take up that
Decide
section
in
64 and 64, 65?
It was badly conducted, the suit on behalf of the authorities. By looking into the defense taken, the courts proceeded on the assumption that these areas were encroached upon, and the decrees are granted.
By you forming a civic community and a road.
That is not.
Roads and formation of civic community sites and roads are, according to them, is an encroachment. Section 32 says when he has relinquished on his own by executing 3 registered relinquishment deeds, whether
The sites have been sold.
sites have been, he has sold everything. This is a speculative claim which is being kept alive for about 20 long years.
So what happens if we cancel this plan sanction now?
I mean, it could still be, I'll point out, even if your lordships would be.
Anything else?
Let's
I
only.
did.
Let's kindly see minutes. I think the facts.
First, you show us in this plan
Yes, minutes.
where this encroached area is.
Minutes, sir. Factually, minutes, I shall have to verify that portion where they encroach, because minutes, this road, what was formed, was, or proposed to be formed.
Suit ಹಾಕಿದೀರಾ, encroach ಹಾಕಿದ್ರೆ 2,900 square feet.
Correct. ಜಾಸ್ತಿ
ಅದೆಲ್ಲ
ಆಗಿದೆ.
ಹೇಳಿದೀರಾ.
ಜಾಸ್ತಿ ಆಗಿದೆ. Road was not proposed to be.
40 into 400 feet ಅಂತ ಹೇಳಿದೀರಾ.
Correct, minutes.
40 into 400 feet ಎಲ್ಲಿದೆ?
Minutes, sir. It is in the ODP area and minutes, the extended area thereafter. That is what I was informed, minutes. Because of which, minutes, my landed area also became less consequently. There, please, minutes, thus saying, instead, look, we gave you 44%, later on we incremented it to 48%. So you are not entitled to ask it. Minutes, I was entitled to 55. Whatever the layout could give us, minutes, I am entitled to that there. It is not that, minutes, they give me a bargain for that. Minutes,
It is depending on what plan you submit.
minutes, my plan which was submitted, minutes, is at the same thing at 47.
See, you could not submit more for simple reason that you had a high tension wire running.
Yes, minutes.
Is a 220 kVA HT line.
Yes, minutes,
So
yes.
that required a buffer in this whole.
Correct, minutes, correct.
And that whole area you made the road and CA.
Correct, minutes, correct. Now,
In fact, you use that also
In fact,
to the maximum permissible extent.
In the modification, it is
The sides you have made it on the other side.
sites are there on the other side.
Ah.
Sites are there on the other
So
side.
the only,
question which was
only
involved
area
also
that
was-
you could have probably not utilized is that buffer for the high tension wire, which you have not used. Otherwise, you have used everything. Where is the encroachment?
Minutes, I'll just point out. This is why, minutes, I requested. Minutes, these are findings which have crystallized. Minutes, why I'm
You're
pointing.
not concerned about those findings, Mr. Counsel. You
Minutes,
tell us where the
fine.
encroachment is.
Minutes, the encroachment.
First of all, that court did not have jurisdiction.
That court not, in order to decide whether the suit for possession could be, I mean, not, it was not a suit for
You
possession.
are asking for compensation.
We were asking not that declare that there's an encroachment.
And that court only said you agitate
There is
before a
a-
proper forum.
They said there is an encroachment.
And
you
this
go
is not a
agitate.
proper forum. Then go to the proper forum
This is the
to
proper.
find out which forum it is.
To find out which forum. That is exactly what
You
the
won't
court
be
said.
able to find.
So the fact finding is not, there was an
If there is an
encroachment.
encroachment,
Yes,
show us, we'll direct them.
Please, minutes. Please, minutes.
But if you were to contend that the road is encroachment, sorry, it can't be.
I don't think road can be an encroachment per se. But not, if the road not is in an extended area beyond which they had shown or disclosed, not, then it would form an encroachment. That is the line of argument. Or that is the only point I can make out before this honorable court.
We'll ask you for the last time. Show us
ಹೇಳ್ಬಿಟ್ಟು
where the
ಹೇಳ್ತೀನಿ sir.
encroachment is.
ಅದನ್ನ ನಾನು
Nothing more that we can ask you.
ನಾನು ಕೇಳ್ಬಿಟ್ಟು ಹೇಳ್ತೀನಿ, ನನಗೆ 2 ದಿವಸ ಕಾಲಾವಕಾಶ ಕೊಡಿ. ಎಲ್ಲಿದೆ ಅನ್ನೋದು ನಾನು ತಿಳಿಸ್ಬೇಕಾಗತ್ತೆ ನಮ್ಗೆ.
Encroachment ತೋರ್ಸ್ಲೇಬೇಕು.
ಹೇಳ್ಬೇಕಾಗತ್ತೆ,
ಎಲ್ಲಿ ಅಂತ.
ಹೇಳ್ಬೇಕಾಗತ್ತೆ. ಯಾಕೆಂದ್ರೆ in the second suit, not they have pointed out where is the encroachment, there is a boundary for that. In the second suit. First suit only, I am not able to point out the boundary there.
That is coming to the road.
No, that's
40 by 400 feet, existing 40 feet road is the
Because
40
not
feet,
the-
extend ನೋಡಿದ್ರೆ 400 feet ಇದ್ದಂಗಿದೆ. That entire road is the encroachment.
in the second
It's
suit.
a very novel way of doing it.
In
You are
this-
put on notice.
In the second suit, not they have pointed out where the exact extent. 40 feet is the encroachment beyond the road.
You are put on notice. You know what that means.
I will put on. I understand.
After arguing for some time, learned counsel for the petitioner seeks for and is granted a week's time to point out as to where the alleged encroachment made by the second respondent is in the plan sanction produced at annexure R1. Since in none of the suits, there's any, in none of the suits where a decree has been claimed to be passed in favor of the petitioner, the location of the encroachment has been identified. Relist on 11th at 2:30 PM for further
Could
hearing.
this be on 14th, perhaps, if it is?
14 ನೀವೇ
14th
ಬರ್ಬೇಕು.
in the meaning, let's 16th, I'm sorry. 16th, 11th, maybe 16th, Monday.
12th, 13th,
12th or 13th,
13th at 2:30 PM for further hearing.
Please.
Serial number 20. K.S. Bhimaya.
Petitioner in this case, my lord. This case, my lord, the petitioner herein has filed the petition for seeking writ of mandamus against the respondent number 1 to 2, my lord, to initiate insolvency resolution against the Mrs. Carby Stock Broking Limited, that is the respondent number 4 herein, as empowered under Rule 5AI of the Insolvency and Bankruptcy. Within bracket, insolvency and liquidation
Insolvency and bankruptcy
Yes,
rules.
yes, my lord.
How would this court get power under this?
Yes, my lord. My lord, what has happened, my lord,
To approach the NCLT.
the petitioner is a cooperative bank, my lord. And they are invested, that is, they 15 crores of rupees with the.
You know, you might have invested, you might be due,
Yes.
everything.
Yes.
But how would this court get the power to initiate insolvency when there is a specified setup made under the IBC for NCLT, NCLH?
That is what, my lord. That is
Alike.
what I'll come to that point.
Insolvency,
My lord,
liquidation proceeding of service providers and application.
I
by
request to
executive
lordship to-
authority. Rule 5A1.
Oh, can I read, my lord? That is
Hmm.
section 5I1AI, my lord.
Hmm.
Corporate insolvency resolution process of financial service providers. The provisions of the code relating to the corporate insolvency resolution process of the corporate debtor shall mutandis apply to the insolvency resolution process of a financial service provider subject to the following modifications, namely: A, initiation of corporate insolvency resolution process. I, no corporate insolvency resolution process shall be initiated against a financial service provider which has committed a default under section 4, except upon an application made by the appropriate regulator in accordance with Rule 6. So appropriate regulator is the RBI, my lord. So I cannot directly approach the NCLT. The first thing is the RBI as being the regulatory authority.
Under section 4 of the code.
Yes,
Alva?
yes.
What does section 4 say?
But section 7. Section 7, my lord. Section 7 states initiation of corporate insolvency resolution process by financial creditor.
So there's a bar on you approaching the
Yes,
NCLT.
yes, yes.
And it is because they are a service provider, it's
Yes,
only the
yes.
RBI which can do it.
RBI has to initiate.
Have you submitted any representation to the
Yes,
bank?
yes, my lord. At annexure K, my lord, the last annexure, which is at page number 101, my lord, at annexure K. That is on 22/3/2022, my lord.
SFIO has initiated action already.
No, my lord. They have not initiated any action.
Like SFIO.
SFI also they have not.
Note that register of companies serious fraud investigation office.
That has been,
have initiated action
no, that has been, we have
RBI.
deleted from this thing. Wide order dated, my lord, 27/7/2023.
Yes.
You submitted that the respondent number is only a formal party and as the permit us to delete. Accordingly, this honorable court was pleased to permit us to delete this thing. This is only a formal party, whereas the respondent number 2 and 3, plus 1 and 2, my lord, whereas the respondent number 1 is the regulating authority. They have to initiate the process, my lord.
Yes.
Lord, I appear for the RBI. Respondent number 4 is not a regulated entity under the RBI, my
Who
lord.
is the regulator then?
My lord, I'm not aware of that, my lord. But
How is the RBI not aware of?
my lord, it's a
You are
stockbroking
the primary regulator, you are the bank of banks.
banks, but respondent number 4 is not a bank, my lord. It's Karvi Stockbroking Limited.
So who is the regulator?
My lord, may kindly see section 227, my lord, of the IBC. The relief sought over here is to initiate CIRP against the financial service provider, which they say is respondent 4. As per section 227 of the IBC, it provides that notwithstanding anything to the contrary contained in the code or any other law for the time being in
Section?
force, the central government may.
Which section are you referring to? 227.
Section 227, my lord.
Yes. Yes.
It provides that notwithstanding anything to the contrary contained in this code or any other law for the time being in force, the central government may, if it considers necessary, in consultation with the appropriate financial service sector regulators, notify financial service providers or categories of financial service providers for the purpose of their insolvency and liquidation proceedings, which may be conducted under this code in such manner as may be prescribed. Now, my lord, may kindly see Rule 2, my lord. So only those financial service providers who are notified CIRP can be initiated against them as per section 227.
Yes.
My lord, may kindly take rule 2 of the rules, my lord. I've annexed it as annexure R1
Who
to
of which rules?
the insolvency and liquidation proceedings of financial service providers
Yes.
rules. Rule 2 provides for the application of the rules. and says that these rules shall apply to such financial service providers or categories of financial service providers as may be notified by the central government under section 227 from time to time for the purpose of their insolvency and liquidation.
So if your contention is that respondent number 4 is not a financial service provider within the definition of the code and the rules,
And notification issued by the central government, my lord.
and your contention is no notification is issued,
No, there is a notification issued. That is
naming
some-
respondent number 4. Naming respondent number 4
Not, respondent number 4 does not come within the purview of that
does
notification.
not come with the. So you as RBI will take note of your submission that the respondent number 4 does not come under the protection of Rule 5. Therefore, the petitioner would be free to approach the NCLT on its own.
My lord, my submission may be noted
That
that
is
it
what my
does not.
submission, that is their content, sir. Let them file the affidavit before this.
My lord,
We'll record the submission.
Yes.
My submission may be.
Then
recorded-
Mr. Bhima will be free to go to NCLT.
My submission may be recorded that it does not come within the purview of the notification enabling me to initiate proceedings.
So if
The
you are the
notification-
regulator, this respondent number 4 is not in the of subclause A of section 5 will not apply to respondent number 4. Therefore, he does not need to approach you. Only you don't need to take action. He can take direct action under section 7. Simple.
My lord.
You are entitled.
One more thing, my lord. My London friend is appearing for the, as well as respondent number 1. My London friend has taken up that contention and they filed the objection also. Kindly see the objection filed by the same counsel for the respondent number 2. I may be permitted to read their objection at paragraph 4, my lord. It
For
is
respondent number 2.
2. It is submitted that the respondent is not.
Respondent number 2, yeah.
2 objection, yes.
On behalf of respondent number 1, respondent number, yes, respondent number 2,
Paragraph 4, my lord. It is submitted that this respondent is not the appropriate regulator to initiate CIRP against the respondent number 4 under the code and relevant rules insofar as the matter relates to the issuance of commercial papers. As per section 45 capital U of the Reserve Bank of India Act 1934 within bracket RBI Act, commercial papers fall under the definition of money market instruments. Commercial papers are an unsecured money market instrument issued in the form of a promissory note. It is submitted that as per section 45 W, capital W of the RBI Act, the Reserve Bank of India has the power to regulate money market instruments.
That is not their contention.
Yes.
Their contention is that respondent number 4
Yes.
is not a notified financial service provider.
My lord may take page 27 of
In
my.
terms of section 227, which would be relatable to section rule 2.
Yes.
So therefore, they don't have power and ಅಷ್ಟೇ ಹೇಳ್ತಾ ಇರೋದು.
My-
They are not the regulator and ಹೇಳ್ತಾ ಇಲ್ಲ.
My
I'm
lord,
not saying that you are not the regulator, right?
not of money market instruments, I may be the
Not the
regulator, my
regulator.
lord. But.
They had been notified, then you would have exercise powers.
Exactly, my.
Only because they are not notified,
Yes,
you
my lord.
don't have.
The
we recorded
notification is at page.
That since they are not notified, they are free to deal under section 7. Petitioner is before this court seeking for the following following reliefs. The petitioner claims to be a cooperative bank registered under the provision of the Karnataka Cooperative Societies Act 1959, and during the course of business had invested a sum of rupees 15 crores in Messrs. Karvi Stock Broking Limited, respondent number 4 herein, who is stated to be a financial service provider. The amounts not having been repaid by the said Karvi, the petitioner is a creditor of the said Karvi. However, the petitioner being unable to initiate proceedings against the said Karvi under the Insolvency and Bankruptcy Code. The petitioner is before this court contending that in terms of subclause 1 of clause A of Rule 5 of the Insolvency and Bankruptcy Insolvency and Liquidation Proceedings of Financial Service Providers and Application to Adjudicating Authority Rules 2019, it is only the appropriate regulator who can initiate proceedings in terms of Rule 6 thereof. And as such, the above relief of mandamus is sought for directing the RBI, who is the regulator of financial service providers, to initiate appropriate action before the NCLT. Learned counsel for the respondent the respondent number 1 in the present matter is the RBI. Respondent number 2 is the Securities and Reserve Bank of India bracket RBI. Respondent number 2 is the Securities Exchange Board of India bracket SEBI bracket close. Objections have been filed by both the respondents. Respondent number 2 contending that respondent number 2 is not the financial regulator. It is the RBI which is the financial regulator insofar as financial service providers are concerned.
My lord, my humble submission, that is not the contention of SEBI. SEBI's only contention is that money market instruments may be regulated by the RBI. They're not saying RBI is the only regulator of financial service providers. As per the definition of financial service providers under the IBC, it includes SEBI, RBI, IRDA, and other regulators.
Whether it is the commercial paper or not is immaterial for this matter. When we go under these rules, you can regulate commercial papers by RBI. SEBI cannot issue any guidelines, rules, notification, that is fine. But if you are an appropriate regulator, it does not say the regulator, it says appropriate regulator.
Yes.
The appropriate, if both of you are the regulators, insofar as financial service providers are concerned, any of you could be the appropriate regulator for initiating NCLT proceedings.
Indeed, my lord.
If your contention is only limited to this one, we'll deal it that way. The SEBI has filed its statement of objections contending that insofar as commercial papers are concerned, which is the subject matter of the transaction between the petitioner and Karvi, the SEBI is not the financial, not the regulator. It is the RBI which is the regulator insofar as commercial papers are concerned. Respondent number 1, RBI, has filed a statement of objections contending that in terms of Rule 2 of the rules of 2019, the rules would apply only to such financial service providers or categories of financial service providers as may be notified by the central government under Section 227 of the IBC. In terms of Section 227, the IBC, it is contended that the central government is required to notify the financial service providers. The said provision is a non-substantive provision which indicates that notwithstanding anything contained in the code, bracket IBC, or any other law for the time being in force, the central government may, if it considers necessary, in consultation with the appropriate financial sector regulators, notify financial service providers or categories of financial service providers for the purpose of their insolvency and liquidation proceedings. On that basis, it is contended that the respondent number 4 or the category of in which respondent number 4 comes under has not been notified by the central government under Section 227. Therefore, the rules of 2019 would not be applicable to respondent number 4 in terms of Rule 2 of the rules of 2019. And as such, it is submitted that neither SEBI nor RBI, though being a regulator, would be required to initiate insolvency proceedings under Clause 1, would be required to initiate liquidation proceedings under the IBC. The embargo which has been imposed on the petitioner in terms of subclause 1 of Clause A of Rule 5 of the rules of 2019 would not apply insofar as respond number 4 is concerned. Heard so and so, peruse papers. It is not in dispute that respond number 4 is a financial service provider. However, it is also not in dispute that respond number 4 has not been notified under section 227 of the IBC. That being the case, as rightly contended by the learned counsel for the RBI, the rules of 2019 would not apply to respond number 4. Therefore, the embargo created under subclause 1 of subclause A of section rule 5 of the rules of 2019 would also not apply, requiring only the regulator to initiate insolvency proceedings under the IBC.
My lord, that may not be recorded as my submissions, it may be made an order of the court because
It's your submission.
I can only say whether I have any role.
Let them file the affidavit.
You are the big RBI and you are the big SEBI. You have to decide
My
whether you are going to initiate.
Whether I have any role to play, I don't have any role to play.
If both of you don't have the role, they'll go
Yes,
and file it.
let them not prevent me to go.
Is your submission will be on record because Karvi should not take up that contention there saying that you should have initiated.
Yes. Maintainability.
This will preempt that he has to be safeguarded. Either you initiate or they will initiate.
Our hands are tied by the rules and the act, my lord.
We don't know. Tomorrow it can't be that you have not initiated. In that view of the matter, the petitioner would be free to initiate such proceedings before the NCLT as may be available to the petitioner. Since according to both SEBI and RBI, respond number 4 is not a notified financial service provider under section 227 of the IBC.
Notified for either of us, my lord, as regulators.
It is notified. If it is notified, then you're required to.
There may be other regulators, my lord. There may be other financial service regulators.
Is it notified or not notified, madam?
My lord, the only notification that RBI is aware of and SEBI is aware of is what has been produced along with RBI's
You
statement.
will
of
go by
objections.
aware of. Next time you come before us about aware, we'll deal with RBI.
There is no other notification that has been issued, my lord, under the rules.
You are supposed to know it.
There is no other notification, my lord.
That's all. Don't go by aware of. You'll be in trouble in a lot of other matters then.
My lord, in the meanwhile, my lord, with regard to the delay. If
We'll deal with that.
Yes.
Since the petitioner was required to approach this court seeking for the mandamus being under the impression that the embargo under subclause 1 of clause A of rule 5 was applicable and it was only the financial regulator who could initiate proceedings. And a notice had also been issued by the petitioner to the RBI on 22/3/2022.
Yes.
And this stand was not made clear by both respond number 1 and respond number 2 in reply thereto, thereby enabling the petitioner to approach the NCLT under the IBC. I have the considered opinion that the time spent by the petitioner before this court would entitle the petitioner to the benefit of section 14 of the Limitation Act. Reserving such benefit, the petitioner is providing such benefit of section 14. Liberty is reserved to the petitioner to approach the NCLT as in the manner applicable.
One submission. The representation made by the petitioner was not addressed to SEBI. It was only addressed to the RBI.
So respond number 1.
My statement of objection may formally be taken on record, my lord.
It's already on record.
I had filed an application seeking extension of time. There was a peremptory order passed and I had filed an application.
Daily order and statement of objections filed by respond number 1 is taken on record.
Yes.
We have referred to it also.
Further hearing serial number 21. Oh, the hearing for the petitioner, my lord, on the last occasion, my lord had
Yes.
asked for certain
Yeah, my
site
lord.
conditions to be.
Yes, Mr.
verified.
Srinivas.
This is the matter, my lord, where conditions have to be told.
Hmm.
My lord, what has happened, my lord, the total extent of site conditions site was 22 acres, my lord. Admittedly-
Is there
Admittedly, yes,
BMRCL?
admittedly 6
Actually.
acres. No, my lord, may I request, my lord.
I have a meeting on Saturday with the chief engineer, my lord. My request for a week, 2 days time, my lord, after which Monday, I can come into a solution, my lord. May I?
My
Come
lord,
with
solution is
Dragged
demand
for
draft.
years, man. So
Demand draft
2013
with
matter.
interest.
Solution, some solution I will for sure come out, my
If
lord.
you don't come with the demand draft with interest, these officers.
Then my hands are tied, my lord. I will not take time more than that.
My lord may record that, my lord. Otherwise, every time this is getting dragged on, my
Lord,
lord.
what has happened?
It's for further hearing, madam, don't worry.
What has happened, man? 22 acres is what the total extent was. In which, my lord, there was 17 acres, which was 70. The STP plant is come in that 22 acres. We have not changed the total plan at all. The same plan is being modified, my lord.
If the BMRCL has come there and
Allah,
if the metro station
that
or
22
metro rail
acres.
line is there, is a change of condition. People had to sit across and verify where the STP could be
Allah
shifted.
bandide. In that
That you
22
don't do.
acres. No.
There's complete mala fide here. When you ask for extension, when they refuse it, you issue a LOI of your own accord in 3 days' time.
2 days.
2 days' time.
Well, what happens, my lord? The site conditions.
doesn't
are not,
happen like
no,
that.
Site conditions are not changed.
It cannot happen like that. Why did you ask for extension?
And, it
And
was
then when they say
recorded, my
no,
lords.
you LOI you issue
But before
on the last
LOI
day.
But before the LOI, they cancelled this one, my lord. That
This is completely mala fide. You
I'll-
can't protect.
Monday, man. Monday or Tuesday.
You have the demand draft with interest, then fine.
And next,
Otherwise, our hands are tied.
will try my best, my lord, but it is.
Otherwise, our hands are tied.
Yes.
Monday,
Request
my
of
lord.
learned counsel for respond number 1 relist on 10th, ಅದು Monday SCST ಇದೆಲ್ಲ. Released on 10th at 2:30 PM.
Much obliged.
22. K.R. Nair.
Appear for the petitioner, my lords.
Dated 22/12. Who has filed this application for recall? Twenty-two, 12, 2020. Who has filed this? Filed by advocate for petitioner. You have filed application for recall of the order.
My lords, I do not have instructions to argue the matter. The arguing counsel is actually unwell.
ಮತ್ತೆ ಹೇಳ್ಬೇಕಲ್ಲ.
Yes, please. Actually, there's a compliance that needs to be done by the respondent.
A statement of objection by the government advocate.
We have to file, we have to produce by LOC file, my lord. Lookout notice, lookout circular.
ಯಾವ್ದು ಅದ ಇದು? ಏನಾಯ್ತು?
Lookout circular file ಸಿಕ್ಕಿಲ್ಲ. We tame, means we pray.
Adverse inference ಅಷ್ಟೇ.
One more day.
Lord AGA once again seeks for a week's accommodation.
Next week, my lords, please.
To comply with the order dated 25/10/2024. Released on 12th December. It is made clear that if the file is not produced by then, adverse inference would have to be drawn and the matter proceeded with.
Please.
23. Vikram Balaji.
Lakshman? Password?
24. Chandranath Ariga.
Not this CVC report, my lord.
Hmm.
Called them, my lord. Pass over, my lord, they are pass over.
Password.
Final hearing, serial number 25. Vice Chair Shetty.
Preparing for the petitioner in this matter. Lord, this matter is settled. We'll report it by next date of hearing because the KCDC has agreed to receive the amount.
ಎಷ್ಟು ದಿನ ಬೇಕು?
On the 10 days backup.
After vacation or before vacation?
Because he's an officer, ranger.
After vacation or before?
Before vacation.
That counsel for the petition submit that the dispute between the parties has been settled, given 10 days time. They'll report settlement. Relist on 19th December.
Please, man. Obliged.
26.
ಒಂದ್ ನಿಮಿಷ ಇರಿ. Serial number 23, Mr. Lakshman.
But they wanted, my lord, to discuss about the persons who are belong to the various layouts. Everybody is afraid because they have filed FIRs against the petitioner also. In fact, I told them, of course, I can't discuss with them. I told them that nothing will happen, you take the responsibility.
If they take that responsibility and build the STP,
Please, my lord.
we'll take it as a mitigating
cost of-
circumstances and for consideration in those FIRs.
Yes, my lord.
But ಅವ್ರು ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ then it becomes serious.
Yes. ನಾನು ಹೇಳ್ದೆ, ಏನ್ ಸ್ವಾಮಿ ನಾವು ಕೇಸ್ ಹಾಕಿ ನಮ್ಮ ಮೇಲೆ
ನೀವು
ಪರವಾಗಿಲ್ಲ.
layout ಮಾಡಿದ್ರಲ್ಲ ಏನಂತ ಇವಾಗ?
Bloody well, Lordship may grant us 2 weeks' time, definitely I will.
After vacation or before vacation?
Last working day, 17th or 18th.
Shri V. Lakshman, Senior Counsel, seeks for 2 weeks' time to make his submission. Relist on 19th December at 2:30 PM.
But I'll see that something is done, committees,
But then it will help them also. It will help everybody.
not only them, the entire village and public
The criminal
also.
prosecution ನಿಮಗೂ ಯೂಸ್ ಇಲ್ಲ, ಅವ್ರಿಗೂ ಯಾರಿಗೂ ಯೂಸ್ ಇಲ್ಲ.
ಹೌದು. ಈಗ petitioner 2-3 ಅವ್ರ ಆಫೀಸ್ ಬೇರರ್ಸ್ ಇದ್ರು, ಅವರು ರಿಸೈನ್ ಮಾಡಿ ಹೊಟ್ಟೋದು.
ಥ್ಯಾಂಕ್ಲೆಸ್ ಪೋಸ್ಟ್ ಅವೆಲ್ಲ. ಬಿಗಿನಿಂಗ್ ಮಾತ್ರ ಅದು
ಇಲ್ಲ,
ಇರೋದು.
see
ಆಮೇಲೆ
that there is no difference.
Serial number 26.
Here for the petitioner in this case, my lord.
Yes.
On the last date of hearing, your lordship directed the registry of this court to secure,
Oh, this is the
granting
one.
2 more weeks' time to trace the missing file. And further, your lordship also directed the first respondent PF organization to rebuild the
ಯಾರ
records.
ಹತ್ರನೂ ಇಲ್ವಾ ಫೈಲ್ಸ್?
ಅಲ್ಲ, ನಮ್ಮ ಹತ್ರ we are not the custodian, ನಮ್ಮ ಹತ್ರ ಏನಿಲ್ಲ, ಬೇರೆ some
ಯಾರ
papers.
ಹತ್ರ ಫೋಟೋ ಕಾಪೀಸ್ ಇದ್ರೆ
ಅದೆಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ, that we have produced.
Just, that's what I just thought, my lords. ನಮ್ಮಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ಗಳಲ್ಲೆಲ್ಲ ಮಿಸ್ ಆದಾಗ ಮಿಸ್ಸಿಂಗ್ ಫೈಲ್ ಅಂತ ಮಾಡೋದಕ್ಕೆ there is a provision in law.
Yes.
I thought that both of us can sit together and give all the records so that at
Records.
least ನಾವು ಒಂದು ಕಂಪೈಲ್ ಮಾಡಿದೀವಿ. I will give it to my learned friend also. Let him also see. Let him also give his records if he has any. So that the case can go ahead and if.
2011 matter.
Yes, yes, yes.
That's what we
In
wanted.
fact, we have argued this matter on
Like-
coordinate benches.
Administratively, whatever we have to require to do, we'll do that.
Yes, sir. Yes.
ನಮ್ಮ ಹತ್ರ ಇರೋದು xerox copies original.
ಮಾಡ್ತೀವಿ.
Once we start hearing, we'll know
Yes, yes, ma'am. Yes, ma'am.
why this has gone missing.
Yes,
ಗೊತ್ತಾಗತ್ತೆ.
yes, ma'am. Yes, ma'am.
Where it has to be what.
100%, madam.
And
ಎಲ್ಲ ಗೊತ್ತಾಗುತ್ತೆ.
but
In
in
fact, I
whose
have
benefit,
In
in whose
2008
benefit that file has
in
gone missing, ಅಂತನೂ
2018
ಗೊತ್ತಾಗತ್ತೆ.
in 2018 itself, my lord, I have deposited the entire amount what was due.
ಅಲ್ಲ,
Around 66 lakh rupees I have
We
deposited.
have purchased.
About
by
4-5
paying
years,
some
6 years back.
1.9 crores in
You
those
are
days.
appearing for the purchaser.
Purchaser, 1.9 crores. Now PF melons, even assuming for a while, if it is not here, it should be with the PF. If they had given it to the registry, they should have one set of copies. That's where I'm requesting them that in all.
ಅವ್ರು ಹೇಳ್ತಾರೆ, they came and gave the whole original file here, we
Fair
don't
enough. If
maintain
they have
copies
given
ಅಂತ ಇದ್ದಾರೆ ಪ್ರದೀಪ್. Which is surprising again.
Let it be produced before the court, that endorsement with, at least one set of documents will be with them. Let them place it before the court. I'm requesting them, my lords, that it is a case where we have to place everything
That
before
is
the court.
surprising that you are given the entire file without keeping a photocopy of it.
That's,
No government officer does that.
it is impermissible rather. And nor the registry will take it. They will,
The registry will take whatever is given.
ಅಲ್ಲಲ್ಲ, ನಾವು
ಅವರು ಕಾಪಿ
originals-
ಮಾಡದೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳೋದು is not believable.
ಅಲ್ಲ, ಗವರ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದ್ದಾಗ ನಾವು ಏನಾದ್ರು ಕೊಟ್ರೆ ರಿಜಿಸ್ಟ್ರಿಗೆ, ಅವರು ನಿಮ್ ಹತ್ರ ಒಂದು ಕಾಪಿ ತಗೊಂಡಿದ್ದೀರಾ ಅಂತ ಅದಕ್ಕೊಂದು ಇದು ಹಾಕಿ ಕೊಡ್ತಾ ಇದ್ರು, ನಮ್ಗೊಂದು ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಚೀಟಿನೂ ಕೊಡ್ತಾ ಇದ್ರು.
Since the action was conducted in Bangalore, the original file is dealt by Bangalore office itself. Recovery officer was at Bangalore at that point of time.
In fact, we have addressed an RTA application. We have received a reply that all the records have been transmitted to Chikmagalur regional office.
But it is not.
We have got RTA this one. We are ready to produce the
One
RTA
set
reply.
photocopies are ಇರ್ಲೇಬೇಕಲ್ಲ ಪ್ರದೀಪ್.
ಇರುತ್ತೆ ಸರ್, ನೋಡಿ ಸ್ವಲ್ಪ ದಯವಿಟ್ಟು.
They say that it is a bundle of voluminous records were there.
Whatever it may be voluminous, produce the voluminous thing, it's fine.
I will ascertain, my lord, today. Once again.
Matter is being lying around for from 2011.
promptly ascertain.
ಥರ್ಡ್ ಆರ್ ಫೋರ್ತ್ ಗೆ ಫೈನಲಿ ಅಂತ ಒಂದ್ ಕೊಡ್ಬೋದು ಸ್ವಾಮಿ. ಅಷ್ಟೊತ್ತಿಗೆ ನಾವು ರೀಬಿಲ್ಡ್ ಮಾಡಿ ನಮ್ಮ ಹತ್ರ ಇರೋದನ್ನ ನಾವಿಬ್ರು ಸೇರಿ
Weeks time may be, in the meantime, I will also file objections. I'm disabled to file objections in the absence of records. Disabled to file objections to the amendment, the absence of records.
ನಾವು ಹಾಕ್ಬೇಕು, ರಿಜೈಂಡರ್ ಹಾಕ್ಬೇಕು, ಬಟ್ ವಿ ವಿಲ್ ಫೈಲ್ ಇಟ್ ವಿತ್ ಇನ್ ಎ ಡೇ, ನೋ ಪ್ರಾಬ್ಲಮ್.
Lordship may kindly fix a date for final hearing. That day we would like to go ahead with this one, irrespective of the availability of records. Sir.
ನಮ್ಮ ಸೈಟೇಷನ್ಸ್ ಎಲ್ಲ ಇದೆಯಾ? ಇದೆಯಲ್ಲ?
The report of the registrar computers has been submitted. As per the said report, the registrar computers has stated that there are fields available in the High Court Case Information System for entry of all filing which take place in open court, which would be required to be done by the pending branches. And a circular to that effect is recommended to be issued. The Registrar General is directed to look into the same. Insofar as file tracking is concerned, it is stated that barcode mechanism to assign barcode for all files, both judicial and administrative, is being prepared, and a dashboard would be available for each user to find out where exactly the files are moving. So as to fix the responsibility on the concerned official. The said report is taken on record. The Registrar Judicial has submitted a report stating that memos have been issued to the concerned as regard the missing documents, and a search is being made to trace out the same. Released on 17th December.
17th, I have some, 17th to 19th, I have some difficulty, my lords. Could it be on
Six-
3rd?
16 December,
Alla, 6th, on some puja ide.
13 December,
3rd to, 3rd,
3rd illa, year 5th.
one second, Swami, there is a some
Even
small.
Bharat Bekaila, first
13th,
let us get these files. We have
Please, my lord.
started hearing, but those files are required.
Okay, Agbo.
So once the files come, we have to get those files.
Grateful.
I will also,
Sir.
today I will also convey to the.
Released on 17th at 2:30 PM.
Much obliged.
The learned counsel for the EPF, Allah, submit that the auction proceedings were originally conducted by the Mangalore office.
Regional office at Bangalore.
Mangalore Regional Office. And on inquiry, the Mangalore Regional Office does not have any files. The counsel for the petitioner submit that an RTA application having been filed by the petitioner
And information
With-
received?
with the Mangalore Regional Office, the reply to the said RTA application is that the files have been transferred to the
Chikmagalur office. Regional.
Chikmagalur
PF office.
PF office. Again, regional officer, PF.
Other sub-regional office. Because these properties
Chikmagalur
are to check.
sub-regional office. Learned counsel for the EPF seeks for a week's time to obtain instruction, make a submission if the files are available at the Chikmagalur sub-regional office. Photocopies of the files are available at the Chikmagalur sub-regional office. And to produce whatever files are available in relation to the subject matter by the next date of hearing. Released on 17th at 2:30 PM.
Much obliged.
My presence taken.
For further hearing. But
27.
impleading application,
Last time itself order has been made.
I 1 of 17
Yeah, has to be heard along with the main matter.
along with the main. Okay.
He has nothing to do with it, wants to assert some right which
Anyway,
independently.
he is not here. You can address. Yes.
Let's,
AG is appearing. So Yavaga,
18th, 19th.
could it come, let's,
after vacation only. And
could it come on next Thursday?
any urgency?
No, it's going, hanging, coming time and again.
We have
2000,
not started hearing this matter. Whatever we have started, we'll try and complete.
tentatively, Lords may call it on 12th, subject to their getting ready.
Bada idave. Further hearings idave.
I don't know who is appearing because they keep changing. Okay.
Then the AG submit, AGA submit that the additional advocate general would be appearing in the matter. He seeks for a short accommodation. Released on 9th January.
Could you Lords tentatively have it, Lords, if there is some difficulty, then it can always.
Unnecessary listing, we don't want. Every listing, 13 people have to work. Mr. Naik. Unnecessary, we don't want. If it's not going to be taken up, why waste other people's time?
Lords may have it instead
First
of
week,
9th.
second week,
No, the next day, not on 9th, 10th or
10th,
whatever date. my lords.
10th of
Lords.
January.
28. M.R. Vijay Kumar.
Mr. Vijay Kumar.
Notification. Respondent undertake to file some notification. I don't know what notification.
ನೀವು ಹೇಳಿದ್ದು
ನಾನಿಲ್ಲ, ನಾನೇನ್ ಫೈಲ್ ಇಸ್
he secured the file is not able to secure the notification.
ನಾನು ಸೆಕ್ಯೂರ್ ಫೈಲ್ ಮಾಡಕ್ಕೆ ನನ್ನ ಹತ್ರ
ಅವರೇ
ದೇ ಹ್ಯಾವ್
petitioner ಅಲ್ಲ.
ರಾಂಗ್ಲಿ ಪ್ರಿಂಟೆಡ್ ಆಸ್ ಪಿಟಿಷನರ್.
Petitioner ಅಲ್ಲ. Notification, ಏನ್ notification ಇದು? What is the notification to be produced?
ನಾವು ಫೈಲ್ ಸೆಕ್ಯೂರ್ ಮಾಡ್ಕೊಂಡಿದೀವಿ, ಒಂದು ನೋಟಿಫಿಕೇಶನ್ ಇಲ್ಲ, ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀವಿ ಅಂತ ಅಂದ್ರು.
ಏನ್ notification?
ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಏನ್ ನೋಟಿಫಿಕೇಶನ್.
ನಿಮಗೂ ಗೊತ್ತಿಲ್ಲ? ನಿಮಗೂ ಗೊತ್ತಾ?
Not in this case, I think.
Not in this case. Some other case which has been.
ಇದ್ರಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟಿದೆ.
There is ಯಾವ notification ಬೇಡವಾ?
We have already filed everything, my lordship.
ಮತ್ತೆ argument ಮಾಡಿ ಅಷ್ಟೇ.
It is already argued for some time. My lord may have it on Tuesday, my lord. And ಏನೋ notification ಕೊಡ್ತಾರೆ ಅನ್ಕೊಂಡು
Not in this case, it was.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಆಗಿದೆ ರೆಕಾರ್ಡ್ ಆಗಿದೆ. petitioner also.
Both the councils submit that there is no notification which is required to be produced in the matter. Given a short accommodation, they'll address arguments. Relist on 11th.
Great.
29, Srinivas Babu.
For 2 more weeks to file statement of objections, my lord.
But question is, my lord, whether reservation for one education, same caste, and one employment. Employment group D, for education group B.
You already argued.
I will
You
file
filed
my
amendment.
objections,
It-
my lord.
it- it
Two
not-
more
amendment
weeks.
is
You not
fine, my lord.
filed the amendment and this one also.
Yes, my lord. Vasant Kumar case is covered.
Non-amendment, non-filing ಅಂತ ಹೇಳಿದೀರಾ?
ಹಾಕಿದೆ.
Amendment ಮಾಡಿದೀರಾ? ಮಾಡಿದಾರಾ?
Already filed, but copy is also given. ಅಲ್ವಾ?
A copy
Put
to
it.
the amendment
Yes. Put it one copy.
Not done. Amendment is not done.
has to be carried out.
Rectangle, you have to do it.
Amended petition ಹಾಕಿದಾರಾ?
Amended petition
Petition is
ಹಾಕಿದ್ದಾರೆ,
filed.
ಹಾಕಿದ್ದಾರೆ.
Amended petition has been filed.
You have to amend it in writing.
ಅದೂನು ಹಾಕಿಲ್ಲ.
ಇದೆ ಒಂದು extra
ಬೆಳಿಗ್ಗೆ
copy.
file ಆಯ್ತು.
ಇವಾಗ ಕೊಟ್ರೆ?
ಅಲ್ಲ
ಅದು
ಹಾಕಿದ್ದಾರೆ
ಕೊಡ್ರಿ.
ಬೆಳಿಗ್ಗೆ file.
ಅವ್ರಿಗೆ ಕೊಟ್ಟಾಗಿ ಅಲ್ವಾ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ.
Copy sir,
Copy, sir.
ಒಂದು ಬೆಳಿಗ್ಗೆ file ಆಯ್ತು.
You are the one delaying it. ಆಮೇಲೆ ನೀವು ಅವ್ರ ಮೇಲೆ ಗಲಾಟೆ ಮಾಡ್ತಾ ಇದ್ದೀರಿ. Counsel for the petitioner submit that given a week's time will carry out the amendment and the amended petition has been filed today. Learned AGA seeks for and is granted 2 weeks' time
Please, my lord.
to file his objections to the amended petition.
Petition.
Objections, if any, by 10th January, released on 16th January.
Please, my lord.
30,
ಎಂಟ್ರಿ ಮಾಡಬೇಕು.
Interim order earlier granted is extended till next date. We'll come back. ಕೊಡಿ.
The lordships were pleased to fix a matter on 6th. I was under the impression it is 6/1, but I am told it is tomorrow 6/12.
ಯಾವ್ದು 6th?
Islamic mission ಇದು.
ಹಾ.
ನಾಳೆಗೇನೆ ಪೋಸ್ಟ್ ಆಗಿದೆ. ನಾಳೆ ನಾನು 2:30ಗೆ some.
Already fix ಆಗಿ ನಾಳೆ ಹೇಳಿದ್ರೆ we'll adjourn it.
Please.
Please,
sir,
We
30th
don't know which matter it is, depending on who says what.
I'm sorry, your lordship. 30th matter, let it be on Monday.
ನಾಳೆ ಇದ್ರೆ ಆಯ್ತು.
Serial number 33, my lord. 30th matter, let it be on Monday, your lordship.
Who is appearing for the respondent?
On Wednesday, lordships, next Wednesday, I'm ready.
30,
Next
Lordship.
Wednesday, lordship.
2013. Released on 11th.
33, my lord.
Permission,
serial number 6,
Lord.
lord.
In for it to the 1 week time because the issue in this involved in this case, already the suit has been filed. OS number 3 of 23, that before the Tribunal in Mysore, Lord. I have to get that client copy because the issue is just.
The respondent is saying he has no objection to allow your petition. ನಿಮ್ ಪಕ್ಕದಲ್ಲೇ ನಿಂತಿದ್ದಾರೆ.
ಹೇಳಿದ್ದು ಬೆಳಿಗ್ಗೆ.
ಹಾ.
That's why I could not be able to. Next week any date, Lord, because already before the Tribunal a suit is filed, Lord. I will place it before the sample.
At the request of counsel for the petitioner, released on 11th.
33, my lord.
33. Yes.
After the vacation,
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀರಾ?
and I'll inform.
ವಿಲ್ ಬೇಡ, ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀರಾ? ವಿಲ್ ಮಾಡಕ್ ಬಿಡಲ್ಲ. Yes.
Week ಆದ್ರೆ I am ready.
32,
your lordship can have Wednesday or Thursday.
32.
I'm sorry, 31, your lordship. Wednesday or Thursday.
ಶುರು
33
ಆಗಿದೆ
ಇಲ್ಲ.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಇಲ್ಲ?
ಆಗಿಲ್ಲ.
ಶುರು ಆಗ್ಬೇಕು.
33 ಇಲ್ಲೇ ಇದ್ದಾರೆ ಸರ್.
31 at the request of counsel for the petitioner, released on 9th January.
33, Lokaयुಕ್ತ council is here.
33 at the request of counsel for the petitioner, released on 10th January.
35, my lord. 35 for the petitioner.
Serial number 40, my lordship. My lordship, Bipin Hegde, your lordship has directed to take notice for
KSFC.
KSFC, my lordship. The copy is not served upon me. And
That is not something that you can mention now when called out.
yeah, please.
35, I am for the
52.
petitioner.
Hmm.
Any other day.
At the request of counsel for the petitioner, released on 10th January.
My lord,
32 million.
Huh.
I informed other side.
At the request of counsel for the petitioner, 10th January.
52, my lord. 52.
52.
52 appearing for petitioner.
Respondent, my
Yes.
less time for senior.
At the request of counsel for the petitioner, 10th January.
Kindly show the name of S.A. Sudhindra. My senior is as a designated senior counsel.
52, registry director print the name of Shri S. A. Sudhindra and delete the name as that appearing for the petitioner and delete the name of Shri S. N. Ashwatthayana as that appearing for the petitioner. And at the request of petitioner, request of respond number 1.
Interim order may be extended.
Interim order earlier granted is extended.
ಆ ಮೆಮೊ ಅವ್ರ ಹತ್ರನೇ ಕೊಟ್ಬಿಟ್ರ? ಕೊಡಲಿ, ಕೊಟ್ಟಿದ್ರೆ ಮಾತ್ರ ಡೇಟ್ ಅಷ್ಟೇ. ಪಾರ್ಟಿ ಕೇಳಿದ್ರು ಕೊಡ್ಲಿಲ್ಲ ಅಷ್ಟೇ. ಸರಿ, ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಆ ಮ್ಯಾಟ್ರ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ, ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಯಾವ್ದಾದ್ರು ಫೈಲ್ ಬೇಕು ಅಂತಂದ್ರೆ ಎಲ್ಲ ಬಂಡಲ್ ವೈಸ್ ಇಷ್ಟು ಇದೆ. ಬಂಡ್ಲು ಯಾವ ಬಂಡಲ್ ಅದಾದ್ರು ಬೇಕು ಅಂದ್ರೆ ಅಕಸ್ಮಾತ್ ತೆಕ್ಕೊಡ್ತಾರೆ. ಗಮನ ಅಲ್ಲಿ. ಹಾ 9th ಮಂಡೇ. ಫೋನ್ ತಗೊಳಲ್ಲ ಅಂತ ಆಮೇಲೆ ಹೊಟ್ಟೆ ನಮ್ಗೆ ಇರೋ ಟೈಮಲ್ಲೇ ಮುಗಿಸ್ಕೋಬೇಕು. ಆಮೇಲೆ 2:20 ಬರ್ತೀನಿ, ಎಲ್ಲ ಮುಗಿಸ್ಕೊಂಡಿರ್ತಾರೆ. ನಿಮ್ಮಂದು ಬರ್ತಾರೆ ಎಲ್ರು. 23 ಆಗೋಯ್ತು. ಅದೇ ಲಕ್ಷ್ಮೀನಾರಾಯಣ ಅಂತ ಕೇಳಿದ್ರು. ಬಂದ್ಬಿಟ್ರಲ್ಲ ಲಕ್ಕೆ ತಗೊಳ್ಳಿ ಅಂತ. ಹೌದು. ಅಲ್ಲಿ ಏನಾದ್ರು ಹೇಳಿದ್ರು ನಮ್ಗೆ ನೆನ್ನೆ ಅದೇನಾಯ್ತು, ನಾನ್ ನೆನ್ನೆ ಲಿಸ್ಟ್ ತಗೊಂಡು ಹೇಳ್ಕೊಂಡಿದ್ರೆ ಊಟ ಮಾಡೋದೇ. ಈ ನಡುವೆ ಫೋನ್ ಅಟೆಂಡ್ ಮಾಡೋದೇ ಬಿಟ್ಟಿದ್ದೀನಿ. ಬೈಕೊಂಡ್ರು ಪರವಾಗಿಲ್ಲ.
What of sir?
ವರ್ಷವ್ರನ್ನ ಮಧುರಿ ಅಂತ ಮಾಯ ಈತಮ್ಮ
List 230 matters. Dharwad, Kalburgi ಆಮೇಲೆ second list. Sir? One. ಕಲಬುರ್ಗಿ ಜಾಸ್ತಿ ಇದೆ. ಟೈಮ್ ತಗೊಳುತ್ತೆ. ಫಸ್ಟ್ ಧಾರವಾಡ, ಆಮೇಲೆ ಕಲಬುರ್ಗಿ, ಆಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್. DB 445 ಇನ್ನೂ ಬಂದಿಲ್ಲ.
ಗುಡ್ ಆಫ್ ಸರ್, ಧಾರವಾಡ ಎಷ್ಟಿದೆ?
ಸೆಕೆಂಡ್ ಲಿಸ್ಟಾ ಫಸ್ಟ್ ಲಿಸ್ಟಾ? ಫಸ್ಟ್ ಲಿಸ್ಟಾ ಲಾಸ್ಟ್. ಸರ್ ಹೇಳಿ ಸರ್.
ಧಾರವಾಡ ಎಷ್ಟಿದೆ ಮೇಡಮ್? ಫಸ್ಟ್ ಧಾರವಾಡ ಕರಿತೀರಾ?
ಫಸ್ಟ್ ಧಾರವಾಡ ಬನ್ನಿ.
ಹೌದು ಮೇಡಮ್, AG ಆಫೀಸ್ ಇಂದ ಇದಾರೆ ಯಾರು? ಅವರೇ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೇಕು.
ಏನ್ ಹೆಸರು ಸರ್ ಅದು? ಅವರು ಇರೋರು
ಧಾರವಾಡದ ಎಷ್ಟಿದೆ ಮೇಡಮ್?
ಒಂದೇ ಒಂದು.
ಓಕೆ ಮೇಡಮ್.
ಬಂಡಲ್ ವೈಸ್ ಇಟ್ಟಿರ್ಬೇಕು. ಯಾವ್ದು ಬಂಡಲ್ ನಂಬರ್. ಕೊಡಿ ನಾಗರಾಜ್. Harvard bench matter. Santosh RB.
May I please,
Yes, Mr. Raut.
my lord, this is review petition against the wherein the additional document by way of partition was produced and prepared the SLP of the Honorable Supreme Court. When this ground was ours, they have reserved us the liberty to file the review petition.
Where is that order?
My lord, it is at review petition order is at page number
Drawn
31.
with liberty to file review. What is the ground for review?
My lord, ground for review is the document which sought to be produced was in the form of earlier partition which we have pleaded in our plaint, my lord. Actually, Vinit Sharma, my lord, even the oral partition is permissible and same was acted upon by all the family members, my lord.
Yes, we'll have to hear you. Who is appearing for the respondent?
We are appearing for the response. We are here.
You are ready for argument, Mr. Patil?
My lord, this may be taken in next month, my lord, January, that can be heard here.
Yes. At the request of counsel for the respondent, released on 16 January at 2:30 PM.
Obliged.
Kalburgi bench matters. Serial number 1. Sanjay Kumar C. Patil on connected matters.
Yes, madam.
Lords, in this case, AHA was supposed to appear in these matters regarding. Malhar Rao is.
Mr. Rao? Mallar Rao.
Lord, it could be passed over, my lord. I will communicate him. It appears, my lord, he's not online.
Pass over. Pass over.
List number 2. Order serial number 1. Vijay Kumar R.
The other one has come. End of the list matter banta. Where's Ms. Sudev? Pass over. Pass over.
Serial number 2. B.M. Halaswamy.
My lord, for petitioner, my lord. We have paid the subsisting allowance, my lord. We have paid the subsisting allowance, my lord. Yes.
Mr. Divyatesh. Give it.
Digvijay.
The counsel for the petitioner submit that the subsistence allowance has been paid as directed by order dated 14/11/2024. None appears for the respond number 6 today. Baki ella neevena?
Also,
Released on 7th January.
my lord, extension of interim order.
Interim order earlier granted is extended till next date.
Serial number 3. Pradeep Kumar.
For petition.
Notes may kindly recollect, this had
Yes.
come on 2nd. Notes I directed my friend to inform the court under what authority the minister has directed this.
Yes, madam.
Sorry, sir. Kindly see annexure A, my lord.
Aneksha?
A.
Yes.
A and B same, no? That is 5/11.
Yes.
5/11/24. ದಿನಾಂಕ 2/9/24ರಂದು ನರ್ಸಿಂಗ್ ಕಾಲೇಜುಗಳ ಪರಿಶೀಲನಾ ಸಭೆಯಲ್ಲಿ ಮಾನ್ಯ ವೈದ್ಯಕೀಯ ಶಿಕ್ಷಣ ಸಚಿವರು ನರ್ಸಿಂಗ್ ಕಾಲೇಜುಗಳ ಗುಣಮಟ್ಟ ಹಾಗೂ ಮೂಲಭೂತ ಸೌಕರ್ಯಗಳ ಲಭ್ಯತೆಯ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಲು ಭಾರತೀಯ ಶುಶ್ರೂಷಾ ಪರಿಷತ್ತು ನಿಯಮಗಳನುಸಾರ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಶುಶ್ರೂಷಾ ಪರಿಷತ್ತಿನ ಮಾನ್ಯತೆಯನ್ನು
Nursing council.
ನೋಂದಾಯಿಸಿಕೊಂಡಿರುವ ರಾಜ್ಯ ಎಲ್ಲಾ ನರ್ಸಿಂಗ್ ಶಾಲೆ ಕಾಲೇಜುಗಳ ತಪಾಸಣೆ ಕಾರ್ಯಗಳನ್ನು ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಮೂಲಕ ಕೈಗೊಳ್ಳಲು ಸೂಚಿಸಿರುತ್ತಾರೆ. ತಪಾಸಣೆ ಅಗತ್ಯವಿರುವ ಜಿಲ್ಲಾವಾರು ವಿಷಯದ ಪರಿಣಿತರ ನರ್ಸಿಂಗ್ ಸಬ್ಜೆಕ್ಟ್ ಎಕ್ಸ್ಪರ್ಟ್ ಪಟ್ಟಿ, ಜಿಲ್ಲಾವಾರು ನರ್ಸಿಂಗ್ ಕಾಲೇಜುಗಳು ಶಾಲೆಗಳು ಕಾಲೇಜುಗಳ ಪಟ್ಟಿ, ILC ಮಾರ್ಗಸೂಚಿಗಳು ಮತ್ತು ಈ ಹಿಂದೆ ಮಾನ್ಯ ಉಚ್ಚನ ಮೊರೆ ಹೋಗಿದ್ದ ಹೊಸ ಶುಶ್ರೂಷಾ ಶಾಲೆಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ನಡೆಸಲಾಗಿರುವ ಪರಿಶೀಲನೆಯ ನಮೂನೆಯನ್ನು ಪ್ರತಿಯನ್ನು ದೊರಕುತ್ತದೆ. ಬೇರ್ಪಟ್ಟ ವಿಷಯ ಸಂಬಂಧಿಸಿ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಶುಶ್ರೂಷಾ ಪರಿಷತ್ ನೋಂದಾಯಿಸಿರುವ ಇದುವರೆಗೆ ಲಭಿಸಿರುವ ಪಟ್ಟಿಯಲ್ಲಿ ಜಿಲ್ಲೆಯಲ್ಲಿರುವ ನರ್ಸಿಂಗ್ ಶಾಲೆ ಕಾಲೇಜುಗಳು ಭಾರತೀಯ ಶುಶ್ರೂಷಾ ಪರಿಷತ್ತಿನ ನಿಯಮಾನುಸಾರ ಗುಣಮಟ್ಟ ಹಾಗೂ ಮೂಲಭೂತ ಸೌಕರ್ಯಗಳನ್ನು ಲಭ್ಯತೆಯ ಬಗ್ಗೆ ತಪಾಸಣೆ ನಡೆಸಿ 1 ತಿಂಗಳು ವರದಿ ಸಲ್ಲಿಸುವ. That is based on the complaint received by the students as well as the public, that they does not have the infrastructure and they are not running in the same place where they have taken the permission, my lord. So based on that, the policy decision has been taken to that is special force has been initiated, madam, to inquire and with that special special team.
Under what provision of law? Shurudra's client can go under section 13. They can inspect. The university can do it
45,
under the disaffiliation 40.
section 45.
47.
Affiliation 48,
47.
47.
Within a month, they want some,
Good.
with regard to all these aspects.
You can request INC to do it. If you have the complaints, you can forward it to INC. INC will do it, or
No,
the
no.
university will do it.
How to, that is different. For the renewal, they will do it, Mela. For the purpose of, Indian complaint. Okay, a complaint received, by the public, my lord, they are specially, special force.
The complaints you can forward to INC. The authorities who are required to administer and govern this are the INC and the university. See, tomorrow another officer, if he says something, because complaint has been received, it has to go to the concerned agency.
No, we will file statement of objection, my lord. The question is statutory provisions when
India
available.
Karnataka
serial number
Nursing,
10.
Karnataka Nursing Council.
Karnataka or India, state.
When statutory powers are available already, then whether executive powers exercising will overrule or not is the question before this
You're
honorable court.
supporting the petitioner or you're supporting the government?
No, I am supporting government, my lord.
did.
Executive power, minister power is executive power under the constitution.
Yes, but that has to be as per the statute.
Just
Constitution is very.
that can be
very-
clarified within 15 days, my lord. We will clarify, my lord.
Then don't do any inspection till then.
No, my lord.
Adunu agala, idu agala and raga.
We are not.
My lord, just for.
You show us a power that is vested with you to do a particular thing, we will be the first one to support you. This would be required. No doubt that it would be required if complaints are received. But whatever has to be done in that particular manner. We can't have that one complaint is received. We don't want to say anything more.
Several complaints have been received.
Forward all of it to Mr. Hand it over to Mr. Shivrudra.
Every year.
He is duty bound. Hello, Mr. Shivrudra. You ask them to do in 30 days, they will do it in 30 days and give it to you. They cannot escape
No, my lord, the
inspection, but
infrastructure,
it has
the
to be done by-
infrastructure they have got means they need not to worry at all.
They'll,
We have a different story to tell. It's been happening since 2020, whenever a new government or a new minister comes. This is the process they initiate. Way back in 21, this honorable court held that extra statutory authorities like high-powered committee, which they had constituted, is impermissible in law. Thereafter, lords, there was some demand in the assembly, so they constituted a committee of the legislators that was subject to litigation here. This court, my lord, said you can go and inspect for purpose of your study to legislate in future and nothing more. That, my lords, is pending in the Supreme Court and state. This is, my lords, there are statutory provisions under which they have power, but they want to have this through the DC so that the executive authorities directions could be, my lords, pushed through the process,
give it
which
to
is
Mr.
only
Shivrudra
without.
and you can give it to the university. KNC ಅಲ್ಲಿ ಏನಿದೆ? Where are your rules?
My lord,
Yeah.
my lord, I will come back. my
KNC
lord.
rules.
Let's rule
ANC
13.
under section 23 and 24, my lord, training institutions are there. Training institutions na inspect ಮಾಡೋದಕ್ಕೆ they have got the full powers under the act.
So training institution ಅವರು ಕೊಡಿ, colleges ಇವರು ಕೊಡಿ. ಎರಡು ಯೂನಿವರ್ಸಿಟಿ ಕೊಡಿ. In a time bound manner, they will do it. ನೀವು ಏನೇನ್ ಮಾಡಿದ್ರು ಅದಕ್ಕೆ ವೆಬ್ಸೈಟ್ ಮೇಲೆ ಹಾಕಿ ಅಂತ ಹೇಳ್ತಾರೆ ಅದಕ್ಕೆ. The details of everything of each college, those items that you tick mark,
Please.
There are
should be
600
available on the website. If anything is wrong on the website, anything on the website is not found in the college, action can be taken. You do that 30 items,
My lord, kindly see these proceedings, my lord.
Insolvency Act.
The last paragraph. Third page, last one.
Yes.
ವಿಶೇಷಾಧಿಕಾರಿಗಳು ಕರ್ನಾಟಕ ರಾಜ್ಯ ಸುಶ್ರುತ ಪರೀಕ್ಷಾ ಮಂಡಳಿ ಇವರ ವಿಳಾಸ ಬದಲಾವಣೆ ಕುರಿತು ಕೆಲವು ಖಾಸಗಿ ಸಂಸ್ಥೆಯ ವಿದ್ಯಾರ್ಥಿಗಳ ಹಿತದೃಷ್ಟಿಯಿಂದ ಕೋರಿರುವುದರಿಂದ ಪ್ರತಿ 5 ವರ್ಷಗಳಿಗೊಮ್ಮೆ ಸುಶ್ರುತ ಶಾಲೆಗಳ ತಪಾಸಣಾ ಮಾಡಲು ಕ್ರಮ ವಹಿಸಿಕೊಳ್ಳುವ ಬಗ್ಗೆ ಸಭೆಯಲ್ಲಿ ಮಂಡಿಸಿದರು. ಮಾನ್ಯ ಸಚಿವರು ಉತ್ತಮ ಗುಣಮಟ್ಟದ ಶಿಕ್ಷಣ ನೀಡಬೇಕಾಗಿರುವುದು ಆಯಾಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಮಟ್ಟದಲ್ಲಿ ತಪಾಸಣೆ ನಡೆಸಲು ಕ್ರಮ ವಹಿಸಿರುವ ಕುರಿತು ಸರ್ಕಾರದಿಂದ ಸುತ್ತೋಲೆ ಹೊರಡಿಸಿರುವಂತೆ ಸಂಬಂಧಪಟ್ಟ ಅಧಿಕಾರಿಗಳಿಗೆ ಸೂಚಿಸಿದರು ಹಾಗೂ ಇಲಾಖೆಗಳಿಂದ ಜಿಲ್ಲಾವಾರು ವಿಳಾಸದೊಂದಿಗೆ ಸುಶ್ರುತ ಶಾಲೆಗಳ ಮಾಹಿತಿ ಪಡೆದು ಕ್ರಮ ವಹಿಸಲು ಜಿಲ್ಲಾಧಿಕಾರಿಗಳಿಗೆ ಪತ್ರ ಬರೆಯಲು ಸೂಚಿಸಿದರು.
The intent is good. The purpose is also good. But the authority we will have to do is INC, RGUHS and KNC. You give it to them, they will do it. As we said, they are duty bound to listen to you. You will direct them to web post all these details on their website. All the items that they inspect, number of teachers, number of professors, number of whatever infrastructure is required, everything will be web hosted on INC's website.
That is there, my lord.
No, INC Albarala, sorry. That will have to come under university's website.
They will do it at the time of renewal. Every year they have to do the inspection, my lord. This is for the purpose of complaint and the.
Where does it say it's only at the time of renewal? It's not restricted.
That is the purpose we are, this is 636 BSc colleges there and 834 DNM colleges are all over
See,
state.
if your request is for yearly inspection,
No, we need it for, that is the purpose we are deputed the DC to conduct all the.
if you want to see that whatever they've done, within a month ಅವ್ರು ಮಾಡ್ತಾರೆ. ಅದು ಬೇರೆ. month ಅಲ್ಲಿ ಮಾಡ್ತಾರೆ ಅವ್ರು ಹೇಳ್ತಾರೆ. But whatever it is, if you want to do it on a yearly basis, INC will undertake to do it.
All right.
This impute notification will have 2 items. That is Gunamatta and Moolabhuta Saukarya. These are the 2 items. Basic amenity and not the
Infrastructure.
Which is not a condition requisite for granting of approval, renewal of approval.
Yes.
In fact, that is being carried out by the concerned.
What the state is saying is that it is only done at the renewal, and renewal happens once in how many years?
Every year.
Every year. Every year.
My lord, but that is the purpose. Now we are special task force has initiated. Whether
You give us a list of items that are to be checked. We'll make it a part of the order. We'll direct the INC and the
No,
RGUHS to
they
check.
don't have any such list, my lords. It's all for the purpose of enabling the minister to call the deputy commissioner. If they had, then they could have mentioned it in this only.
We'll now make it, if that is the thing. If the intention is good, you will also
No,
have to.
we
you-
have.
It'll be transparent for you
What
also.
we are trying to point out is that this, my lords, is something which is outside the statutory provisions provided for by the state government under enactments.
That
This-
we agree with you, Mr. Naik.
This being, my lord, something outside that, they must do in accordance with law. That's all that we are seeking. We have no objection for the competent authority to inspect in terms of section 47 of the RGHS Act, in terms of section 13 of the INC Act. They are free to do it.
23 of the
But
KNC.
then minister can't decide on a sudden one day saying that I will order through the DC. I don't understand what.
Always ask
what
INC,
expertise
KNC and
the
RGHS.
DC would have.
Whatever items you want to be checked, to make a list. Until then, don't do anything.
Yes.
We'll make it an order. INC will do it within a particular time frame. What INC has to check, you can make a list. What KNC has to do, you can make a list.
Yeah.
What RGHS can do. you have to
All
make a
these
list.
check what all things to be done, Lord, it is only one arena, one umbrella. That all the three can join together and just check it once. That can be done also, because the infrastructure which is prescribed by the apex body is one and the same, which is being followed by the ANC as well as the university.
Which is the authority see, there are three authorities who can do this.
Please, no.
13, 23 and 47. Each of them have to do it.
Here also the expert body is doing the inspection and not through DC.
He is not an authorized person, he is not an authorized officer. Has to be done as per law. The intent is fine. We presume the intent subject. They have a different contention on that, but we'll assume everything to be bona fide.
If there are complaints, my lord, or only humble request, my lord, if there are complaints, my lord, I am not saying not, the institutions may not confirm, may not, if there are complaints, my lord, the minimum courtesy is issue of the Tokas notice. Say this is what is wrong. My lord,
And
without
forward
even
it to the
asking-
concerned authorities.
This is an inspection, not Tokas notice is not necessary.
No, if there is a complaint, my learned friend says there are complaints.
Under which provision you are authorized to. You are authorized to, under any provision, you show it to us. Otherwise, it will be the only authorized person who has to do it. You give us all the things that you want to be verified. As we said, bona fide is intent, we are not doubting. We'll direct the concerned authority to do it. And to say whenever they receive anything from you, you can forward it to them.
Kindly have it on Monday. my lord.
Sure.
Monday.
Lord AGA.
May request, Lord, Monday, Lord, I will not be in town, Lord. Tuesday or Wednesday, Lord. I request on the other day also.
It's Tuesday, na?
Please.
Thursdays, my lord. Next week, just
No,
1 week, my lord.
Let them
Because it's-
file
You
their
can record. You only to do it, ashte.
To assist her only. my lord.
ಮಾಡಿ.
Let them file their statement of objection. Till then, let them not take any precipitative action.
Statement of objection would not be necessary. Why waste time on that?
Or at least let them apply their mind and come back with some proper assistance to the court, my lords, to take it. forward.
1 and, 3 and 10 connect to each other.
Now since my lords are
Sorry,
there,
3 alli, no? Who are the authorities? Only state, 10 alli, 10 ಕೊಡಿ. Notice ಆಗಿದೆ ಅಲ್ಲ? So in 3, only the state is a party. In 10, all the others are parties. So 10 would take care of 3 also. 3 and 10 connect to each other. The submission of the learned senior counsels, Sri Madhusudan Naik and Sri M.S. Shamsundar, is that the respondent, that a minister would not have any authority under the INC or the KNC to direct inspection of the colleges. They coming under the purview of the INC stroke KNC and being affiliated with the Rajiv Gandhi University of Health Sciences. The submission of the learned AGA is that the state having received several objections, several complaints, it is in the interest of the students and the parents who have complained that the inspection has been ordered, since the allegations relate to both the infrastructure availability and the standards which are maintained in the nursing school, nursing colleges, ಆಮೇಲೆ ಎರಡೆಲ್ಲ nursing schools and nursing colleges. Institution ಯಾವ್ದದು?
ಅಲ್ಲ ಅದೇ ಬರುತ್ತೆ. ಒಂದು GNM ಕೋರ್ಸ್ ಒಂದು
ಸ್ಕೂಲ್ ಇವ್ರ ಕೆಳಗೆ ಬರುತ್ತೆ, ಕಾಲೇಜ್ ಇವ್ರ ಕೆಳಗೆ ಬರುತ್ತೆ. ಇಬ್ರೂನು ಅವ್ರ ಕೆಳಗೆ ಇದ್ದಾರೆ. ಇನ್ನೇನಾದ್ರು ಇನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಸಪರೇಟ್ ಇದೆ?
ಇಲ್ಲ, ಇಲ್ಲ, ಇಲ್ಲ. Institutions ಎರಡು ಬರುತ್ತವೆ. Schools and colleges both.
Stroke nursing institutions. There being no particular power which is available under the INC or the KNC Act so and so. Empowering the executive to direct inspection, the further proceedings in pursuance of the order at Annexure
B to my writ petition.
A and B, A in WP number 32106 of 2024 and Annexure
B in my petition.
B
Is already
in WP number 32185 of 2024 is stayed till the next date of hearing. It is always available for the state to forward the complaints received by the state to the INC stroke KNC stroke RGUHS to take necessary action. And the INC stroke KNC stroke RGUHS would be duty bound to act on the request made by the state while enclosing the complaints. Now, AGA seeks for and is granted a week's time to place on record the complaints, the details of the complaints received and the scope of inspection required to be made to address the grievance of the concerned students stroke parents. Relist on 11th or 12th? 11th at 2:30 p.m.
It's incidentally, I may point out, under section 45 of the RGHS Act, it is after the prior approval of the state government, which examines all these inspections and grants approval.
Mr. Naik, the problem that we are also seeing,
No.
and you also know what is happening is,
No, the reason
when the
why-
permission is taken, everything is there.
No, no, no.
At the renewal time, everything is there. In between, some of the things go missing.
No, after the approval, approval took place 2 months back. Suddenly there can be a awakening by the government, seek to revise what approval it has given. Therefore, my lords, the exercise of power which is being now initiated apparently is for some other purpose, not for the purpose of
Fair enough. That is why we have restrained.
lordship.
But the INC and all these
Yeah, they are
authorities would have to
duty-bound.
maintain a website with all the details. So that everybody knows how many beds are there, how many doctors are there, how many professors are there, how many.
Transparency.
Occupancy strength of the hospitals, not only the bed strength, the occupancy strength would should have been there.
What is the authorization for number of beds on MCI's website?
Transparency.
KPMC Act take care of that.
I'm
Everything
sure
you
lords,
upload.
The government will also prima facie place some complaints for your lordship's perusal.
The name
So-
of the parent hospital, relationship with the parent hospital, the trustee of here being the trustee there. All of it you will have to verbose there.
That we should-
Address is available on the website. If someone wants to complain, they can complain it online.
The first person they will find is the state, and it will be the Ministry of Health or Education.
Yes.
They are, INC doesn't have a big office in Bangalore where they can go. So it will be the health minister or the education minister to whom they go. They have their own issues. They are their constituents. They will have to take care of it. But through the correct process. ಏನೇನ್ ಬೇಕು ಇವೆಲ್ಲ ಲಿಸ್ಟ್ ಮಾಡಿ. 30 ಐಟಮ್ ಇದೆಯೋ 50 ಐಟಮ್ ಇದೆಯೋ 100 ಐಟಮ್ ಇದೆಯೋ ಲಿಸ್ಟ್ ಮಾಡಿ.
List all ಅದು ಬರುತ್ತೆ. Pollution Control Board has to certify the number of bed strength. Accordingly, the Pollution Control Board will give the permission based on the disposal of the medical waste in the hospital. Now, the bed strength and the occupancy of the bed strength in the hospital has to be given to the INC. All these things are there, not the technical
We
things.
already told you, Mr. Rudra, the application that is filed by the college should be online. The documents that are to be uploaded have to be online, so that Pollution Control Board permission is there online.
ಅದೆಲ್ಲ ಕೊಡ್ಲೇಬೇಕು ಅವರು.
ಕೊಡ್ಲೇಬೇಕು, but ಇವಾಗ ನೀವು
Before the government grants the permission, all these things have to be submitted to the Rajiv Gandhi University of Health Sciences.
ಇವಾಗ ನೀವೆಲ್ಲ ಫಿಸಿಕಲ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ, ಆ ಫೈಲ್ ಎಲ್ಲೋ ಇರುತ್ತೆ.
Except RERA, my lord, the e-governance.
Online, ಈಗ ಆನ್ಲೈನ್ ಆಗ್ತಾ ಇದೆ that they will check online itself. University will check online.
ಅಪ್ಲಿಕೇಶನ್ ಆನ್ಲೈನ್ ಇರಬೇಕು, ಅವ್ರ ಎಂಟೈರ್ ಅಪ್ಲಿಕೇಶನ್ ವಿತ್ ಆಲ್ ದಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆನ್ಲೈನ್ ಇರಬೇಕು. ನಿಮ್ಮ ಪ್ರೋಸೆಸ್ ಆಫ್ ವೆರಿಫಿಕೇಶನ್ ಆನ್ಲೈನ್ ಇರಬೇಕು. The cross checking should be there so that
Verification ಆನ್ಲೈನ್ ಮಾಡಬಹುದು. ಫಿಸಿಕಲ್ ಆಗಿ ನೋಡ್ಲೇಬೇಕಾಗ್ತದೆ.
ನೋಡ್ಬೇಕು, ಅದ್ ನೋಡ್ಬಿಟ್ಟು ಫೋಟೋಗ್ರಾಫ್ಸ್ ತಗೊಂಡು ಹಾಕಿ ಅಲ್ಲಿ. ನಿಮ್ಮ LIC ಅಲ್ಲಿ ಫೋಟೋಗ್ರಾಫ್ಸ್ ಇರಲ್ಲ.
ಇರುತ್ತೆ. They have to take photographs. They have to
ಬಂದಿರೋದ್ರಲ್ಲಿ ಎಷ್ಟೋದ್ರಲ್ಲಿ ಇಲ್ಲ, ನಿಮ್ಗೂ ಗೊತ್ತು.
ಅವ್ರು ತಮ್ಮ ಮುಂದೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರಲ್ಲ ಅಷ್ಟೇ. It has to be produced.
ನೀವೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋ.
Tag the location. Be very precise. Google
Everything
location,
could be
they
there.
tag the device, they tag the location as well. The hospital, campus or.
ಟ್ರ್ಯಾಕಿಂಗ್
institute.
ಲೊಕೇಶನ್ ಎಲ್ಲ ಇದೆಲ್ಲ ಗೂಗಲ್ ಮ್ಯಾಪ್ ಅಲ್ಲಿ ಎಲ್ಲಿದೆ ಲೊಕೇಶನ್ ಕೂಡ ಅದನ್ನ ಟ್ರ್ಯಾಕ್ ಮಾಡೇ.
ನಾವು ಎಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್ಸ್ ವೆಬ್ ಹೋಸ್ಟ್ ಆಗುತ್ತೆ, ಎಲ್ಲ ಜಜ್ಮೆಂಟ್ಸ್ ವೆಬ್ ಹೋಸ್ಟ್ ಆಗುತ್ತೆ, ಡೇಟ್ಸ್ ಬರುತ್ತೆ. ಲೈಕ್ ದಟ್ ಯು ಶುಡ್ ಹ್ಯಾವ್ ಎ ಸಿಸ್ಟಮ್.
We'll do it.
So that if it is there, everybody is this one is available. And if any one thing, if that parent hospital goes for 3 colleges, is immediately known.
That is how the other matters are before my lords and lord.
ಹೆಸರು ಹಾಕಿದ್ರೆ ಗೊತ್ತಾಗತ್ತೆ.
ಹೌದು, ಅದನ್ನ ಹಾಕಿದ್ದಕ್ಕೆ ಇದು ಬಂದಿರೋದು. That's what people are there before my lords on the other cases like.
ಅದೆಲ್ಲ ಆದ್ರೆ
My lord requires separate judgment at the hands of your lord.
ಅದು ನೀವು ಎಲ್ಲ ಲಿಸ್ಟ್ ಮಾಡಿಕೊಡಿ.
In this very case, my lords may kindly issue them some direction so that the e-governance is put in act. But my lord, we are all alerted. Otherwise, it has taken for a surprise like this.
Advocate General is here, so you can make the request directly.
General conveys that my lord, I have not prepared.
He hasn't heard you as it.
Now, there's the other side of the picture. Milords, if they apply all these parameters, all the government institutions will get closed. That's the main problem with the government.
It will apply to everybody.
If your lords have noticed, all this inspection is by the faculty of the government colleges, but they are not being scrutinized by anyone.
Government colleges are not.
No. No, that's the way things happen.
On that side, especially.
You know it.
On that side, my lord, especially. But one thing was, only with regard to nursing college, it's a different ballgame.
Very fair, my lord.
See, and nurses from India are in demand all across the world.
Throughout the world.
And
If a Karnataka is a large number of nursing colleges are there.
but there are a lot of complaints also of the nurses trained here. So that is also there. We're not saying we can take judicial notice on that. There are a lot of.
What is sufficient infrastructure, we are not against. Any support from our end, only question is, they have sufficient infrastructure. If they're able to show that they have infrastructure.
ಅದನ್ನೇ ಎಲ್ಲ ವೆಬ್ ಹೋಸ್ಟ್ ಮಾಡಿಸಿ. When the inspection is done, everything is available as to what is there.
Mr. Naik was not there in one matter. I appeared in 5 months, 5 inspection. I mean, the judge was not convinced saying that because the judge has seen that building while going on the road that name. He saying this can't be.
Kalburgi.
Impossible that your inspection is right.
We also saw that building.
It's impossible.
That matter had come up before us. So
I mean, this not being an illustration.
that is why get the photographs, Krishna ಹೇಳಿದಂಗೆ geotagging, ಎಲ್ಲ ಅಲ್ಲಿದ್ರೆ photographs ಇರಬೇಕು.
The faculty brought the Indian has introduced NRPS system, wherever the nurse, whoever works there, whoever works as a teacher or a staff nurse, that has to be uploaded in the INC portal, so that if they are shifting also, it will come to know by the INC telling that yes, they are not here, they are not there. So the complete faculty is being uploaded.
Unfortunately, what has happened is all these details are in different locations. You will not know what another institution is maintaining. So one single place where all this data is available can be cross-checked. That could probably be the university for the state of Karnataka, where the whatever you give should also go on the university, because students will check up the university website.
Then the students list also should be uploaded the INC website. That's the rule.
Everything.
Like MCA, what the same thing is done here
Point
also.
of law, where Mr. Naik saying where law is very clear. The facts is where the whole, in each, you have to go by each of the.
ಅದಕ್ಕೆ ಸುಮ್ಮನೆ ಆ ಬೇಸಿಸ್ ಮೇಲೆ ಡಿಸ್ಪೋಸ್ ಆಗಿ ಮಾಡೋ ಬದಲು, if you give us the whole list, we can direct them to, as Ms. Shamsundar said, that we can direct the concern to implement a e-governance system.
Suggest to it, like, yeah, 5 doctors from overall nursing also going and like, I think we should come up with someone. Yeah, honestly.
No, their legislators have already studied to amend the law. Let them have it amended and then authorize themselves, not the minister calling the colleges saying, I'm going to have an inspection, you do this, that. That's not the way the governance should happen.
Last occasion also, the legislators committee was formed to inspect these schools. And by the way, the government changed and it stopped them.
No, it's right by the Supreme Court.
High-powered committee.
As the lordship suggested, we should be transparent, or the college institution itself should put their staff.
That also will, once you give us the list, we'll direct that to be listed, web hosted by each of the institution, but a central repository of the university would be a better one. All those items that you list should be uploaded on each college's website.
Yeah.
That will have to be there. And this teacher and professor business of being part-time here, part-time there, and being nowhere is also a big issue. We understand the issues, but we need to come up with a nice solution within the legal framework.
Suggest something from what the institution can.
No, we have our own headaches. We don't want to assist the government. Government has enough bright brains with the government. They can take advice from my learned friend, the Advocate General.
The Advocate General, as Mr. Shetty, has more experience. So if you make that list, relist on 11th at 2:30 PM for further hearing. Yes.
Under 145 matter where Kamal had referred to Justice A.V. Chandrasekhar to mediate, you know, and almost it is settled. We are drawing up the settlement memo is also ready. If your lordship may suggest, if I may suggest, the same Justice A.V. Chandrasekhar may be appointed or have it on some other day to settle these also. Only the amount of money and interest in each of the cases, we are filing a compromise petition in each one of the cases. Once we go there, we'll come back before your lordships and file the memo of settlement.
Your lordships, I'm sorry, my camera is not on. I'm appearing for Karnataka Niravari Nigam, Lalit Mohini Bhatt, your lordship. So I think if it's the same as Mr.
Yes,
Shetty.
It's the same matter.
Sir, as far as my clients are concerned, we are not agreeable for any mediation, sir.
You are not agreeable when the state is agreeable. That is rather telling.
So as far as the Nigam is concerned, being a completely independent identity, my instructions are to this effect that mediation is not in the wing for us in this.
I think this
is funding. Don't give them any money.
Maybe your lordship, in this case, your lordship may kindly give some time. Maybe we will have a discussions again and then see that both of us are aligned.
I don't know, because last time I thought this is what was.
This is what I got the
Have it
instructions.
next week, Manoj, we'll just.
Yes.
Because.
It's rather telling when the state is saying, Advocate General is making the submission, the KNL is making the submission.
Yeah, your lordship, I may be given some time. Let me just let us clarify this whole situation, because the recent instructions were this, as far as Nigam is concerned.
You made the submission in the open court. Everybody has heard it, madam.
Yes, yes, I'm aware of the submissions that I'm making. I'm making it with the instructions I received from my client, your lordships.
Your arrow is not only out of the quiver, but out of the bow also. We are little
I'm sorry to say that.
difficult to go back on that.
Uh.
That only indicates something else.
Your lordship, please
Which is what we
kindly
have
give us
observed in
time.
this matter. Then it is clear, all that allegations are clear.
Your lordship may kindly give us time. We will sit
We
with
don't
the
want to even do
AG.
that.
Understand. Your Lordship, we can have it next week, my lord. We'll just
Shall we
talk.
record your submission? And
Your Lordship, just have it on 10th or 11th, not 9th. This
Uh,
other matter, my lord.
Your lordship, maybe after 11th, if it is convenient, your lordship.
yes. Yes, Mr. Sudarshan, you were saying something?
Please, my lord, a similar set of matter, my lord. Before the division bench, my lord, has come up and my lord, almost arguments concluded by both my lord advocates on record. 9th is a my lord date for my lord hearing. So after that, my lord, any convenient date for these matters, my lord, we will be humbled, my lord, deeply
What is
humbled.
pending before the division?
Well, the similar matter, when the question of law, whether KNN is not made a party, my lord,
Yes,
we'll
ma'am. Yes,
award past whether it is binding. My lord. On question of law, my lord, that is clear. The
That is
question-
that is
that's a
going for the
different issue.
MFA.
That is a.
in a writ appeal only, my lord.
That's a legal position, my lord, that then, which we have sought to argue. Pending that, my lord, this is what has transpired. Lordship may consider any date, 11th or 12th, my lord.
The request for Learned Advocate General relist on 12th at 2:30 p.m.
Published.
Please, your lordship. Please, your lordship.
Number 2, serial number 4.
Preparing for the petition in this matter.
Yes.
Please, the petitioner is the employee of the fifth respondent, which is please,
Yes.
the petitioner is the employee of the fifth respondent. Under the fifth respondent, she was appointed on 29/10/2007. She is working from last 16 years. After 14 years working, she became a secretary of the institute, the Cooperative Society. She took charge on 22/4/2021. Later on, the society, they have old structure building. They are planning to construct a new building. For that, their totally construction value of 35 lakhs. Out of the 35 lakh, the NABARD granted 28 lakhs and rated 28 lakh. Out of the remaining 7 lakhs, you should be using profits of the cooperative fifth respondent this thing, not for the any deposit or amount or whatever it. So after releasing the amount, the 7/7/2021, the NABARD granted amount through the Asan Cooperative Bank, Asan District Cooperative Society to sanction the amount. In between, the Mysore issued a circular in 24/1/2024 imposing some conditions not to utilize the amount for the shareholders. Deposit not to utilize, only for profits of the cooperative society. The society, the fourth respondent was president of society, entered the construction agreement on 27/7/2021. The total construction value 65 lakhs. Instead of 35 lakhs, already Mysore Cooperative Society was instructed, not behind that. So we are complaining there is a circular issuing by them, issuing the so many condition. Out of the one condition, only within the 35 lakhs matra use madbeku, not behind that. So for that, petitioner is objection for that. You are entering the 65 lakhs, so saying that only 35 lakhs use madbeku. And for that, they did not consider the petitioner objection. Then
they entered the construction document on 27/7/2021. They started the construction April 20, they started. And the amount was not released, only for 35 lakhs, 27 lakhs, 28 lakhs and 7 lakhs only you should be using. So when the petitioner is raising the objection,
Please mute yourself. Mr. Shivkumar.
These are all the matter of facts that has to be decided by the AR, my lords.
That's what I'll come there only. On 27/4/2022, they stopped the construction on midway. He took the amount 26 lakhs. Remaining balance using the profits of the cooperative society, they construction the building. After completion of the building, the fourth respondent, he himself lent the rent without any authorization.
Are you challenging the KAT?
ಇದರಲ್ಲಿ ಅದೇ ಅದೇ ಬರ್ತಾ ಇದ್ದೀನಿ.
Revision no dismiss ಆಗಿದೆ.
ಹೌದು ಸ್ವಾಮಿ, ಅದರಲ್ಲೇ ಬರ್ತಾ ಇದ್ದೀನಿ ಸ್ವಾಮಿ. ಯಾಕೆ ಅವ್ರು ನನಗೆ
application in the revision petition has been dismissed.
Before that,
That order has been passed long ago.
ಹೌದು ಸ್ವಾಮಿ.
Kindly see, my lord.
8/12/2023, they make a resolution. Board, the fifth respondent make a resolution, stating that I'm depromoting. When I CEO, secretary ಇಂದ ಮತ್ತೆ ನೀವು ಗುಮಸ್ನಾಗಿ ಹೋಗಿ ಅಂತ ಹೇಳಿ they'll pass an order. That is exhibit PC. Kindly ಅದನ್ನೇ ನಾನು ಈಗ ಸ್ಟೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಸ್ವಾಮಿ.
You can't continue as secretary now, pending all these things. If that stay is granted, a stay grant ಅಂದ್ರೆ secretary ಕಂಟಿನ್ಯೂ ಮಾಡ್ಬೇಕು ಅಂತ ನೀವು.
ಹೌದು ಸ್ವಾಮಿ.
ಅದು ಹೆಂಗೆ?
ಅಲ್ಲ ನಾನು ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿ they themselves took
this will have to be
resolution before the
order ಸಿಗಕ್ಕಾಗಲ್ಲ ನಿಮಗೆ.
Lordship, my lord, pass an order, my lord. Kindly see annexure Q, my lord. Annexure Q, my lord. Page number 100. Page number 102, my lord. 101, my lord.
102.
Please. Same prayer, my lord. Now, same prayer has been sought, my lord. My lordship have view that the consideration of the prayer.
Another writ petition on the same cause.
Also, ಅದರಲ್ಲಿ Your Honor is said that you go to KAT ಇಲ್ಲಿ ಮಾಡ್ಕೊಂಬನ್ನಿ ಅಂತ. Went to KAT, I'll raise the dispute under section 70. For there, after hearing the matter, he said that dismiss the application. So therefore, once again I came before this honorable saying that, so kindly we stay as and to permit me to read.
Can't stay. That we can't stay. You can't continue in that post when there are allegations made against.
Allegation without enquiry, it would conduct the enquiry without issuing any show cause
KAT
notice.
seized of the matter. It's only interlocutory application.
Please now.
So let the KAT decide the matter.
Interlocutory application.
You already observed that KAT is to decide. Already order ಆಗಿದೆ.
Interlocutory application.
ಇನ್ನೊಂದು petition ತಗೊಂಡ್ ಬಂದ್ರೆ.
ನಾನು interlocutory application I challenge before the KAT, where they saying that the authority, honorable authority saying that this order is not executable. So again, I prepare the appeal before this writ petition before this honorable court. Your Honor is directed to that. You go to the KAT. Then again, I'll go to KAT before the KAT. I'll file the application and saying that kindly be still conduct the my inquiry.
You can't continue as a secretary.
Till continue. ನಾನು enquiry ಆಗೋವರೆಗೂ at least I'll be in the post ಅಂತ ಹೇಳಿ ಅಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿದೆ. That also got.
ನೀವು ಆಗಲ್ರಿ ಪೋಸ್ಟ್ ಅಲ್ಲಿ ಇರಕ್ಕೆ ನೀವೆಲ್ಲ ಮಾಡಿರೋ ಕಿತಾಪತಿಗೆ.
ನಾನು ಏನು ಮಾಡಿಲ್ಲ ಸರ್. Without issuing.
Last time we did not observe in the order ಅಷ್ಟೇ. We left it open to be decided. ಇವಾಗ ಹೊಸ ಕೌನ್ಸಿಲ್ ಬಂದ್ಬಿಟ್ಟು ಇನ್ನೂ ಒಂದು ಸೇಮ್
ನಮ್ಮ ಸೀನಿಯರ್ ಅವರು ಔಟ್ ಆಫ್ ಅಬ್ರಾಡ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ, ಅದಕ್ಕೋಸ್ಕರ ನಾನು
ಬೇರೆಯವ್ರು ಬಂದಿದ್ರು ನಾವು ಹೇಳಿದ್ವಿ ಅವ್ರಿಗೆ ಅಬ್ಸರ್ವ್ ಮಾಡಲ್ಲ ಹೋಗ್ಬಿಟ್ಟು ಎಲ್ಲ ವಿ ಆರ್ ಲಿವಿಂಗ್ ಇಟ್ ಓಪನ್ ಅಂತ. ಇವಾಗ ಮತ್ತೆ ಅದೇ ತಗೊಂಡ್ ಬಂದ್ರೆ ನೀವು ಇವಾಗ ಅಬ್ಸರ್ವ್ ಮಾಡಿದ್ರೆ ಮತ್ತೆ ಪ್ರಾಬ್ಲಮ್ ಆಗತ್ತೆ ನಿಮ್ಗೆ.
ಅಲ್ಲ ನನಗೆ ಕಂಟಿನ್ಯೂ ಯಾಕೆ ನಾನು ವೈ ಐ ಆಮ್ ಆಸ್ಕಿಂಗ್ ಟು ಕಂಟಿನ್ಯೂ ದಟ್ ವಿತೌಟ್ ಗಾಟ್ ಎನ್ಕ್ವೈರಿ.
That will be decided by the KAT.
Until that at least.
And AGA accepts notice for respond number 1 to 3. Notice to respond number 4 is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following reliefs. Once earlier, a writ petition had been filed by the petitioner in WP number 30490 of 2024, seeking for the following reliefs. And the same came to be disposed by this court on 14 November 2024, relegating the petitioner to the tribunal before whom the matter is pending,
At least decide
leaving
of that
open
matter.
all the questions to be agitated before the tribunal. Rather shockingly, the petitioner is once again before this court claiming the very same reliefs.
Until that decide agavaragu at least one interim order plays on. Otherwise, I'll have
The-
very much.
No, now we'll have to observe on your conduct of filing this. The present writ petition having been filed for the very same relief, even after the same having been rejected by this court, is clearly mala fide. In that view of the matter, the above petition is dismissed by imposing cost of rupees 10,000 payable to the Advocates Clerks Benevolent Fund, the amount to be paid within 15 days from today. If not so paid, the said amount shall be recoverable as arrears of land revenue. Benevolent Fund bada KSLSA madi. They will recover.
The Caste better some please.
You can't file these kind of matters.
Lords, may I make a submission?
Yes, madam.
The Kalburgi bench matters, my lord, serial number 5 has not been called.
Where is 5?
Oh, serial number 5.
ಎಲ್ಲ KNNL ಅನ್ಕೊಂಡ್ವಿ.
Appearing for petitioner, Worship. Serial number 5.
ಒಂದು ನಿಮಿಷ.
Appearing for the respondent.
4 ಇದೆ. 4 KNNL ಅಲ್ಲ. 4 ಕರಿ.
4 where Malad Shukmar Malipatil is waiting. He is also on.
Kalburgi bench matter, serial number 4.
Yes, Mr. Malipatil.
I have filed affidavit giving clarification about clause 313A. In addition to this affidavit filed by the KRC, my lord. No, I have made it clear that the buildings constructed by the respondent 2 to 5 consists of 3 floors each. Thereby total built up area is more than 500 square meters, including staircase area and balcony. Therefore, consumer response shall have to pay. So, as per the 9th amendment of KRC recovery of expenditure regulations, they have to provide space for installing transformer by the licensee.
So 500 square meters ಮೇಲೆ 25 kilowatt ಗೆ ನಿಮ್ಗೆ ಟ್ರಾನ್ಸ್ಫಾರ್ಮರ್ ಜಾಗ ಕೊಡಬೇಕು.
Only 2/3 ones free. Only. Leave it. That is the 9th amendment. KRC is we are bound by it, man.
Heard, reserved.
Yes, my lord, in this case.
Yes.
My lord, in this case already the KERC officer has clearly submitted before this honorable court on last date of hearing. It is mentioned in the order sheet, my lord. The land has no also pro rate charges to be borne by the consumer, etc. There is no mandatory requirement for providing a transfer merely because the construction is more than 500 square meter. He has clearly submitted before this honorable court, and honorable court mentioned in order sheet. In that regard, your lordship has asked it to file affidavit, joint affidavit. But instead of that, my lord, they have filed affidavit with regard to the what provision is there.
We'll deal with it.
Please, please.
Reserved.
Please.
Number 5.
Serial number 5, my lord, appearing for the respondent.
Appearing for
Yeah,
petitioner.
request, my lord.
My lord, say in this case, my
27,
lord,
2024 order, my lord. The petitioner
All
has
the
sent the
reports have been
SRs.
filed.
My lordship, you have not received any report, my lordship, still now. KSLSA report has been not received still yet. I think they have filed in the Kalburgi bench itself, my lordship.
Yes, madam.
lords, in this case, the BO of Authorized has forwarded the SR of the teachers to BO of Bidar, where they are now have taken the service, my lords, and in short period, they'll be given their salary.
That
after
undertaking
joining.
may be recorded, my lord.
In CL number 5.
Yes, my lord. 202-151 of 2024, my lord.
And SCGP submit that insofar as respond number 6 to 13 are concerned, the SR has been received by the BO Aurad.
BO from the management, and he has
From the
forwarded to
management.
the either.
And the same has been forwarded to
The concerned BO where they are now, they have joined the service.
the BO having jurisdiction over the location where respond number 6 to 13 have joined service. And the same will be actioned as salaries paid to them as and when due. Our submission is placed on record. So these reports have come now.
Reports.
Ashwardhan? Have all of you received the reports?
The copy is to be served.
You are in the first petition. You haven't received.
Petitioner, we have not received the report, my lordship.
Ashwardhan is not here. Learned counsel for the petitioner in WP number 202151 of 24 submit that he has not received copies of the reports.
Yes, my lordship.
The petitioner would not be entitled to the entire report, but would be entitled to the report pertaining to the petitioner institution.
Much obliged, my lordship.
The learned counsel for respond number 4 to 9 in WP 202663 of 2023 is directed to furnish the report pertaining to the concerned institution to the respective petitioners. Released on 16th January.
Kindly extend the interim order.
Interim order earlier granted is extended till next day.
Much obliged, my lordship.
Yes? Where are they?
List number 2, serial number 5.
Preparing for petitioner, my lord.
Yes, Mr. Thin.
My lord, what has happened, my lord, in this? One letter came to be, some ex-person, my lord, files a complaint stating that my institution is not in the exact location wherein the permission was issued. Based on the said letter, my lord, Karnataka State Diploma Board, my lord, Examination Board, issues a direction, not to me, my lord, but to the person. They send an endorsement to the person who filed a complaint. That is at page number 19, my lord, annexure C, stating that all activities have been stopped insofar as the institution is concerned on the software. Now, my lord, my problem is that, my lord, third year students' examinations is on 11th, my lord. And I have not been served this endorsement or this letter until this date, my lord. When I went there and I have given physical representations, my lord, they showed this document, and that is how I have this document available with me.
Who is N. Raju?
I have no idea, my lord. In fact, at page number 41, my lord, what this Raju does, my lord, he calls up and demands 1.5 lakh rupees to settle the complaint also. To that effect, I file a complaint. And that also nothing has happened. But, my lord, my only submission is, my lord, let them inspect, my lord. And if my building is not there, then very well, my lord, whatever action is initiated stands valid, my lord. But they have never inspected my property. And to the effect of the documents that I have submitted, my lord, wherein permissions are granted, I have submitted the encumbrance certificate, tax paid receipt, and all of it.
The location. Once you geotag the location, this won't happen. And AGA accepts notice for respond number 1. Respond number 2, Yaro? Yogesh Naik accepts notice for respond number 2.
Examination is on 11th.
Board. Sudarshan. Sudarshan, you know? Yes, Sudarshan is directed to accept notice for respond number 2. The respond number 2 is directed to open the students registration portal and grant access to the petitioner institution to upload the names of the students and other details insofar as the examination commencing from 11/12/2024 is concerned. Respond number 1 is directed to carry out an inspection of the college of the petitioner to ascertain the location and produce a report with geotagged location thereof. The above interim order shall not confer any equity on the students and will be subject to the result of the above petition. Released on 9th January.
One submission, my lord.
In the meanwhile, office objections to be complied with.
Yes, my lord, one submission, my lord.
Yes.
In accordance with the location where I'm at the moment, my institution is there, my lord, is the location wherein permissions are issued in annexure A, my
They've
lord.
got all the records. They'll know where to.
Yes. All right. Much obliged.
ಇದೆಲ್ಲ ಹೇಳೋದ್ ಬೇಕಾಗಿಲ್ಲ ಅವ್ರಿಗೆ.
Much obliged. Thank you. Much obliged.
Yes.
Serial number 6. K. and Dayalu.
For the petitioner, auction date 11-12 ಇದೆ borrowers.
11-12 ಇದೆಯಾ?
11-12 ಇದೆ.
ಎಷ್ಟು ಅಮೌಂಟ್?
Reason ಅಲ್ಲಿ 25 lakhs and odd.
ಆಕ್ಷನ್ ನೋಟಿಸ್ ಅಲ್ಲಿ ಎಷ್ಟಿದೆ?
25 lakhs
47,000.
47,95 ಇದೆ.
ಎಷ್ಟು ಕೊಡ್ತೀರಾ?
ರೀಸನಬಲ್ ಬೇಕಾದ್ರೆ ಲೇಡಿ ಶಿ ಹ್ಯಾಸ್ ನೋ ಬಿಕಾಸ್ ಪ್ಯಾಂಡಮಿಕ್ ಪೀರಿಯಡ್ ಬಹಳ ತೊಂದರೆ ಆಗಿದೆ. ಕಟ್ಕೊಂಡು ಹೋಗ್ತಾರೆ. 70 lakhs ಪ್ರಾಪರ್ಟೀಸ್ ಅನ್ಯಾಯ ಹೋಗ್ಬಿಡುತ್ತೆ.
ಆಯ್ತು, ಎಷ್ಟು ಕೊಡ್ತೀರಾ ಹೇಳಿ ಅಂದ್ರೆ ನೀವು ಅದೆಲ್ಲ ಹೇಳಿದ್ರೆ ಪ್ರಯೋಜನ ಏನು?
ಒಂದು 3 months ಟೈಮ್ ಕೊಟ್ರೆ.
ಯು ಹ್ಯಾವ್ ಟು ಪೇ ದಿಸ್ ಅಮೌಂಟ್. ಸೊ ಇವಾಗ ಒಂದು 15 ದಿನದಲ್ಲಿ ಎಷ್ಟು ಕೊಡ್ತೀರಾ?
15 days ಅಲ್ಲಿ ಒಂದು 3 lakhs ಕಟ್ತೀವಿ. ಅಲ್ಲ ಕಟ್ಕೊಂಡು ಹೋಗ್ತೀವಿ. ಅಮೌಂಟ್ ಏನಿದೆ ಕಟ್ಕೊಂಡು ಹೋಗ್ತೀವಿ.
ದಯಾಲು ಅಷ್ಟು ಕೊಟ್ಟರು ಅದು ಬರೀ ಇಂಟ್ರೆಸ್ಟ್ಗೆ ಹೋಗುತ್ತೆ.
ಅಲ್ಲ ಟ್ರೈ ಟು ಕ್ಲಿಯರ್.
ಇನ್ನೊಂದು 6 ತಿಂಗಳಲ್ಲಿ ಬರ್ತೀರಾ, ಅದು 50 ಲಕ್ಷ ಆಗಿರುತ್ತೆ.
ಅಲ್ಲ ಎಂಟೈರ್ ಅಮೌಂಟ್ ಅಕ್ರೂಡ್ ಅಮೌಂಟ್ ವಿಲ್ ಬಿ ಕ್ಲಿಯರ್ಡ್ ಮೇ ನಾಟ್ ಸಮ್ ಟೈಮ್ ಬ್ರೀತಿಂಗ್ ಟೈಮ್.
ನೀವು ಇದು ಕೊಡಿ, ವಿಲ್ ರೆಕಾರ್ಡ್ ಇಟ್ ಸೊ ದಟ್ ಯು ಆರ್ ಹೆಲ್ಡ್ ರೆಸ್ಪಾನ್ಸಿಬಲ್ ಫಾರ್ ದಟ್. 15 ದಿನದಲ್ಲಿ 3 ಲಕ್ಷ.
3 ಲಕ್ಷ ಕಟ್ತಾರೆ.
ಒಂದು ತಿಂಗಳಲ್ಲಿ ನೀವು ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅದು ಇಂಟ್ರೆಸ್ಟ್ ತಿಂದಾಕ್ಬಿಡತ್ತೆ.
ಅಲ್ಲ ಕರೆಕ್ಟ್, ಬಟ್ ಅವರಿಗೆ
ಇದೆಲ್ಲ 19%.
ಲಾಸ್ಟ್ ರೀಸನಬಲ್ ಅಟ್ಲೀಸ್ಟ್ 6 months ಎಲ್ಲ ಕ್ಲಿಯರ್ ಮಾಡಿ.
6 months ಲೆಕ್ಕ ಕೊಡಿ,
ಕ್ಲಿಯರ್ ಮಾಡಿ.
ಲೆಕ್ಕ ಕೊಡಿ, ಕಂಪ್ಲೀಟ್ ಬೇಡ. ಆ 3 ಲಕ್ಷ ವೇಸ್ಟ್ ಆಗುತ್ತೆ. ಆಮೇಲೆ
15 days 3 lakhs, ಅನದರ್ 1 month ಅಲ್ಲಿ ಒಂದು 3 lakhs ಕಟ್ತಾರೆ. ಬಹಳ ಪ್ರಾಬ್ಲಮ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ.
ಅದಕ್ಕೇನಪ್ಪ ಹೇಳ್ತಾರೆ, ಪ್ರಾಬ್ಲಮ್ ಅಲ್ಲಿ ಇದ್ದು ಆಮೇಲೆ 10 ಲಕ್ಷ ಹೋಗತ್ತೆ. ಅದನ್ನು ಇರೋದನ್ನು ಹೋಗತ್ತೆ. ಗುಡ್ ಮನಿ ಆಫ್ಟರ್ ಬ್ಯಾಡ್ ಮನಿ.
ಅವ್ರಿಗೆ ಅಡ್ಜಸ್ಟ್ ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ. ಅದರ್ವೈಸ್ they would have paid the amount.
And AG accepts notice for respond number 2 and 3. Issue notice to respond number 1 returnable by 16th January. That counsel for the petitioner submits that due to financial stringency, the petitioner could not make payment of the due amounts, resulting in the auction notice having been issued. To establish bona fides, he submits that an amount of rupees 3 lakhs would be deposited within 15 days from now, that is on or before 19th December, and a further amount of rupees 5 lakhs would be deposited by another 15 days.
3 lakhs.
3 lakhs.
3 lakhs.
3 lakhs would be deposited within 2 weeks thereafter. That is on or before 9th January. Considering the said
ಅಲ್ಲ ಆ ಕಡೆ
submission,
1 month ಅವಕಾಶ ಕೊಡಿ.
considering the said submission, though it is ordered that though the auction proceeding may go on, the respond number 1 would be restrained from confirming the auction. Needless to say, if any of the above amounts are not paid within the time fixed, the interim order will stand automatically vacated. Process fee and copies to be furnished by end of day 6 December, failing which the interim order will stand automatically vacated. ಕೊಟ್ಟಿಲ್ವಾ? ಕಾಪಿ ಕೊಡಿ.
ಕೊಡ್ತೀನಿ.
Serial number 7. Vijayta Nair.
Yeah, for the petitioner.
Appeal for respond number 4 in this case.
Lordship had directed,
Yes, my lordship.
had heard this matter and had asked R1 to give clarification
Yes,
on
Mr.
whether
Prabhakar.
any violations.
I'm here to represent Mr. Prabhakar. I'm for R4, my lord.
Yes.
Lords, you had, my lords had directed in the last occasion to secure the bylaws of the building which I am in. We could not, in spite of trying our best, we could not secure our bylaws. We are
You are
trying.
wasting the time of this court.
We are trying our best, my lord.
Despite the order dated, the petitioner is before this court seeking for the following liquidity. The petitioner is before this court seeking for the following reliefs. During the pendency of the matter, an inspection of the property of the petitioner was directed to be carried out. When a report was received as regards certain violations on the terrace floor, the learned counsel for the petitioner had indicated that the said demolition would be, that they said violation would be demolished, bringing the same in conformity with the building bylaws. Subsequent thereto, the demolition was effected and the respond number one has confirmed that the construction is in accordance with the building bylaws.
After removal of deviations. After removal of deviations.
And all the deviations have been removed. Thereafter, respond number 4 sought to contend that the removal is not in terms of the
I have
applicable
photographs
building
showing,
bylaws.
I have photographs ready showing that, my lords.
Photographs are
I
like.
have the building bylaws, your
The
lordship.
bylaws also, my lords.
I have the building bylaws,
They've
your lordship.
given you 5 times to show what is the violation. You are not showing anything. Why should we be adjourning the matter?
The violations were shown in the last occasion, my lords.
Your lordship, I have the building bylaws.
Bodies.
It has already been produced earlier, your lordship.
Illy, it has not been produced.
Last year it was produced. Your lordship.
What is the setback in the front and?
Setback in the front is 1 meter, left, right and back, there is no setback, your
No
lordship,
setback.
for commercial.
Now, counsel for respond number 4 had indicated that the setbacks have not been left on the left hand, right hand and the back side of the building. Hence, he had been called upon to produce the bylaws to indicate the same. Today, though, respond number 4 has not produced the bylaws, the petitioner has placed the said bylaws for consideration before this court. A perusal of the petition, said bylaws would indicate that the plot of the petitioner measuring 240 square meters would have to have a setback of 1 meter in the front, and no setback is prescribed in terms of building bylaws for the left, right, and the rear portion. That being the case, the respondent number 1 authority having categorically indicated that the setback in the front is proper and correct, the submission made by counsel for respondent number 4 that the applicable setback for the left, right, and rear has not been left, would not, cannot be countenanced under law or fact, inasmuch as per the building bylaws, there is no setback to be left on the left, right, or rear for a property measuring up to 240 square meters. The building now being brought in accordance with, in compliance with the building bylaws as contended by the, as certified by the counsel for respond number 1.
That building bylaws mean which was prevailing on that time.
As prevalent as on the date on which the building was constructed. I pass the following order. Writ petitions allowed. Though there is a deemed commencement certificate and building plan sanction for the purposes of formality and completion, respondent number 1 is directed to issue a formal commencement certificate and formal building plan sanction in accordance with the building bylaws as applicable at the time when the building was, when the plan sanction had been initially
Not
submitted.
building was commenced.
Building construction was commenced.
No, your lordship, within 3 months, if it is not communicated. it is
Normal, we are asking them to give it so that you can have it in your record.
Please, your lordship, and even the OC, your lordship.
We are coming to it.
Please.
My lords, since my building is 100 years old, my lords, I'm not, I'll get the bylaws, my lords.
Nim action, nim building mele in action ತಗೊಂತಾ ಇಲ್ಲಪ್ಪ. The communication dated 29/6/2023 at annexure P no longer survives for consideration as such is quashed. The mandamus is issued directing the respondent number 2 to issue an occupancy certificate.
Respondent number 1, my lord.
Respondent number 1. Ella respondent number 1.
Yes.
Respondent number 1 within a period of
1 month.
30 days from the date of receipt of a copy of this order.
Obliged, your lordship.
What's up, Ajay?
Hearing for the petitioners. Hearing for the petitioner, my lord. My lord, the other side was to file their objections. We had filed the IA for amendment.
Madam, for the respondent number 1, my lord. Lord, in this case, for respondent number 1, senior counsel MR Nayak has been engaged, my lord. He is on his legs in court.
You have not filed objections to the amendment.
Please, my lord.
My lords, arguments has already been addressed, my lords. The matter may be reserved, my lords. The
The urgency is this, my lord, that the student is in a limbo at the moment, my lord, and the exams are coming up in January, my lord. We had argued the matter on both sides at length, my lord.
Thereafter, you filed amendment application.
My lords, yes, there was an order where we were allowed to orally submit already, my lords, for the sake of, my lord, because they had brought up the issue. Despite that order, my lord, we had filed the IA for amendment.
Pass out.
Great.
Bill number 9.
Your Lordship, appearing for the petitioner.
Yes.
The respondents were previously directed to submit their objections, but they have not filed the same. So I kindly request the respondents to
Awaga,
submit
file
their objections.
And AGS seeks for and is granted 3 weeks time to file a statement of objection. Objections, if any, to be filed on or before 9th January, failing which it will be taken as not filed and matter proceeded with. Pre-list on 17th January.
Much obliged.
230 matters. List
10
number,
item. Yes.
list number 1, serial number 60. DS Umesh and connected matter.
Yes. You are appearing in 60?
I'm appearing for the petitioner.
Yes. So in
I'm
60
sorry.
or 61?
I'm sorry, but
Mr. Umesh? Petitioner. Mr. Srinivas?
The matter was settled before Lok Adalat, my lord. Now, my lord, subsequently, we have come to know that the driving license is a fake driving license.
No driving license. Fake
That is why we filed an application for recalling the order. My lord, they have no powers. The my lord view is the only
Fake driving license and pay and recover.
ಅದಾದ್ರೂ ಆಗ್ಬೇಕು, but my lord, since we have settled the matter, unless there is order by the tribunal, that is the.
Pay and recover will direct you. You're paid.
My lord,
You can recover.
but my submission is, my lord, unless it is ಟ್ರಯಲ್ ಆಗದೇನೆ ಲೋಕದಲ್ಲತ್ತಲ್ಲಿ ಸೆಟಲ್ ಮಾಡಿದೀವಿ.
ಆಯ್ತು.
ಹಾಗಾಗಿ DL ಆಸ್ಪೆಕ್ಟ್ ನ ಫೈಂಡಿಂಗ್ ಇಲ್ದೇನೆ my lord, I am prepared to pay the amount, but the matter may have to go back to try that issue, my lord. That's all my.
When you recover andre,
Yes.
you'll have to file proceedings.
My lord, the Supreme Court view is, my lord, in the same proceedings it can be recovered. That is why, my lord, I will pay the,
only
I will pay
limited
the
to
money.
that.
Yes, it may be sent back only to find out whether my stand is correct or not.
Yes. Petitioner insurance company is before this court seeking for the following relief. The proceedings have been filed before the MACT for compensation in MVC number 2434 of 2019. The matter was referred to Lok Adalat, where it was settled by the petitioner insurance company on and an amount of rupees 4,40,000 was paid on 22/11/2019 on the premise that the owner of the vehicle had a valid and subsisting license. Driver had a valid and subsisting license. Subsequently, after the settlement, the insurance company sought to verify the details of the license when it came to know that the license was a fake license and not that one issued to the driver. It is in that background that the petitioner is before this court seeking for the aforesaid relief. Though respondent number 1 has been served.
That I am representing for respondent.
ಮತ್ತೆ ಯಾರು ಬರ್ತಾನೆ ಇಲ್ಲ.
I am representing.
ಇವತ್ತಿದ್ದೀರಾ? ಹೇಳಿ
ಏನು ಇದೆ
ಹೇಳಿ
That the
ನಾವು ಹಳೆ ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿ ಯಾರು ಬಂದಿಲ್ಲ ಅಂತ.
that the matter was referred to the Lok Adalat, settled, joint memo was filed. My lord, the Lok Adalat, my lord, they fixed 2 months' time to pay this amount of compensation. Subsequently, my lord, they verified that there is no driving license. Then thereafter, my lord, the application has been filed to recall that amount. The learned judge says, my lord, it cannot be recalled. It has been settled between the parties because the deceased is not, my lord, the party to the fraud or misrepresentation. Therefore,
They're not
rejected.
disturbing that. The inquiry will be as regards respond number 2. ನೀವು respond number 1.
Please, my lord.
ನಿಮ್ಮ ಅಮೌಂಟ್ ನಿಮ್ಮ ಹತ್ರನೇ ಇದೆ. We are not disturbing that.
Owner of the vehicle.
Recover from respond number 2.
That's right. That too, my lord, as my lord said, if I am able to establish that there
That
is
if the
then I
driver of
will
the
pay.
vehicle does not possess the valid license or a fake or a fabricated.
Srinivas say your amount is not being disturbed. ನಿಮ್ಮ ಅಮೌಂಟ್ ನಿಮ್ಮ ಹತ್ರ ಇದೆ. Pay and recover ಅವ್ರಿಗೆ.
Yes, I even said, my lord, the amount can
Within
be released
two
to him. I have
months,
no
my lord,
issues.
within 2 months, my lord, which expires on 14/2/2020.
You are
They are
appearing-
liable to pay the interest also.
You are appearing for respond number 1 or respond number 2?
Respondent number 1, because
ಅಷ್ಟೇ
my
ತಾನೇ?
lord, if they should have been deposited within 2 months, my lord,
ಇನ್ನ ಡೆಪಾಸಿಟ್ ಆಗಿಲ್ವಾ?
ಮಾಡೇ ಇಲ್ಲ. Therefore, they are liable to pay the interest. That is the joint memo.
Immediately.
Impugned order was passed by.
ಪೇಮೆಂಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ
No, with interest. Kindly, my lord, see the annexures. Page 18.
I immediately, my lord, is reasonable time, maybe I will see that it is deposited.
ಅಷ್ಟು ಕೊಟ್ಬಿಟ್ಟು ಬನ್ನಿ.
4 years you have not been deposited.
ಅಲ್ಲ
4 years.
Yes, please, my lord. This is a order passed by the Lok Adalat.
Stay
Kindly see,
ಆಗಿತ್ತು,
my lord,
ಸ್ವಾಮಿ,
annexure
ಹಾಗಾಗಿ.
D, page 18.
My lord.
1 minute, sir. Kindly, my lord, see the last lines.
Then you
The
told us
respondent
it is
number
being
1.
paid.
No, my lord, I did not say. I
The
said
respondent
it
number
can be
1
paid
is
to them.
agreed.
I said it can
1
be
minute,
paid to
sir.
them.
I will read the order.
Submission of the council we normally accept.
My lord, I did not say, my lord, I have deposited. I said it can be paid to them. I'm sorry. I said it can be paid to them.
First pay it.
My lord, I'll do that.
Now we'll increase the interest from 6% to 12%. That you are holding back the money for last 4 years.
My lord, stay ಇತ್ತು ಹಾಗಾಗಿನೇ.
Sorry.
My lord, I have made efforts to, my lord, it was posted.
ತಗೊಳ್ಳಿ.
It was, did not reach, my lord, several occasions.
Disposal ಬೇಡ.
He also aware of that.
Council for respond number 1, submit that despite a settlement which occurred before the Lok Adalat on 22/11/2019, the amounts have still not been paid to the
Please, my lord.
respond number 1. The counsel for the petitioner submit that the payments was not made due to the pendency of the above proceedings. The said submission cannot hold any water. Even if the petitioner has any grievance acts against the insured on account of the insured's driver not having a license as contained in the present matter, once the dispute had been settled before the Lok Adalat, it was but required for the petitioner insurance company to have made payment of the due amounts to the victim of the accident. Even if, at the best, even if the contention of the petitioner were to be accepted, it would amount to an order of, it could only lead to an order of pay and recover, in as much as there is no fundamental breach of the contract of insurance, which would entitle the petitioner insurance company to withhold the money. In this case, the matter is even worse, in as much as there is a settlement which had been arrived at before the Lok Adalat, and the payments have not been made for nearly 5 years now. In that view of the matter, the stand of the insurance company being completely unreasonable, and the considered opinion that the petitioner insurance company will have to be mulcted with penal interest. As such, the petitioner is directed to make payment of the amounts agreed upon, namely rupees 4,40,000,000, with interest from the date of the
Petition.
accident, from the date of the petition till payment thereof at the rate of 9%. The said payment to be made
Yes, sir. 12%.
within 12 ಸುಮ್ನೆ ಹೇಳಕ್ಕೆ.
stay ಇತ್ತು ಸ್ವಾಮಿ, ಇಲ್ಲದೆ ಇದ್ರೆ ನಾನು ಖಂಡಿತ
Within 2 weeks from now, relist on 19th.
Connected matter also, that is, my lord, see, 5
ಅಷ್ಟೊಳಗೆ
lakhs
ಪೇಮೆಂಟ್
65,000.
ಮಾಡಿ, ಇಲ್ಲಾದ್ರೆ ನಿಮ್ ಪೇ ಅಂಡ್ ರಿಕವರು ಬರಲ್ಲ.
ಅಲ್ಲ, may I make one request, Mila? Probably I may have to undergo an operation. It may kindly be
Any of your colleagues can
January, illa, I'm all and soul in the office. Mila. January.
Relist on 9th January for further hearing.
It is my line.
In the connected.
3.1 ಅಲ್ಲಿ
Same.
5,65,000.
ಅಷ್ಟೇ.
5,65,000
Same day, ಅದು
same.
please, madam.
ಅಲ್ಲಿ ಸ್ವಾಮಿ ಒಂದು
ದುಡ್ಡು
ಈಗ
ಕೊಡ್ಬೇಕು.
ರೀಸೆಂಟ್ ಡಿಸಿಷನ್ ಒಂದು ಪೇನ್ ರಿಕವರಿನೂ ಬರಲ್ಲ ಅಂತ ಆಗಿದೆ, ಹಾಗಾಗಿನೇ ತಮ್ಮ ಗಮನಕ್ಕೆ ತರಕ್ ಟ್ರೈ ಮಾಡಿದೆ.
ನೀವು ರಿಕವರಿ ಮಾಡ್ಕೊಳ್ಳಿ, ದುಡ್ಡು ಕೊಡಿ.
ಅಲ್ಲ ತಮ್ಮ ಗಮನ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಚೇಂಜ್ ಆಗಿದೆ. ರೀಸೆಂಟ್ ಅಲ್ಲಿ ನಮ್ಮ ಡಿವಿಷನ್ ಬೆಂಚ್ ಎರಡು ಜಡ್ಮೆಂಟ್ ಅಲ್ಲಿ
Insurance company.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿ ಆಗಿದೆ.
ಅಲ್ಲ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ದೇ ಒಂದು ಬೆಲಿರಾಮ್ ಕೇಸ್ ಅಲ್ಲಿ ರೀಸೆಂಟ್ ಆಗಿ
ಈಗ ನಾನು
ಬರಲ್ಲ. ಅಲ್ಲ ತಮ್ಮ ಗಮನಕ್ಕೆ ತಂದೆ
ಕೊಡಿ
ಅಷ್ಟೇ.
ಕೊಡಿ ನೋಡೋಣ.
61.
ಡ್ರೈವರ್ಗೆ ಲೈಸೆನ್ಸ್ ಇಲ್ಲದೆ ಇದ್ರೆ ಏನು ಅಂತ ಹೇಳಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಬರ್ದಿದ್ದಾರೆ.
Number 61, XM Joseph and connected matter.
Pay for respond number 1 and 61.1, my lordship.
Respond and 2 and 3 euro.
Yes.
RB,
Is regarding the continuation, my lords, on the last occasion, my lords, we stopped at.
Statement you have to give us.
statement is.
Who has
there.
to give?
We have to give euro. Statement is there. I'll give.
You are appearing for the Union of India. Yes, statement ಕೊಡಿ.
The lordships kindly, my lords, I'm presenting a court convenient synopsis. Court convenient synopsis, ma'am.
ಕೊಡಿ. They have to give the statement when they declared it NPA.
My submission, my lords, is the RBI directive speak about account being standard, not about NPA.
Let us see what they give us.
With mem.
What is the date of the NPA, madam?
Date of NPA, there is 4 accounts, Your Honor.
Hmm.
In 2018 only, there 3 accounts has got NPA, Your Honor.
Where is that?
Last time we have submit one,
Last time ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಅಜ್ಜನ ಆಯ್ತು.
section ಕೊಟ್ಟಿದ್ವಿ, ಅದ್ರೊಳಗಡೆನೆ, there is a 13-2 is there, Your Honor. ಅದ್ರೊಳಗಡೆ we have classified it, Your Honor. Date ಇದೆ.
ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲಿದೆ?
Page number 6 of objection, Your Honor.
Page number 6.
36-18. Page number 6, Your Honor. Which we have given objection last year. Statement of objection alide. Demand notice ಕಳಿಸಿದೆ, ಇದರಲ್ಲಿ NPA assets on 36.
ಅಲ್ಲಿದೆಯಾ statement of objection? So one account is 36, 2018.
Please, Your Honor. One more is. Another one account is ಇನ್ನೊಂದು.
Seen in page number 12, my lordship.
12. Another account.
Loan account number ಎಲ್ಲಿ ಸಿಗತ್ತೆ? To see what the difference is.
The loan account may be seen on page number 9,
9,
my
Your
lordship.
Honor.
9.
Please, Your Honor. Schedule A.
IP 1022 term loan.
The first two law accounts and the
And
another one is page number
Page number 14.
14, my lordship. That also got NP and dated 36 2018,
18.
mentioned in page number 12, my lordship.
658 hypothecation. IP 17022. Overdraft 493. Yes, ಮೂರ್ ಅಕೌಂಟ್ ಆಯ್ತು. ನಾಲ್ಕನೇದು?
ನಾಲ್ಕನೇದು Again, they have given a loan for 30 lakhs, so OD, 19 Your Honor. ಅದಕ್ಕೆ
ಬೇಗ ಕೊಡ್ಬೇಕು.
Please, Your Honor.
The Lordship will kindly see page number 4 of the convenience synopsis. The classification of NPA in June, in 2018 is regularized. Subsequently, in 2019, they advanced me another term loan. That date is inconsequential. How it is inconsequential is forthcoming from page 144 of merit petition. There are 4 accounts: 1022, 0493, 0693. In page 144, your Lordship will get. These are classified as non-performing asset. At page 145 on 24/12/2020, because the earlier date of classification is inconsequential because I have regularized the loan.
How was it regularized on 31/3/19?
Plus, I have paid the, whatever dues were there, I have paid it. My accounts became regular standard.
Once a NPA, how can you do that?
Now, your Lordship will kindly see, my lords. The reason that is shown for classification of the account as NPA is irregularity in the accounts. That is not the criteria for classifying the account as NPA. It should be a standard account or substandard account, doubtful account. That's what I was submitting, my lords. If your Lordship will look into
Where
section
is
2.1 of Surface Act.
24/12, they issue a notice?
Plus, your Lordship will kindly see, my lords, their application under section 14 of Surface Act. They maintain 2 applications.
Page?
Page 144. At 145, in para 5, your Lordship will see. I'm sorry, para 4.
This is what you had shown us last time. That is why they asked.
Account number 1, 1022, 493, 693.
This is 3 account numbers I mentioned.
3 account numbers. They maintain 2 petitions, which is not permissible in law.
Which is the other petition?
The other petition is, your Lordship gets it at page 156. At 157. At para 4, account number 658.
This is as regard the 4th account.
This is the 4th account.
Account
Hmm.
got
It's a
NPA.
different account.
2120.
It's not a second petition, it's a different account.
No, this is the second, but same for section 14 application.
Correct, but this is as
Second-
regards
the
HP.
fourth account.
They maintain 2
Hypothecation account.
applications. There are 4 accounts. In respect of 3 accounts, they maintain 1 petition.
Yes.
That is 50107.
That was NPA on 24/12/2020.
2020.
And the other one is
The
on
other one
21/2021.
is 658 is 21/2021.
Yes.
2021. Not the classification of my account as NPA in 2018, June 2018 is
You
inconsequential.
can submit, that you can.
Is inconsequential.
Your own application, madam. That is why we had asked you.
Can they have it tomorrow? Senior is there tomorrow. Civil court.
ಇದೇನೋ ತೋರಿಸ್ತಾ ಇದೆ. ಅದು ಆಲ್ರೆಡಿ ತೋರಿಸಿ ಆಗಿತ್ತು. ನಿಮ್ಮ ಪೆಟಿಷನ್ ಅಲ್ಲೇ ನೀವು ಇಟ್ ಬಿಕೇಮ್ NPA ಆನ್ 21/2021. ಆಮೇಲೆ 24/12/2020 ಅಂತ ಹೇಳಿದ್ದೀರಾ. ಆವಾಗ ದಿ RBI circular will apply. 16, 17 ಇವಾಗ ತೋರಿಸಿ ಪ್ರಯೋಜನ ಇಲ್ಲ. Because you yourself have said 2020.
Can we have it tomorrow?
Further hearing ಮತ್ತೆ.
And the clarification my lord sought on the last occasion, it's forthcoming in annexure H at page 81.
81.
81. This is the continuation of annexure E. Para 2, my lords, third line. With the objective of alleviating the potential stress to individual borrowers and small business.
Where are you reading?
Para 2, my lords,
Para 2 at page?
page 81.
81 is resurgence of COVID-19.
It's 81.
Third line, my lords.
81.
Para 2
RBI
starts with
circular
resurgence
dated
of
5th May
COVID-19 pandemic.
2021. Page 81, my lord. Circular dated May 5th, 2021.
Yes.
It is also addressed to the urban cooperative banks. Now, para 2, the third line. With the
Yes.
objective of alleviating the potential stress to individual borrowers and small business, the following set of measures are being announced. These set of measures are broadly in line with the contours of the resolution frameworks 1.0 with suitable modifications. That resolution framework 1.0 is annexure E.
So it was enhanced to 31st March 21.
Please, my lords.
So your second notice also will come within the purview. First one is
Yes.
December 2020,
Yes,
second
yes,
one
yes,
is
yes.
January 21.
Yes.
At the request of counsel for the respondent, release tomorrow. It's made clear that no further adjournment could be granted.
62.
Right here for the petitioner.
Yes.
This is that matter relating to execution of a sale deed in my favor. Your Lordship had directed me to place an
Shareholding
affidavit.
pattern.
Shareholding pattern.
Yes.
I filed that one. I'll show you Lordships that affidavit first. We had filed it on 2nd December.
Yes.
On the date, my lord, of execution of the lease agreement,
That is, the date is
can I request my lord to come to page 5?
9 June 2005.
Yes, so I've taken the period 1st April to 30th June,
Yes.
35.22%.
Who are the shareholders?
The promoters, my lord, have indicated here because it's a public listed company. So the promoter holding is shown separately, institutional holding is shown separately, my lord, and the private and public holding is shown separately. My lord, will see Indian promoters is 35.22, then non-promoter holdings, institutional investors, mutual funds, banks, FIIs.
That will keep on changing.
Everything will change, my lord, in my humble submission. As a matter of fact, since it is a listed company, I'll
Promoters cannot change.
it can change. I'll show you what is why. Then, Lord, the next one, please come to page 7. In 2011, at the time when the lease came to an end.
Yes.
Page 6 is the period, 1st April 2011 to 30th June 2011. It's come to 22.97%.
Indian promoter is 1.92%.
No, 22.97.
Where is that page?
Page 7, my lord.
Page 6, bottom. Shareholding of promoter and promoter group, Indian.
Yes, my lord.
1.92.
Yes.
Foreign
Institutional investors,
is
my lord,
also
the
1.9,
individuals
is zero.
is 22.93.
Where is 22?
1.92 shares pledged. My lord, you'll see on top, just about percentage. Shares pledged or otherwise encumbered. Total shareholding as a percentage of total number of shares. And total number of shares held in dematerialized form. My lord finds that, I'm sorry. Just above shareholding of promoters, which is, I think, in a lighter font. Category of shareholders.
Yes, category of shareholders.
Then number of shareholders, total number of shares, shares held in demat. Then total shareholding as a percentage of total number of shares is 22.93%.
Pledged is 1.9.
Pledged is 1.9.
And who are these 12 individuals? Are they the same as the 12 there?
Yes.
So that is what they are saying, it's changed.
No, that they're not saying it. No. They're not saying it. I'll just point out, if your lordship grants me 1 minute, I'll just show it. Then, Lord, we've taken also in 2015 at page 9. If my lord kindly comes to the bottom, it's 22.21%.
Number has got down to 9.
9.
Are they the same?
The same, but I would respectfully say, my lord. Now, can I show the clause?
Yes.
And I want to show you, lordship, one judgment which has considered this clause. Page 109. May I read that clause? R1. The lessee shall not change the constitution / status of its firm / company in bracket proprietary or partnership, registered or unregistered, or private limited company or unlimited company. Only those categories are covered. A public company is not covered. First, my lord, without the previous written consent of the lessor or any other officer authorized by the lessor, and such consent shall be granted by the lessor subject to the condition that the original applicant, partners, promoters, directors, or shareholders should continue to hold a minimum 51% of interest or shares in the newly constituted firm or company. Where, my lord, this is a classic case of a transfer, where there is some kind of a transfer which is planned with respect to the company into a newly constituted company or an entity, then this clause applies. It doesn't apply within the entity itself. And which is why, my lord, it is limited only to a firm or a company which is a private limited company or unlimited company. Unlimited, of course, my lord, as your lordship know, not limited by shares or guarantee.
Your original, what they are contending
is the name of the company.
Only
my
name,
lords,
nothing else.
Is changed without our consent.
And the applicants also have changed, is what you said.
No.
That is why we asked him to give the shareholding. Otherwise, why should we ask him to give the shareholding?
As this issue.
If that was not raised.
Like, please annex your aim.
This is applicant, partners, promoters should hold a minimum of 51%. So the applicants in 2011 are the same ones which are continuing in 2005 and 11. Give that list, that's all.
No, but that's not what they're saying. They're saying name change. That's all they're saying. Please see, my lord, the
impugned order, my lords, it is with respect to only the name, my lords. What
only name
the
change.
impugned orders is.
But you argued on the shareholding. That is why we asked them to give the shareholding.
No,
There's
my
no
lords,
requirement for shareholding.
I pointed out, my lords, 2 documents, my lords, where one is the audit objection which was raised. Then the other one is, in spite of there being a change in name, they continue to correspond with the old name. That is what
Third aspect, yes.
At that point in time, my lords, this court, my lords, directed them to give the shareholding pattern.
Court only directed.
No, my lords,
We'll pick it up.
That's the only issue.
So you have no issue about shareholding?
Shareholding, my lords, we haven't.
We'll record, then there's no issue.
With respect to the change of name, my lords, they have not obtained previous consent is what we. That.
What difference does that make? That is only as regard the product and
Product.
this one,
109 R2.
name and product.
Product has also not changed.
There's no product change.
We are same service company.
Name of the product is, please, name of the product is market exigencies. If they want to rename the product in something else, they can always do it. How does that have a bearing on your lease? Please. Sorry. Petitioner is before this court, seeking for the following reliefs. I heard reserved. That's order later. Please.
I filed my objections.
After argument, you
No,
want to file
in the
objection?
sense, no, the objections are there, my lords, little bit, not that,
We don't want any objection. You argued. You can't say objections after that.
no, my lords, the objections are already filed, my lords, by Kionix.
You have filed.
Please.
Serial number 63, Ramesh Kulkarni.
Hearing for respondent 3 to 6, Your Lordship. Senior counsel is held up in other court, Your Lordship. Senior counsel is held up in the other court.
Every time same thing. I don't want to say anything more. ಇದರಲ್ಲಿ documents ಕೊಡಬೇಕಾಗಿತ್ತು. Documents ಕೊಟ್ಟಿಲ್ಲ.
Kindly
There was
pass
an
over the
order.
matter, Your Lordship.
We'll pass over, let us see if
Very
it
well,
reaches.
very well. I'll be here.
64. Vinayak Kulkarni.
That's to refresh my lordship minds. Yesterday, learned government council submitted that apart from the lands which have already been covered in the road widening, the remaining portion, whatever remaining, that may be measured and that can be given as a part of utilization.
A small portion is left unsaid.
It's not like that. Great respect.
ಒಬ್ಬೊಬ್ರು ಒಂದೊಂದು ಹೇಳ್ತಿರಲ್ಲ.
ಆತರ ಇಲ್ಲ ಅಂದ್ರೆ 17 ಅದು ಎಲ್ಲಿಂದ ಬರುತ್ತೋ ಈ theories, my lords. We don't know how they come out with the 17 meters and it's not like that. Great respect.
See, there's a submission made yesterday that there's one temple, small temple. So, Panindra,
My lords,
there's a small temple and a platform. Apart from that, you do whatever you want.
I'll just
Only leave that to them because they have been doing
my lords,
pujas from
it's
last 42 generations.
not a single day. That is our submission. They don't do it. My lords, it's in our dictum. We have shown it. From 50s, my lords, it's only us who are doing the puja every day. And it's been intimated to them not once, 4 or 5 times from 80s. And they keep quiet. It is not so. My lords, and also I got instructions about the temple. Now, my lords, we said, in our counter, we have said that the entire thing will be removed and a dining hall and a prasad center is to come. But my lords, this small Garbhagudi which is there, in which the idol is there, the idea is experts will be, they will remove that with all customary things, install it in another place. Then a new Garbhagudi in the small thing will be constructed in the same place. Idol will be placed back with all customary things. This puja, everything in our dictum will show it, my lords, that it is in the custom. The entire puja is being conducted by the temple itself. There are archakas. In fact, we also found out almost about 20-25 years. The mutt head has never come. Only 2 years back he had come, and it's only the archakas of the temple who do the puja. They take the prasad and do. Today to say we will conduct the puja, it is not so. The idol will be what they call it as stapane, pratistapane, my lords. The idea is this dilapidated structure will be removed with all customary things. Experts are there. We had issued a tender, given the work order also for that. Then, my lords, it will be installed in another place because it is known as the Prana Devaru or the family. Yeah. My lords, family thing, it's there in Kannada, my lords. I'll just show.
When your submission is Pranadevaru, Anjaneya Swami.
Anjaneya
Gestu,
Swami,
inna Pranadevaru is
Mane-
another name.
My lords, it belongs, that is, my lords, the puja. Parivara Devaru in the Ditham. Parivara Devaru. So, my lords, puja has to be done to that also, to this. Then, my lords, for the main deity, then the puja will be done there. It is like there are 3 or 4. This is known as Parivara Devaru. Then there is one more Prana Devaru and all that. So they do pujas for this first.
Then the main deity, that is Lord Subramanya, the Mahapuja happens only after these pujas are conducted here. And this is done only by the temple. It is not done by anyone else. In fact, my lords, even in Garbhagudi anywhere, let alone this Swami Mat, my lords, other Swamijis also who come, they are not even allowed inside the Garbhagudi.
Yes.
Nobody is allowed. That's a settled position, my lords. Today, their entire claim has been that allow us to start doing puja. Now to say that we have been doing, it is not found anywhere. Even in the Dittam, it is not. Dittam shows that it is the temple which is doing. There are archakas. We had in fact, after yesterday's thing, my lords, I was briefed. I had a discussion. Lords, it is a very sensitive issue also. So far as puja, because my lords, those are sensitive issues where there have been suits with the other temples, my lord, with the other mutts from 1916 onwards. Now my learned friend put that AS 28 to show that we have said Uttaradi Mata is there. That judgment got modified in a compromise in RSA with the other mutt. So that judgment will not even hold. We are producing that.
You are producing it now.
No, it's because they are producing that AS which is not even connected to this matter. It is
ಅವ್ರಿಗೊಂದ್ಸತಿ ಕೊಟ್ಬಿಡಿ ಹಾಗಾದ್ರೆ.
ಕೊಟ್ಟೆ ಅವ್ರು ಕಾಪಿ ಕೊಟ್ಟೆ. I am just showing the RSA order. Lords, what I want to show, my lords, I will just take your lordship shortly, briefly. Original.
My lords, my limited submission in respect of that AS document is on page 25 and 41. It is their
Contentions were taken.
It is
That's
their
okay.
pleading that there have been.
ಅವ್ರು ಇನ್ನ ಸಬ್ಮಿಷನ್ ಮಾಡಿಲ್ಲ, ರಿಪ್ಲೈ ಶುರು ಮಾಡ್ಬಿಟ್ರು.
I'm sorry,
ಮಾಡ್ಲಿ ಅವರು.
My lords, my line of arguments would be, I will just show those, since I have given that document, my lords. The first document, as I submitted, it was the letter dated 25/4/22, written by the Mutt, my lords, to the Honorable Chief Minister then. Where they again request possession to be given in page 3, if your lordship comes, my lords. Bottom. ಈ ವಿಷಯದ ಕುರಿತು ಅಂತ ಶುರು ಆಗುತ್ತೆ. ಈ ವಿಷಯದ ಕುರಿತು ತಮ್ಮಲ್ಲಿ ಸವಿನಯ ಪ್ರಾರ್ಥನೆ ಏನೆಂದರೆ, ಸದರಿ ಕಟ್ಟಡವನ್ನು ಧಾರ್ಮಿಕ ದತ್ತಿ ಇಲಾಖೆಯವರ ಅಧೀನದಿಂದ ಮುಕ್ತಗೊಳಿಸಿ ನಮ್ಮ ಉತ್ತರಾದಿ ಮಠಕ್ಕೆ ಕಟ್ಟಡವನ್ನು ಕೂಡಲೇ ಹಸ್ತಾಂತರಿಸಬೇಕು ಎಂದು ಅಲ್ಲಿಗೆ ಸಂಬಂಧ ಪತ್ರ ಅಧಿಕಾರಿಗಳಿಗೆ ಸೂಚಿಸಬೇಕು ಎಂದು ಪ್ರಾರ್ಥನೆ. ಮೇಲಿನ ಎಲ್ಲ ದಾಖಲೆಗಳು ಅನೇಕ ಕಾರಣಗಳಿಂದ ಆ ಕಟ್ಟಡವು ಶ್ರೀ ಉತ್ತರಾದಿ ಮಠಕ್ಕೆ ಸೇರಿದ್ದು ಎಂದು ಸ್ಪಷ್ಟವಾಗಿರುತ್ತದೆ. ಶ್ರೀ ಸುಬ್ರಹ್ಮಣ್ಯ ಸ್ವಾಮಿ ಕ್ಷೇತ್ರದಲ್ಲಿ ನಾವು ನಮ್ಮ ಉತ್ತರಾದಿ ಮಠದಿಂದ ಒಂದು ವೇದಾಂತ ಪಾಠ ಗುರುಕುಲವನ್ನು ನಡೆಸಲು ಹಾಗೂ ಅಲ್ಲಿಗೆ ಬರುವ ಭಕ್ತರ ಅನುಕೂಲಕ್ಕಾಗಿ ಆಗುವಾಗ ರೀತಿಯಲ್ಲಿ ಭವನವನ್ನು ನಿರ್ಮಾಣ ಮಾಡಬೇಕೆಂದು ಇಚ್ಛೆ ಉಳ್ಳವರಾಗಿದ್ದೇವೆ. ಅದಕ್ಕೆ ತಮ್ಮ ಸಹಕಾರ ಬಹಳ ಮುಖ್ಯ. So my lords, they never say all these things. Now my lords, the next page is page 5 is the Dittam, my lords. Dittam is, my lords, where every temple, my lords, keeps a record of the pujas to be conducted to the deities, what is the sanctioned pujas and what has to be offered. In that, my lords, it's an old record. This is of 1980, which your lordships would get in page 6, running page 6 of that.
Yes.
Which, my lords, is revised to the earlier Dittam. In that, please turn over to page 7. Lords, your lordships would get Nitya Vinay on top, my lord, Shri Subramanya Swami Devaru, Dina Salluva Samagrigala Vyavara. Your lordship gets the heading on top, my lords.
Yes.
Then, my lords, Nitya Vinayoga Bhagye. Then, my lords, the left side is Vinyogalagala Hesru. That is the idols, my lords. The next column, Samagrigala Hesru. The lordship gets that, my lords. The second one on top, there are column 2 I am talking.
Yes.
Then is Hindina Pramana. That is the previous thing. Jasti Seriddu Jumma Shara.
In that, please come to the first one. It's, my lords, this is a very old record. The record also is like this. The first line in the left side column, my lords, your lordship should get ಅಕ್ಕಿಯ ವಿವರ. ಅದು ಹೂವ ಅಕ್ಕಿ ಅಂದ್ರೆ ಬಿಳಿ ಅಕ್ಕಿಯ ವಿವರ ಅಂತ ಅದು. In that, your lordship should get ಬೆಳಿಗ್ಗೆ ಅಕ್ಕಿ. ಬೆಳಿಗ್ಗೆ ಅಕ್ಕಿ in South Canara, my lords, is known as white rice, because otherwise they use red rice. ಬೆಳಿಗ್ಗೆ ಅಕ್ಕಿ. In that, we have marked and there is a tick portion. ಬೀದಿ ಮುಖ್ಯ ಪ್ರಾಣ ದೇವರಿಗೆ ಅಂತ ಕಾಣುತ್ತೆ, which is marked. I have also given the unmarked one. Just for our convenience, it's been marked. 0800, that is, my lords, akki every day. Jumma 800 grams. 800 grams akki is offered every day to the Pranadevaru. That is the Anjaneya Swami. Like that, for every idol, this dittam is mentioned. In fact, there are other pages which we don't have. There are other samagrigalu which goes to the thing. So, my lord, this dittam, without this, my lords, the temple cannot function. In the sense, all rituals are controlled by the dittam. So this also shows that this idol was always being, my lords, puja was being conducted by the temple. There is no record that they have ever conducted any puja.
Yes.
Now, my lord, the next one is page 9. Your lordship should get this honorable court's judgment dated
In RSA.
in RSA, my lords. It's dated, decree dated 13/12/1978. That was against the Matadipati of Samputa Narsimha Swami temple. In that, your lordship should get at page 10. Please come to page 10. This RS, regular second appeal, your lordship gets. From the decree of the Court of District Judge Mangalore, Dakshina Kannada, in appeal suit number 28 and 30 of 1966, on the file dated 31/1/1972, modifying the decree. Now, pursuant to this compromise, my lords, the decree of the court below were modified in terms of the compromise decree. So, to refer to a decree which is modified may not arise at all is my submission. This was with regard to Samputa Narsimha Swami Mata and the temple at that point of time.
On the northeastern side.
Yes, theirs is a different. It's within the temple premises.
Northeastern, northwestern on the same road. In a map ತೋರಿಸಿದ್ರು.
It's on the northwest.
Map, our map ನಾನು ನೋಡಿಲ್ಲ. Lords, if once we enter the temple, my lords, main, it's behind on the left hand side or the right hand side. Once we enter from
Temple as schedule ತೋರಿಸಿದ್ರು. Northeastern and northwestern, and in between is the Rakta Bidi.
Ratabidi is the road which goes directly to the
northeastern.
If I gave the photos, my lords, your lordship should see. I know file ಅಲ್ಲಿ ಇದೆ. I'll just show them.
So what is the compromise now?
Lords, compromise is, lords, Samputa Narsimha Swami Mata, which was situated next to the Garbhagudi of the temple, or Pauli, what is called as the outer boundary wall. There was a dispute whether that belongs to the temple or belongs to the Mata, all those things. So compromise was arrived where it was demarcated. Samputa Narsimha Swami's Mata's property is divided, separate entrance given, all that. Photos ಇದೆ. That photo which I had passed on, my lords, that shows the main nimsha. Nenne kottid photo. 1 second. Ade. On nimsha kodid. Lords, if your lordship sees these photos, your lordship should see the road.
What is the compromise which varies the decree?
Lords,
what is the variance?
My lords, that is Kwa Samputa Narsimha Swami temple, where, my lords, those properties were demarcated.
The reliance placed on is to show the existence
of Uttara. We also, my lords, it is named as
all the
Uttara
three
Mat.
parts.
There is no dispute on that. We have put a board, or they have put a board. It is named as Uttaradi Mata, that's all. Other than that, my lords, all the ownership rights is shown in our name. Dittam shows we are conducting the puja. And it has been communicated to them. Now to place reliance on AS, which does not even arise. So far, it is not even a suit between us and them. Just to show that whatever is recorded in that judgment gets modified by virtue of this. That judgment will not even, my lords, can't be, with great respect, can't even be referred to, because it's a modified judgment.
Yes.
That's all I wanted to show so far as that aspect of the matter is concerned. Now, my lords, if I have to come to the merits of the matter,
You have produced 2 copies of the same thing.
there are 2 suits, so 2 RSAs. My lords, in that memo,
Wording identical agide.
my lords,
Wording identical agide, so it's the same.
yes, my lords, there were 2 suits running page 15 ಅಲ್ಲಿ,
713.
and my lords, AS number 29.
So in
My lords,
both
the
of
first
them,
one is per,
the appellant.
both were the appellants. My lord, there were 3 suits. AS 28, 29, 30. 713 is for AS 28 and 30 of 1966. Then at running page 15, your lordship should get 714.
The full judgment copy kotra idu.
Here.
That's sort of copy.
Bari 2 page nam
May
kotti.
be permitted to.
That was the contention raised by the trustees of the
29.
In all the 3, you received a full copy.
Please.
We don't want to see 1 page. Inde munde nodbekagitte.
My lords, one of the contentions taken. We are not saying Uttaradi Mata is found everywhere. I'm not denying that. But what I'm saying is it's only named for purpose of convenience. Then, my lord, now coming to the merits of the matter. Now, please come to the writ petition, my lords, for a moment.
Yes.
The prayer, main prayer is only to stop the demolition activities without due process of law. Now, my lords, about 12 paras are mentioned in the writ, because what first ground which I want to raise is, my lords, on suppression of facts. Now, if your lordship sees, they only refer about the mud, the temple, AS suit, and my lords, para 4, they say that certain activities are taking place. And at para 5, they simply say, on several occasions, having regard to high-handed and illegal acts on their part, Mutt had approached the respondent authorities, and they are proceeding with the demolition activities. This is all they say in the writ. Now, please come to my statement of objections. Because this suppression fact, they don't say anything about even in their rejoinder.
Yes.
Now, please come to the first document or communication on behalf of the Mutt addressed to the temple at page 18 of my counter, which are lot 17, my lords, R4B. Sorry, R4B, my lords.
R4B.
Yes, annexure R4B, page 17.
18/2002.
18/2002.
This you have taken us through.
Yes. My lords, please see, there also they say, the said building must be belonging, they themselves say, please see the second para, how they say, my lords, in that. The said building must be belonging to Uttaradi Mutt, constructed long back for the benefit of pilgrims of Kukke Subramanya. At present, same building is under management of Kukke Subramanya temple office and being utilized properly for the use of pilgrims, etc. In this connection, I would be highly obliged if you could inform us as to when this building was transferred, taken over by the temple authorities, so that we can update our Mutt records accordingly. I am a retired audit officer of AG Karnataka. So they don't first of all say how they are claiming right, but they want us to tell them or give the records. Then, my lords, the next document is annexure R4C at page 18.
Yes.
Again, the Mutt addresses a letter to the commissioner on 6/2/2008. The last para in that letter at page 18, my lords, ಈ ಹಿಂದೆ ತಮಗೆ.
Yes.
ಈ ಹಿಂದೆ ತಮಗೆ ವಿವರಿಸಿರುವಂತೆ ಶ್ರೀ ಉತ್ತರಾದಿ ಮಠ ಸಂಬಂಧಿಸಿದಂತೆ ಕಟ್ಟಡವು ದಕ್ಷಿಣ ಕನ್ನಡ ಜಿಲ್ಲೆ ಸುಳ್ಯ ತಾಲೂಕು ಸುಬ್ರಹ್ಮಣ್ಯ ಗ್ರಾಮದಲ್ಲಿ ಶ್ರೀ ಕುಕ್ಕೆ ಸುಬ್ರಹ್ಮಣ್ಯ ದೇವಾಲಯದ ವಶದಲ್ಲಿರುವ ಸ್ವತ್ತಿನ ಸಂಖ್ಯೆ 498 ರಲ್ಲಿ 300.51 ಚದರ ಮೀಟರ್ ಹೊಂದಿರುವ ಕಟ್ಟಡವು ಶ್ರೀ ಸುಬ್ರಹ್ಮಣ್ಯ ದೇವಾಲಯದ ವಶದಲ್ಲಿದ್ದು ಅದು ವಾಸ್ತವವಾಗಿ ಉತ್ತರಾದಿ ಮಠಕ್ಕೆ ಸೇರಿದ ಆಸ್ತಿಯಾಗಿರುತ್ತದೆ. ಸದರಿ ಕಟ್ಟಡವು ದುರಸ್ತಿ ಮಾಡಿಸಿ ಜೀರ್ಣೋದ್ಧಾರ ಮಾಡಿ ಯಾತ್ರಿಗಳ ಅನುಕೂಲಕ್ಕಾಗಿ ಶ್ರೀ ಮಠದ ವತಿಯಿಂದ ಅಭಿವೃದ್ಧಿಪಡಿಸಲು ಉದ್ದೇಶಿಸಲಾಗಿದೆ. ಆದ್ದರಿಂದ ಸದರಿ ಕಟ್ಟಡವನ್ನು ಶ್ರೀ ಉತ್ತರಾದಿ ಮಠಕ್ಕೆ ನೀಡಲು ತಮ್ಮಲ್ಲಿ ಕೋರುತ್ತೇನೆ. ಆಸ್ತಿ ವಿವಾದ ನಕಲು ಇದರ ಜೊತೆ ಲಗತ್ತಿಸಿದೆ. Now, my lords, even in this, your lordship may also observe not a single sentence that they are carrying on any puja, anything. Then, my lords, based on their letters, the commissioner had addressed a letter, my lords, to the temple to give a report. The temple had addressed a report to the commissioner on 6/3/2008, annexure R4D at page 19. In that, please come to second paragraph. E hinde, your lordship gets page 19.
It's 12/12/2001.
That's R4D is 6/3/2008, page 19.
ಅದರಲ್ಲಿ ರೆಫರೆನ್ಸ್ ಇರೋ 12/12/2001 ಪ್ಯಾರಾ 2 ಅಲ್ಲಿ ಈ ಹಿಂದೆ ವಿಷಯದ
ಹೌದೌದು. ಈ ಹಿಂದೆ ವಿಷಯವಾಗಿ ದಿನಾಂಕ 21/12/2001 ಆಯುಕ್ತರಿಂದ ಪತ್ರ ಬಂದಿದ್ದು ಈ ಬಗ್ಗೆ ಶ್ರೀ ದೇವಾಲಯದ ಆಗಿನ ಕಾರ್ಯನಿರ್ವಹಣಾ ಅಧಿಕಾರಿಯವರ ಹೇಳಿಕೆಯನ್ನು ನೀಡಿರುತ್ತಾರೆ. ಈ ಎಲ್ಲ ದಾಖಲೆ ಪತ್ರಗಳು ಈ ಪತ್ರದೊಂದಿಗೆ ಲಗತ್ತಿಸಿ ಸಲ್ಲಿಸುತ್ತಾ ಸದರಿ ಕಟ್ಟಡವು ಶ್ರೀ ದೇವಾಲಯದ ಪಟ್ಟ ಸ್ಥಳ ಸರ್ವೆ ನಂಬರ್ 84/2 ಈ ಬಗ್ಗೆ ಕಂದಾಯ ಇಲಾಖೆ ದೇವಾಲಯದಿಂದ ತೀವ್ರ ಪಾವತಿಯಾಗಿರುತ್ತದೆ. ಅಲ್ಲದೆ ಶ್ರೀ ದೇವಾಲಯದ ಸೆಕ್ಷನ್ 25ರ ರಿಜಿಸ್ಟರ್ ದಾಖಲ ಪ್ರಕಾರ ಈ ಕಟ್ಟಡಕ್ಕೆ ಆಂಜನೇಯ ದೇವಸ್ಥಾನ ಎಂಬುದಾಗಿ ನಮೂದು ಇರುತ್ತದೆ. ಇಲ್ಲಿ ದೇವರಿಗೆ ಶ್ರೀ ದೇವಾಲಯದಿಂದ ನಿತ್ಯ ಪೂಜೆ ಸಲ್ಲುತ್ತಿದೆ. ಆದ್ದರಿಂದ ಈ ಪಟ್ಟ ಸ್ಥಳ ಹಾಗೂ ಕಟ್ಟಡವು ಕುಕ್ಕೆ ಸುಬ್ರಹ್ಮಣ್ಯ ದೇವಸ್ಥಾನದ ಆಸ್ತಿ ಹಾಗೂ ಕಟ್ಟಡವಾಗಿರುತ್ತದೆ. ಅರ್ಜಿದಾರರು ತಿಳಿಸಿರುವಂತೆ ಶ್ರೀ ಉತ್ತರಾದಿ ಮಠ ಸೇರಿದ ಆಸ್ತಿ ಎಂಬ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆ ಆಧಾರ ಇರುವುದಿಲ್ಲ ಎಂಬ ವಿಚಾರವನ್ನು ಈ ಮೂಲಕ ಸ್ಪಷ್ಟಪಡಿಸುತ್ತೇನೆ.
Yes.
Then, my lords, the commissioner addresses a letter on 27/5/2008 at page 20. To Mr. Kembavi, who had addressed the letter, my lords. That's at page 20. In that, please see, my lords, the reference number 2. He gives first reference is their letter. Reference number 2, our letter dated 6/3/2008.
Yes.
My lords, the first para would not be, second para. ಈ ಬಗ್ಗೆ ಕಾರ್ಯನಿರ್ವಹಣಾ ಅಧಿಕಾರಿ ಅಂತ ಶುರು ಆಗುತ್ತೆ at page 20. 6/3/2008, ನಮ್ಮ letter ಇವಾಗ just I read, my lords.
Yes.
And at page 20, second para there is.
Yes.
ಈ ಬಗ್ಗೆ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿಯವರಿಂದ ಪಡೆಯಲಾಗಿದ್ದು ಸದರಿ ಪಟ್ಟಸ್ಥಳ ಹಾಗೂ ಕಟ್ಟಡವು ಕುಕ್ಕೆ ಸುಬ್ರಹ್ಮಣ್ಯ ದೇವಸ್ಥಾನದ ಆಸ್ತಿಯಾಗಿದ್ದು ಅರ್ಜಿದಾರರು ತಿಳಿಸಿರುವಂತೆ ಸದರಿ ಸುತ್ತು ಶ್ರೀ ಉತ್ತರಾದಿ ಮಠ ಸೇರಿದ ಆಸ್ತಿ ಎಂಬ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲು ಆಧಾರಗಳು ಇರುವುದಿಲ್ಲವೆಂದು ಸದರಿ ದೇವಸ್ಥಾನದ ಕಾರ್ಯನಿರ್ವಹಣೆ ಅಧಿಕಾರಿಯವರು ದಿನಾಂಕ 6/3/2008 ಪತ್ರದಲ್ಲಿ ತಿಳಿಸಿರುವರು. ಅಲ್ಲದೆ ದಕ್ಷಿಣ ಕನ್ನಡ ಜಿಲ್ಲಾಧಿಕಾರಿಯವರು ಈ ಹಿಂದೆ so dated 19/4/2002 ಪತ್ರದ ಮೇರೆಗೆ ಕುಕ್ಕೆ ಸುಬ್ರಹ್ಮಣ್ಯ ದೇವಸ್ಥಾನದ ಹತ್ತಿರ ಉತ್ತರಾದಿ ಮಠ ಎಂಬ ಕಟ್ಟಡವಿರುವ ಬಗ್ಗೆ ಯಾವುದೇ ಅಧಿಕೃತ ದಾಖಲೆಗಳಿಲ್ಲ ವರದಿ ಮಾಡಿರುವುದರಿಂದ ಮನವಿಯ ಬಗ್ಗೆ ಕ್ರಮ ತೆಗೆದುಕೊಳ್ಳಲು ಅವಕಾಶ ಇರುವುದಿಲ್ಲ ಎಂಬ ಅಂಶವನ್ನು ಈಗಾಗಲೇ 15/7/2002 ಹಿಂಬರದಲ್ಲಿ ತಮ್ಮ ಗಮನಕ್ಕೆ ತರಲಾಗಿರುತ್ತದೆ ಪ್ರತಿಯನ್ನು. So it was informed to them that there is no documents. Then also they keep quiet. This is in 2008. First time they write in 2002, there is a reply. 2008 again. Then, my lords, there is another report. If your lordship kindly come to annexure R4F at page 22.
Yes.
This is a report submitted to the deputy commissioner, my lords, who had asked us to give a report. Second para I'll read, my lords. E kattadu.
All the chatras you have.
We have mentioned about that, but before that, my lords. E kattadu anta shura, second para.
Yes.
ಈ ಕಟ್ಟಡವು ಇರುವ ಸ್ಥಳದ ಸರ್ವೆ ನಂಬರ್ 84/2 ಪಹಣಿ ದಾಖಲೆಯಲ್ಲಿ ಶ್ರೀ ಸುಬ್ರಾಯ ದೇವರು ಸುಬ್ರಹ್ಮಣ್ಯ ಎಂದು ಇರುತ್ತದೆ. ಪಂಚವರ ವಿಶೇಷ ಉತ್ಸವ ದಿನಗಳ ಬಗ್ಗೆ ಇರುವ ದಾಖಲಾತಿಗಳಲ್ಲಿ ನಮೂದಿಸಿರುವಂತೆ ಮಾರ್ಗಶರೀರ ಮಾಸದ ಶುದ್ಧ ಚೌತಿ ದಿನ ಶ್ರೀ ದೇವರ ವಿಶೇಷ ಉತ್ಸವದ ದಿನ ಬೀದಿ ಆಂಜನೇಯ ದೇವರಿಗೆ ಕೂಡ ದೇವಾಲಯದ ವತಿಯಿಂದಲೇ ವಿಶೇಷ ಪೂಜೆಯನ್ನು ನೆರವೇರಿಸಲಾಗುತ್ತಿದ್ದು ಖರ್ಚು ವೆಚ್ಚಗಳು ಕೂಡ ದೇವಾಲಯದಿಂದ ಆಗುತ್ತದೆ. ಇನ್ಫ್ಯಾಕ್ಟ್ ಟುಡೇ
Only on that day?
no, it is not only on, that's why I said ಕೂಡ, please see, ಆಂಜನೇಯ ದೇವರಿಗೆ ಕೂಡ ಮಾರ್ಗ ಶರೀರ ಮಾಸದ ಶುದ್ಧ ಚೌತಿ ದಿನ ಶ್ರೀ ದೇವರ ವಿಶೇಷ ಉತ್ಸವ ದಿನ ಬೀದಿ ಆಂಜನೇಯ ದೇವರಿಗೆ ಕೂಡ means that on the special occasion also special puja is conducted. Then it proceeds further. Then my lords, please turn to the next page, page 23. That's Chauthi Dina is today, where the special puja is being conducted.
Today.
Today.
That is why you are arguing it today.
Lords, we argued 1 year ago. We are repeating it, my lords. I'm just saying. ಈ ಎಲ್ಲ ಆಧಾರಗಳು 23 minutes. ಈ ಎಲ್ಲ ಆಧಾರಗಳು ಉತ್ತರಾದಿ ಮಠ ಎಂದು ಕರೆಯುವ ಕಟ್ಟಡ ಮತ್ತು ಸ್ಥಳವು ಶ್ರೀ ಸುಬ್ರಾಯ ದೇವರು ಕುಕ್ಕೆ ಸುಬ್ರಹ್ಮಣ್ಯ ದೇವಸ್ಥಾನದ ಒಡೆತನದೆಂದು ರುಜುವಾತು ಪಡಿಸುತ್ತದೆ. ಈ ಸ್ಥಳದಲ್ಲಿ ಉತ್ತರಾದಿ ಮಠ ಸ್ವಾಮೀಜಿಯವರು ಶ್ರೀ ಕ್ಷೇತ್ರಕ್ಕೆ ಭೇಟಿ ನೀಡಿದ ಸಂದರ್ಭದಲ್ಲಿ ವಾಸ್ತವ್ಯ ಹೊಂದಿರುವುದರಿಂದ ಉತ್ತರಾದಿ ಮಠ ಎಂದು ಹೆಸರಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಇದರ ಅಭಿವೃದ್ಧಿ ಪೂಜೆ ಕಾರ್ಯ ಎಲ್ಲವನ್ನು ದೇವಾಲಯದ ವತಿಯಿಂದಲೇ ನಡೆದುಕೊಂಡು ಬರಲಾಗುತ್ತಿದೆ. ಈ ಜಾಗವು ಉತ್ತರಾದಿ ಮಠ ಸ್ವತ್ತಾಗಿರುವುದಿಲ್ಲ ಹಾಗೂ ಈ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲೆಗಳು ಇರುವುದಿಲ್ಲ ಹಾಗೂ ಈ ಸ್ಥಳವನ್ನು ಯಾವುದೇ ಕಾರಣದಿಂದಲೂ ಮಠಕ್ಕೆ ವರ್ಗಾಯಿಸಲು ಸಾಧ್ಯವಾಗುವುದಿಲ್ಲ. ಮಾನ್ಯ ಧಾರ್ಮಿಕ ದತ್ತಿ ಆಯುಕ್ತರು ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ದಿನಾಂಕ 28/6/2014 ಸುಬ್ರಹ್ಮಣ್ಯ ಮಾಸ್ಟರ್ ಪ್ಲಾನ್ ಅಭಿವೃದ್ಧಿ ಕಾರ್ಯವು ಬಗ್ಗೆ ನಡೆದ ಮಾಸ್ಟರ್ ಪ್ಲಾನ್ ಕಮಿಟಿಯ ಸಭೆಯಲ್ಲಿ ದೇವಾಲಯದ ಸ್ವತ್ತಾಗಿರುವ ಸದರಿ ಸ್ಥಳದ ಭಕ್ತಾದಿಗಳಿಗೆ ಪ್ರಸಾದ ವಿತರಣೆ ಮತ್ತು ಅನ್ನ ಸಂತರ್ಪಣೆ ಬಗ್ಗೆ ಭೋಜನಾಲಯ ನಿರ್ಮಾಣಕ್ಕೆ ಸೂಕ್ತವಾಗಿದೆ ಎಂದು ಅಭಿಪ್ರಾಯ ಹೊಂದಿ ಪರಿಶೀಲಿಸಲು ಕೂಡ ಪರಿಗಣಿಸಲಾಗಿದೆ. Then my lords, they have written about the details. Please come 1, 2, 3, 4 my lords about this very same place. ಆಸ್ತಿ ತೀವ್ರ ಪಾವತಿ ಅಂತಿದೆ. ದೇವಾಲಯದ ವತಿಯಿಂದ ನಿತ್ಯ ಪೂಜೆ ಮತ್ತು ವಿಶೇಷ ಪೂಜೆ ಶ್ರೀ ದೇವಾಲಯದ ವತಿಯಿಂದ. Your lordship gets it, my lords? There is a 1, 2, 3, 4 like that, my lords. It's not numbered. In page,
the bullet point.
Yes. ಕಟ್ಟಡದ ನಿರ್ವಹಣೆ ದೇವಾಲಯದ ವತಿಯಿಂದ. ವಿದ್ಯುತ್ ಬಿಲ್ ಪಾವತಿ ದೇವಾಲಯದ ವತಿಯಿಂದ. ಕಟ್ಟಡದ ಮಾಲೀಕರ ಹೆಸರು ಕುಕ್ಕೆ ಸುಬ್ರಹ್ಮಣ್ಯ ದೇವಸ್ಥಾನ ಸುಬ್ರಹ್ಮಣ್ಯ. Then my lords, based on this report, the Deputy Commissioner addressed a letter at next page, at page 24, R4G, on 8/11/2024 to the Commissioner. In that reference number 3, your lordship should get. Ulleka 1 again, my lords, Uttaradi Mata GPA holder Kembavi's letter is referred at reference number 1, if your lordship sees, my lords.
Yes.
The Commissioner, the DC writes, enclosing the report, saying, again repeating the same thing, saying that there is no chance, there is nothing to establish their right over the land. And then, my lords, on 14/9/2015, please come to R4H at page 26. The Commissioner, my lords, writes to the State Secretary. In that reference, your lordships would get reference number 2. The DC's report dated 8/11/2014 at page 26. Saying that it is again brought to the notice of the government, this belongs to the temple and this is what is happening. Then Annexure R4J at page 28, it's a reply given by the Deputy Commissioner dated 2/6/2016 to one Mr. Srinivas Murthy, if your lordship.
Who is he, advocate?
My lords, advocate who had issued the notice on behalf of the MUT.
That notice you have not produced.
ಅದು ನಮ್ಮ ಹತ್ರ ಇವಾಗ ಸದ್ಯಕ್ಕಿಲ್ಲ.
That is
But if your lordship sees ಉಲ್ಲೇಖ.
To the Deputy Commissioner.
ಎಸ್, ಅದು ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ರಿಪ್ಲೈ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದಾದ್ಮೇಲೆ ನಾವು ಕೊಟ್ಟಿದೀವಿ. ಬಟ್ ಇಫ್ ಯೋರ್ ಲಾರ್ಡ್ಶಿಪ್ ಸೀಸ್ ಉಲ್ಲೇಖ 1 ನಮ್ಮ
Notice was to
ದಿನಾಂಕ
the Tahsildar.
ತಹಸೀಲ್ದಾರ್ ಅವರು ಅವರಿಗೆ ಸಲ್ಲಿಸಿರುವ ಮನವಿ, ಪ್ರಾದೇಶಿಕ ಆಯುಕ್ತರು ಮೈಸೂರು ಅವರ ಸೋನ್ಸೋ ದಿನಾಂಕ ರಂತೆ ತಮ್ಮ ಉಲ್ಲೇಖ 1 ಮನವಿಯಲ್ಲಿ ತಿಳಿಸಿರುವ ವಿಷಯದ ಬಗ್ಗೆ ಈ ಹಿಂದೆಯೇ ದೇವಸ್ಥಾನದ ಕಾರ್ಯನಿರ್ವಹಣಾ ಅಧಿಕಾರಿಯವರಿಂದ ಮಾಹಿತಿ ಪಡೆಯಲಾಗಿರುತ್ತದೆ. ಕಾರ್ಯನಿರ್ವಹಣಾ ಅಧಿಕಾರಿಯವರು ಅವರ ದಿನಾಂಕ 2/7/2014 ವರದಿಯಲ್ಲಿ ದೇವಸ್ಥಾನದ ನಿರ್ವಹಿಸಲಾದ ಎಲ್ಲ ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ಉತ್ತರಾದಿ ಮಠ ಎಂದು ಕರೆಯಲ್ಪಡುವ ಬೀದಿ ಆಂಜನೇಯ ಗುಡಿ ಇರುವ ಕಟ್ಟಡವು ರಥಬೀದಿಯಲ್ಲಿ ಉತ್ತರ ಭಾಗದಲ್ಲಿದ್ದು, ದಿನವಹಿ ಕುಕ್ಕೆ ಶ್ರೀ ಸುಬ್ರಹ್ಮಣ್ಯ ದೇವಸ್ಥಾನ ವತಿಯಿಂದ ಪೂಜೆ ನಡೆದುಕೊಂಡು ಬರುತ್ತಿದೆ. ದಿನ
ತಿಳಿಸುತ್ತಾರೆ.
ಸೇವೆ ಸಾಹಿತ್ಯಗಳು ಮತ್ತು ಪೂಜೆಗೆ ಸಂಬಂಧಿಸಿರುವುದು ಶ್ರೀ ದೇವಾಲಯದಿಂದಲೇ ನೇಮಿಸಿರುವುದಾಗಿರುತ್ತದೆ. ಈಗಲೂ ಅದೇ ರೀತಿ ನಡೆದುಕೊಂಡು ಬರುತ್ತದೆ. ಸದರಿ ಕಟ್ಟಡ ಇರುವ ಸ್ಥಳಕ್ಕೆ ಸರ್ವೆ ನಂಬರ್ 84/2 ಆಗಿದ್ದು, ಪಹಣಿ ದಾಖಲಾತಿಯಲ್ಲಿ ಶ್ರೀ ಸುಬ್ರಾಯ ದೇವರು ಸುಬ್ರಹ್ಮಣ್ಯ ಎಂದು ಇರುತ್ತದೆ. ಪಂಚಪರವ ವಿಶೇಷ ಉತ್ಸವ ದಿನಗಳ ಬಗ್ಗೆ ಇರುವ ದಾಖಲಾತಿಗಳಲ್ಲಿ ನಮೂದಿಸಿರುವಂತೆ ಮಾರ್ಗಶರೀರ ಮಾಸದ ಶುದ್ಧ ಚೌತಿಯ ದಿನ ಶ್ರೀ ದೇವರ ವಿಶೇಷ ಉತ್ಸವ ದಿನ ಬೀದಿ ಆಂಜನೇಯ ದೇವರಿಗೂ ಕೂಡ ದೇವಾಲಯದ ವತಿಯಿಂದಲೇ
Same thing being repeated.
ಅವ್ರು ಅದನ್ನೇ, because that is the record. They keep asking, it's the same thing which goes to them. Then he says, my lord, your claim is nothing, and he also encloses the report
Yes.
of the last line in page 29.
This time in 27/2014.
That report of the,
Yes.
he encloses that also. Then, my lords, on behalf of the temple, my lords, and the reply notice is issued to the Mr. Srinivas Murthy.
So you had also received it.
We had also received, and your lordship should see your lawyer's notice issued on behalf of Uttaradi Mata, it says. And he very clearly says, we deny that they are in possession. And that page 31, second para, unnumbered para therein.
Yes.
So far as your client Uttaradi Mata is concerned, there is no mutt at above place. There is only a gudi, small temple called Anjaneya Devasthana. It is not any temple of your client mutt. It is housed in one-storied building, all in my client's possession, and it is my client who has been owning, possessing, arranging for its maintenance, puja, assessed in all revenue records as belonging to the temple, all necessary pujas performed at my client expenses all the while. By relying on some inadmissible name board found, your client at instigation of others seeks to not assert claim thereto. All such claims are denied. You have no right title. Everything is mentioned. So for that, the council gives a reply on behalf of the mutt on 1/11/2017, annexure R4L at page 32. And please see what he writes. The last para in page 32.
Hand over the premises.
Please note, if your client does not hand over premises now, unauthorizedly occupied by them to the rightful owner of Uttaradi Mata, I know what to do in this behalf, which will follow in due course. This is in 2017.
Why are the mutts fighting like this? Why don't you use your good officers, sit across and sort
But
this out?
the problem is, my lords, this institution is a religious, secular, more like a religion.
Every institution, without going into the claims. In the other matter also which had come before us, we had told
No, my lord,
them,
what
but
we
there
are
also they did not.
My lords,
succeed.
if this, that's what, my lords, forever, whenever any Swamiji comes, it's not that they are ignored. All protocol is given. They are honored, but they can't conduct pujas. It is accepted by every Swamiji, not only them. Because pujas, my lords, are conducted only by the archakas.
This also appears to be once a lawyer gets involved.
No, it is the
like-
same thing. Then, my
Like
lords, they have-
matrimonial matter like that, this also gets saved.
it's such a religious thing, my lords. If this going on for years, they should have said something.
Panindra, of course, you finish your argument, no problem. We'll reserve it. No, we'll have to give him an opportunity to reply to that. But use your good officer. Both of you are senior counsel.
Lords, I spoke, my lords, that's exact. I got
Across
lords, not
and-
only your lordship's advice. I was
If we
also
were to
called,
observe anything here, we will try to refrain, but some observation will happen,
lords,
which may not
just-
be good for either of you.
I am just showing, my lord.
And somebody will show after 50 years, this is what this court said in this matter, like what you are showing that arbitration, that suit.
My lords, what I am trying to say is this. We had a discussion. It's not the first time, my lords. We have tried many a times. What the temple authorities and the government says is, this temple which is in a dilapidated state, puja is being done only by the temple. It will continue. This will be dismantled. This has to be reinstalled elsewhere. But pujas will continue wherever it is reinstalled till Garbhagudi is constructed here. Once Garbhagudi is constructed, the idol will come back to its original place with all customary functions. When they come, all honors will be given, whatever they are entitled to. Sometimes they demand more than what is given to the god. That is another dispute in another.
This is again like 5 villages, not even one needle. That
But
is what
lords,
this is.
Today,
What they are also saying is, give us this temple. You have enough of your property there, you continue.
lords,
ನೀವುನು ಅದು ಮಾಡಲ್ಲ ಅಂತೀರಾ, ಅವರು ಅದು ಬಿಡಲ್ಲ ಅಂತಾರೆ.
ಅವರು ಬಿಡಲ್ಲ ಅಂದ್ರೆ ಅವರು ಇಷ್ಟು ವರ್ಷ
ಇಲ್ಲೇ ಮುಗಿಯಲ್ಲ ಇದು.
Rightly, wrongly, what I am trying to say is, have these facts been revealed in the writ petition?
We are not, see, that is why if we pass a judgment, we'll have to go there.
Lords, I understand, my lords, I have
Giving
tried, my lords, we have tried, I have, my lords, to be very honest, I have tried my level best. What they say is, this is possible. But to give puja rights, my lords, if they come, they can, when they come, all honors will be given, puja will be done by the Archaka. But if somebody says, I have a right to enter the Garbhagudi and do the puja, that's where the temple also, my lords, is in a difficult position. Because that's, the dictum does not allow. Today, if this is allowed, my lords, what happens is,
Yes, you continue with ಆಗಲ್ಲ ಅನ್ಸುತ್ತೆ.
ಇದು
We'll have to pass an order.
ಪೂಜಾ
We'll pass an order, ಅಷ್ಟೇ.
puja rights kodi andre, that's where. Then, my lords, the next,
Easier to pass an order than settle the matter.
my lords, that's why I said that, my lords, the next document is Annexure R41.
One
is-
ನಿಮಿಷ, just to, we'll finish one Dharwad.
ನಮಸ್ಕಾರ.
ನಮಸ್ಕಾರ.
I'm sorry.
Division bench matter, serial number 1. Connected by.
You are appearing, Mr. Bhatt.
For the state, my lord, beg to file a memo in further compliance of your lordship's orders. The DGP is online, my lords.
Yes.
My lord, the further compliance report has been submitted by the DGP.
Yes, Mr. Gondwade.
Please.
Yes, Dr. Mohanty.
Am I audible? Lordship?
Yes.
Lordship, there are two compliance reports that we have submitted in this particular petition, one dated 26/11 and 1/3/12. So I'll start off with the 26th November one. I hope Lordship is there, it's there before you.
We have 5/12 and now we have 26/11, yes.
So that's the main compliance. This one is the update.
Mhm. Have they given you the APIs?
Not yet, Lordship.
Email dated 2/12 is annexed, my lords. Today's memo.
Learned additional government advocate has placed on record a memo enclosing the letter dated 26/11/2024 addressed by Director General of Police Computer Wing to the Additional State Public Prosecutor
which
Please.
reads as under. Another memo has been filed enclosing the letter dated 3/12/2024, which reads as under. So your emails have gone unanswered. Yes, Lordship, we have not been able to get any reply. I've also, in fact, next week, I'm planning to go to Delhi, Lordship. In that case, I'll plan a meeting with him. In the meantime, we'll also try telephonically if we can be available. Which is the concerned organization who has to reply? NIC, Lordship. NIC. Is there any particular wing of NIC or? The DDG who looks after the E-Committee, Lordship, Mr. Sharma, Sashikant Sharma. He is the one who. The Dr. Pranab Mohatti, the Director General of Police, who is present through video conferencing, submits that though the police IT is ready to implement various APIs as part of the ICJS, NSTEP and CIS, repeated correspondence to the Deputy Director General NIC has not yielded any results. He submits that he would also be visiting Delhi in the coming week when he would try and meet the said Deputy Director General to resolve the issue. It is rather surprising that emails addressed by Director General of Police are not yielding any replies when the matter relates to the whole of the state of Karnataka, which the Karnataka Police IT intends to make part of the ICJS and or provide and or share necessary details with the courts in Karnataka. The Director General of NIC, Deputy Director General of NIC, are directed to afford utmost cooperation to the Director General of Police in order to enable the implementation of the APIs. So virtual court system is ready for operation. Yes, Lordship. So do I need to? You have integrated all your databases. Everything is integrated. The integration is happening for the petty cases, but the traffic offences are already, Lordship. The further compliance that we have given on 3/12, that mentions what we have done day before yesterday. In fact, we had a meeting conducted by joint meeting by Honorable Registrar Computers and Police for all the district superintendents of police who were briefed. This was on 3/12, Lordship, for the implementation of the virtual court system in the districts. In the meantime, the district in which the trial implementation is happening and where CIS 4.0 has been implemented in full is Kolar. So there, I'm told the things have proceeded satisfactorily and the UAT is happening as we speak. I think this will be over by this week. So we are already in virtual court system, Lordship, for the traffic offences. As regards the updated offence master, we have not heard back from the E-Committee, the technical section of E-Committee, who are supposed to be telling us as to what needs to be done further to update their master, because we are ready with that as well. The second thing that Honorable Registrar Computers had told us was to map all the police stations onto the IP of the traffic IPs, which are already available for virtual courts. So that has been done also. It's complete. So we are all ready for virtual courts rolling out across the state, specifically Southern Range. And this is only for the traffic offences. As soon as the offence master is ready, we can do it for the petty offences as well as phase 2. His further submission is that insofar as virtual court system in all the districts in the state of Karnataka is concerned, the same is ready for implementation. As regards traffic offences, as regards other offences, the nomenclature and the adding of the offences into the NIC master data format is awaited. As soon as the same is done, those offences could also be included
in the virtual court system. As regards e-summons application, he states that e-summons has been running on a pilot basis in the Kolar district successfully, and the same would be replicated. They'll be replicated in other districts by what time?
All other districts, Lordship.
By what time frame?
Lordship, the CIS part of it has to be implemented by the courts. So as soon as the CIS 4.0 is ready, e-summons is completely done. There is nothing further remaining because our app is ready. We've tested it end to end. There is no problem. So as long as the CIS 4.0 is implemented, the digitally signed summons or the processes will be accepted by the system. Apart from that, nothing else remains.
So 4.0 has to be migrated to.
Yes, Lordship.
Submit that the same could be replicated across all the other district on the migration of migration to CIS 4.0 being complete. Registrar Computers is directed to place a report as to when the migration to CIS 4.0 will be complete to enable the above. Relist on 23rd January to enable filing of a compliance as regards the integration of the ICJS and the sharing of data from police IT to the courts pursuant to the NIC's and the action taken by the NIC. You could bring the order to the notice of the NIC.
Yes, I'll also bring this. This will be conveyed to.
Yes.
Thank you, Lordship.
Please move.
Thank you. Namaskar, Basaraj.
Namaste.
File. Yes. Yes, Mr. Pandit. We are at page 32.
Notes, 32 is their reply, my lords. I just showed. Then, my lords, 33, annexure R4M is the 25 register maintained by the temple, my lords. It's of 1950s, my lords.
Yes.
This is of 1950s. In that we have, I'm sorry, my lords. Please come to 37. Typed copy hakidivi.
Yes.
1957 that. This is a temple register, my lords, maintained in that 39 alli. All the temple's properties are mentioned, my lords.
Item number 10.
Item Anjaneya Devasthanama Terebidiyalli ide.
Yes.
Then, my lords, 41, running page 41.
Item number 6.
Parivara Devarugala Samarthanege. Parivara Devarugulu. 6. Uttaradi Mata Mukhya Prana Devarige. Tenginkai Ditto 5. Avagindadu. That's in the sense 5 coconuts every day has to be offered.
ಇವಾಗಲೂ ಅಷ್ಟೇ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
ಅದು I think, my lords,
must
be more. But I'm just showing that this is known as the Parivara Devaru.
Account which was kept for all these.
Then the other one is, my lords, about the master plan details which was taken into consideration is at page 43, where the government also wanted to implement for road widening and for other. The master plan depicts what is the plan for this.
This is not for road widening. This is for dining halls.
The master plan is there. It shows it's for this. The entire town is under a master plan, my lords.
Yes.
Funded by the temple.
Yes.
What is that I wanted to show? Then, my lords, page 45.
45.
That chart contains the master plan properties, my lords.
Yes.
45 ali 1, 2, 3, 4. 84/2, fourth one, my lords, from top. K. Govindas anta barutte.
Yes.
K. Govindas Memorial Chatra Hanumanta Gudi ಇರುವ ಉತ್ತರಾದಿ ಮಠ. ಕಟ್ಟಡ ನಿರ್ಮಾಣವಾದ ದಿನಾಂಕ 9/5/42. ಸ್ವಾಧೀನದ ಖಾಸಗಿ ದೇವಾಲಯ ದೇವಾಲ. Shara is donor Chatra. That's the different properties, my lords, which falls under the master plan is what we wanted to show. Then, of course, the next document was, my lords, by the DC to say that there has been a delay in implementation of the thing. R4Q is a paper public notice which was issued on 14, my lords, on 19/5/2020, calling for, my lords, contractors for the work of dismantling of the structures. Of course, after that, my lords, our case is, it was given, work order is at R4R 26/6/2020. Pursuant to the,
Everywhere you are still mentioning as Uttaradi Mata.
ಅದು ಅಲ್ಲಿ identification, my lords, people who are there will identify each one, my lords. What I'm saying is merely because it's named as that, there should be some semblance. Today, the Mata is coming and saying it's my property, you show your documents. It is not this forum. First of all, you show. Tomorrow somebody comes and says, Panindra, you show your house documents. Why am I to show? I am showing it. But when you are asking me something, you please show what is your document, not a single scrap of paper. And our dictum, every document shows we are conducting the puja. Today, my lords, in a writ which concerns dispossession, alleged dispossession, they want to say, give me rights to puja.
So go to civil court.
You have to. In fact, my lords, I did not want to go to that extent. I will just produce one judgment. It's not there. This is, my lords, a judgment dated 9th of March 99 by this honorable court. Lords, in respect of, I'll just pass it on, my lords, because puja rights bandaga, I just remembered and I took it out. I'll just pass it on. Samputa Narsimha Swami Mat, my lords. What happened is they can't enter the temple and do the pujas to the main deity or other deities. That's what happened when a meeting was called by the then minister and the trustees, my lords, and in the meeting, my lords, what happened? It was decided that the Mat Swamiji will be given certain rights, that he has to be first honored, then the puja will take place, and he will enter, do certain pujas first.
Yes.
That was questioned before that settlement was signed also. That was questioned before this court. Para 8 is the issues that were framed by this court. And this court ultimately held, when it comes to customs, there can't be any settlement at all. If somebody claims customary rights to do any puja, you have to establish in a civil court as to how you get that right. Though the settlement was there, this honorable court, my lords, set aside that settlement. Para 8 issue bandide, my lords, I'm sorry, I will just pass it on, my lords, because I'm only trying to say that somebody can't come in the guise of a writ petition and say, give me the rights.
Yes.
I'll just only, though there is no such prayer in the writ. So, my lord, my first fold is suppression. Now, there is exchange of communications, not a single whisper in the writ petition. And they claim that it's a, there are few authorities which I want to place reliance on suppression, which your lordships are well aware, my lords. For the purpose of record, I'm just passing on. With the proposition and the para numbers I have given.
Yes.
In fact, the courts have held, you can't even enter into merits of the matter if there is suppression. In this case, there is, even in the rejoinder, your lordship says they don't deny any of the exchanges. They still, but they still go on other aspects. But if it is suppression, my lords, your lordships need not enter into the sphere of merits. So far as merits is concerned, their only prayer is dispossession. Now, if they have themselves admitted they are not in possession of the land in question or the temple in question, the question of dispossessing them does not arise. And the repeated plea is hand over possession to us, hand over possession to us. Now, my lords, under the master plan, we have set out in our statement of objections. Clarification. Now, my lords, so far as pujas, I have shown your lordships all the records. Now, my lords, in our counter, we have set out what we propose to do there. And I'm going one step ahead. This temple, only the Garbhagudi will be saved. Now, my lord, the photos itself, the old photo itself shows that, I'm sorry, I have taken it back. Vapas kortini. This was way back in 2020. This is the actual structure, my lords. E photo lero. Almost everything is demolished. The Garbhagudi is there. It is our statement that Garbhagudi also will be dismantled. That's the master plan. And my lords, the idol will be installed at, though it is not their concern, but I'm just saying, it will be installed elsewhere. It will be, pujas will be conducted. Then it will be only the Garbhagudi will come here, nothing else. Then it will be, my lord, the entire place under the master plan is dining hall and prasad center.
And the temple will be in between of it.
My lords, it will not, there will be ideas when they do it, my lord, there will be a plan, not that something is put in between something.
Yes.
So that is the issue today. And so these lands were acquired. There is an acquisition notification which they don't reveal. Samputa Narasimha Swami temple, Kamat had challenged the acquisition. Their writ petition
When was it acquired? That is
Lords,
not
the acquisition
first time
was.
you are making this.
Lords,
This is the first time the submission is being.
no, it has, my lord, because this is a government land, this acquisition took place. I'll just submit, my lords.
Is the subject matter of this petition already acquired?
All this is a part of the master plan. All this, yes.
Master plan is different from acquisition.
Lords, acquisition andre is government land andaga. Lords, the acquisition was in 2004, one notification for the entire thing was in 2013. Then, my lords, 2006 one was in, my lords, 2014. That's
So
pursuant to the
acquired
master
by
plan.
whom for what?
Lords, for the purpose of, there are several activities which have to be done by the government itself, 4161. ಇದು ಬೇರೆ ಕೇಸ್ ಇಂದು I don't have that, my lords.
ಇಲ್ಲಿ acquire ಆಗಿದ್ರೆ that is a very relevant.
No, it is, my lords. It's a part of the acquisition notification, 82. This is 82.
Still, Pranindra, if this is acquired by the state, then you also cannot claim any right.
No. Acquired, my lords, I'll have to check whether this entire, if you see the master plan, if I can produce your master plan, my lords, it shows the entire
Master
land.
plan is different. Is this land acquired?
My lords, I'll come to that survey number, my lords, because this is 82.
4/1.
My lords, I'll just tell your lordships about that, 82/1. But all the other lands have been acquired, which was belonging to the other mutts have been acquired.
Acquired by
The government.
and vested with?
Lords, government for the purpose for which the
And
government
vested with
is
the Muzerai
implementing the
department.
project.
Vested with the Muzerai department.
Yes.
Transferred to the Muzerai department.
The government only will do it, my lords. Its temple is a Mujra institution.
Trace the acquisition notifications.
Lords, that will,
Become
I'm just saying.
relevant.
That apart, my lords, if we are dismantling it, we are installing the temple there. None of the rights are violated, my lords. And this writ, they can't expand this writ to claim puja rights with great respect. There is no pleading. There is not even a document on record.
Lord Shiki and Panindra and senior counsel for respond number.
That acquisition, my lords, I'll just clarify whether this was a part of the acquisition.
He however seeks for, when will you clarify?
Tomorrow morning, I can,
My lords,
or if your lordship passes over, I can just call up and find out and let you.
We need the notification.
No, our survey number gottira.
When will you reply?
my lord, 13th.
Reply, my lords,
Two documents they have produced, my lords. My lords,
on a
what
vacating
is-
stay, my lord, 13th.
My lords,
We are
13th is
disposing of the
because-
petition finally.
My lords, on that day, it may be disposed of, my lords. My humble submission at this juncture is all the records what they have,
Want to reply now?
not now, my lords, on 13th.
Reply.
Please.
However seeks for 2 days time to make a submission as regards whether the land is acquired or not. Learned counsel for the petitioner seeks for a short accommodation to
If it is
submit his
acquired.
reply arguments. Pre-list on 13th at 2:30 PM.
Grateful, great.
Your lordships are posting on
13th.
It is acquired.
if
On acquisition and
Temple is not a local body. In fact, there is a CEO who is a administrative
It is
officer.
acquired, neither you have a right nor they have a right.
Full-
Then it goes to you.
The state, it's a state for which I have been funding. Lord, sir, to say we are now going into some other sphere, for which pleadings are not there, with great respect.
ಇಲ್ಲ, ನೀವ್ ಹೇಳಿದಪ್ಪ acquisition ಅಂತ.
I said, my lords, it is under a project. Now, my lords, that only that. Now, even if that is there, that is not even their case. Your lordships first have to pose a question on suppression without even getting into
That
this.
will pose when he argues, not, can we ask you on that?
Lords, that's why I am still saying, my lords, suppression, somebody.
We'll ask you, Mr. Panindra, why did they suppress ಅಂತ ಕೇಳೋಣ.
No, Allah, our first answer, my lords, the pleadings were there. My learned friend argued on 2 days. On suppression, not even a single answer. Very well, my lords, 13th, your lordship may have it.
Yes.
For further hearing, my lords,
For the hearing,
please.
Grateful.
230 moved by
move back.
Chowda Reddy.
Petition, my lord. Regarding the election to the MPCS, my lord. Puduvati Milk Producers Cooperative Society, Puduvati Chikbalapur Taluk, my lord.
Ineligible voters, huh?
Please, my lord.
Why are you ineligible?
Annexure D, my lord, E, my.
Yes, Annexure D has been issued to out of 100, my lord. The society is having 253 shareholders, madam. Out of which only 23 voters has been made as the eligible voters, my lord. In fact, my lord, the CEO of that society has been temporarily.
Reason for ineligibility.
My lord, they have no reason has been, simply they have been stated that 5 ವರ್ಷಗಳ ಇದರಲ್ಲಿ ನೀವು ಎರಡು ಸಭೆಗಳನ್ನು ಭಾಗವಹಿಸಿರುವುದಿಲ್ಲ ಒಂದು, ಆಮೇಲೆ 180 ದಿನಗಳ ಹಾಲ್ ಹಾಕಿಲ್ಲ ಅಂತ. 180 ದಿನ ಹಾಲ್ ಹಾಕಿರೋದು ಇದೆ ಮೆಂಟೈಡ್. ಬಟ್ he himself has prepared the GBM resolution by the CEO, who has been temporarily appointed. There are several cases has been filed against the CEO. So the notice as annexure issued, my lord, though they dated on 15/10/2024, my lord, they had been served in the month of last week of November 2024, my lord. And after Galata has been happened in that village, my lord, 2 political rival parties has been sit together and they tried to unanimously elected all the directors, my. 3 days sitting has been done, my lord. Subsequently, only 4 directors has been elected. Rest of the directors has not been elected, my lord. Because of the CEO, only all the things has been happened. Earlier, the CEO, all the records has been snatched away by the earlier CEO. Since he has been appointed as a temporary since from 1.5 years, and he was the former director of that MPCS, my lord. So we have been procured the milk from 180 days and have been attended the 4th general body meeting, my lord.
What have you produced to show that?
Well, every record, see, even the ineligible voters list has not been placed before the notice board, my lord. They are not giving any documents at all.
ಅಲ್ಲ, ನೀವ್ ಹೇಳಿ.
My lord, in respect of my lord, annexure D, my lord, E is very clearly say that, my lord, reasoning that is, my lord.
Annexure?
D and
D
E.
and D, my lord.
ನಿಮ್ ಕೇಳಿದ್ರೆ ನೀವ್ ಹೇಳಿಲ್ಲ ಅವ್ರಿಗೆ.
ಅಲ್ಲ, ನಾನೇ ಹೇಳಿದ್ದೆ ಎಲ್ಲ ಇದರಲ್ಲಿ out of 153 people, only 12 to 13 members has been issued. Remaining ಅವರೇ ಸೈನ್ ಮಾಡ್ಕೊಂಡಿರೋದು.
Yes, sir.
So there was a dispute regarding that also. We have been a large complaint before ERCS, my lord.
Yes.
D and E, my lord, very clearly say that, my lord, they are not attending the meeting, my lord. ಒಂದು ನಿಮಿಷ ಕೊಡ್ರಿ.
ತಗೊಳ್ಳಿ ಸರ್. ಹೇಳಿದ್ದಾರೆ ಏನೇನು ಬೇಕಾ ಕರೆಕ್ಟ್ ಆಗಿ ಕಾನೂನು ಪ್ರಕಾರವಾಗಿ ಏನು ಹೇಳಿದ್ದಾರೆ. But when it was served.
Not attending the ನೀವು ಕೇಳಿದಾಗ ನೀವ್ ಹೇಳಲ್ಲ. ಬೇರೆ ಎಲ್ಲ ನಿಮ್ CEO ಮೇಲೆ ಅಲಿಗೇಷನ್
ಇಲ್ಲ, ನಾನು ಹೇಳಿ.
ಏನೇನಿದೆಯೋ ಎಲ್ಲ ಹೇಳಿದ ಆಯ್ತಲ್ಲ. We did not interrupt.
Please, my lord.
Reason for ineligibility ಇನ್ನ ಹೇಳಿಲ್ಲ ನೀವು.
Regarding, my lord, okay, kindly see, my lord.
Attendance ಆಮೇಲೆ
Annexure D, my lord.
D and D, my lord.
D, ಅದರಂತೆ, my lord. First point, my lord.
2A3.
ಸಂಘ, please. ಅದರಂತೆ.
A3.
Please, my lord. ಅದರಂತೆ.
ನಾನ್ ಅಟೆಂಡೆನ್ಸ್ ಅಷ್ಟೇ.
ಅದರಂತೆ 5 ವರ್ಷ ವಾರ್ಷಿಕ ಸಭೆಗಳ ಅಂದರೆ 2019, 20, 20, 21, 21, 22, 23, 24 ವಾರ್ಷಿಕ ಸಭೆಗಳನ್ನು ಪ್ರಣಿಸಿದ್ದು ಅದರ ಕನಿಷ್ಠ 2 ಸಭೆಗಳಲ್ಲಿ ಹಾಜರಾಗಲು ನೀವು ವಿಫಲರಾಗುತ್ತೀರಿ.